Appellate side mentioning.
May I pray for your lordship's kind leave, my lord? May I pray for your lordship's kind leave, my lord, to move on application, my lord. That too, it's a matter relating to tender, wherein I am a MSME enterprise, my lord. Certain statutory exemptions which I am entitled
Why
to.
today?
Lordship,
Why
tomorrow is the last date of submission, my lord.
tomorrow? It will be in the list tomorrow.
My lord, may I mention on a matter, my lord?
And notice to the other side, no ex parte orders.
Lordship,
Yes.
the lordship will
Yes.
not grant leave. I will not be able to serve to the state, my lord.
If you're not be able to serve, I will not take it up, and no ex parte orders.
My lord, I mentioned
matter,
matter, my lord, this matter, the petitioner has liquidated the entire dues of the bank. The petitioner has liquidated the entire dues of the bank. Bank is not releasing the document, original document. Well, last communication was made on 22nd of February 2022. 2023, my lord, sorry, 2023. And mother, the petition was filed on 24th of March 2023.
Yes, on 2nd May.
May I be permitted to mention a matter, my lord? My lord,
Helpful,
this
my lord.
matter, my lord, is appearing as item number 41 in your lordship's list, my lord. My lord, on 7th of February, my lord, your lordship was pleased to, my lord, grant me, my lord, a seat, my lord, reserve my seat. My lord,
Reserve my seat. I don't remember the facts.
my lord, the 7th of February, my lord, your lordship was, my lord, pleased to reserve my seat in a manner admission process, my lord. Your lordship was, my lord, this matter, my lord, the affidavits are exchanged. Now, my lord, if your lordship kindly takes this matter up any day, my lord, subject to your lordship's convenience, my lord.
What is the date of my order?
My lord, 7th of February, my lord. The interim order, your lordship was pleased
Of
to,
this
my lord,
year?
of this year, my lord.
Yes, not before the 2nd week of May.
Madam,
Yes.
may I be allowed to mention, my lord?
Yes,
Let me allow to mention.
I'm not looking at you. Yes.
Madam, may I believe Lord mention this matter for objection, lordship, my lord. The work of property, my lord, and the unlawful persons are representing, and due to that reason, my lord, the work property is going to,
What are the dates?
my lord, there is no such date, my lord.
Yes,
Matter
come
is
back.
appearing.
Come back with dates. Yes.
Yes, my lord. Let me allow to mention that the matter is filed on 22/3/2023. Already I have served the notice regarding the residual matter, the insurance claim card accident, my
I
lord.
can't understand. Microphone, please.
Matter is filed on 22/3/2023. This is a card accident, the insurance claim. But I have served the notice to the insurance company and also the private respondent, because the card was at that moment the private respondent. Before that,
What is the last cause of action? You're
last,
not arguing the matter now, are you?
No. last cause of action, the matter should be listed in the motions as early as possible, my lord.
Not if I'm not satisfied with the urgency. What is the urgency?
Because the claim
2nd week of May. Yes.
My lord, the petition is filed in the year of 2022.
Microphone.
The petition is a old aged person, 70 years old, and his property has been captured by the Eastern Coalfield Limited since long. But now they are in the month of March, on 28th
Yes,
March,
come back
they are
with
trying
dates. Yes, Mr.
Well,
Mujumdar, come back with
it's
dates.
it's
No,
28th
don't
May,
waste the
lord.
court's time. Yes.
On
If I cannot go on repeating this every time, twice a week. So
28th
come back
March,
with
March.
dates. Yes.
On
28th
13th,
March, my
on 13th April, your lordship was pleased to not fix this matter on 28th of April. But we didn't know at that time that on 1st of May, a fresh tender has been called in respect of the self-same matter, in respect whereof there has been an interim order. I'm not, if your lordship will
What
kindly.
is the interim order you're enjoying?
We were blacklisted without a hearing, number one. Number two, not the
What is
tender.
the are you enjoying an interim order? What is the interim order?
Not a stay on operation of the impugned order, not by which we had been blacklisted and retendering had been called.
So what is the urgency now?
Not it's going to expire on 30th of April. On 1st of May, not they had your lordship has been pleased to not allow the mentioning and put it on 28th of April. Not at that time we failed to bring to your lordship's notice that on 1st of May, a retendering process has already
Yes,
been initiated.
2028. Notice to the other side. Yes.
Lordship, may I be permitted to mention one new
I can't hear you.
Lordship, may I be permitted to mention one new motion, Lordship? That is, Lordship, encroachment of the higher land by the private resident. And Lordship, I have been made several representations, but nothing had been done till today, Lordship.
Come back with dates. Yes.
Lordship, the last cause of action on 6th of December 2022, Lordship.
Please
Kindly,
mention in the first week of May. Yes.
Your Lordship, may I be allowed to mention a matter for upgradation? It is appearing in item number 163 of your Lordship's list. The urgency is that on 27th November 2022, the executive members of an association of a residential complex has suddenly stepped down from their executive member post, which has caused at present urgency is that
So
essential.
that's November 2022.
Yes, and the
When
matter
did you file the writ petition?
matter was filed on 20 December 2022. It was supposed to appear on 30th of January. I mentioned before your Lordship on second week of February, and your lordship listed it in the last week of March 2023. It is appearing.
Very well. 3rd May. Yes.
Much obliged, your lordship.
Can't hear you.
My lord, it's a matter of 2021. In spite of completion of job through tender call, I'm not being paid my paying. Number of my staffs are passing in starvation, my lord. They are not, the concerned authority are not paying any for.
When did you file the writ petition?
My lord.
When did you file the writ petition?
File 2021.
And not taken up since 2021?
No, my lord. Distribution.
First time you're mentioning in this court? Yes, 2nd week of May. Yes.
Lord, may I have your lordship's kind leave to mention, Lord, I'm mentioning this matter upon extremely compelling circumstances, my lord. This is regarding the off shop, my lord, which was closed because one of the legal heirs of the deceased joint licensee was not cooperating with the petitioners, my lord, to apply for a permanent settlement of a fresh license, my lord. Your lordship had heard this matter on 14th of March 2023, my lord, when your lordship had directed the shop to remain open until 30th of April, my lord, 2023, my lord. Now, my lord, this matter is running in the list, but because of your lordship's paucity of time, lord, it has not been taken.
24th, notice to the other side.
May I have your lordship's kind leave to mention a matter? The petitioner is the secretary of a district sports association. On 9th March, the district magistrate passed an order dissolving the governing body and appointing an ad hoc committee comprising of 8 MLAs of the ruling party. Thereafter, I filed a writ petition on 24th March 2023. 3rd April, I mentioned before your lordship for listing of the matter, and the matter is coming as item number 137. Your lordship, your lordship, now what has happened on 14th April? They have issued an order suspending the petitioner from the society.
Were you protected by an interim order?
Your lordship, the matter has not been taken for once also. We've written to them that the matter will appear on 17th April. Not taking advantage of the fact that the matter has not been taken up, they are passing orders which is causing prejudice to the petitioner. Your lordship may kindly keep it day after tomorrow.
Why to be day after tomorrow?
Grateful,
Yes,
my lord.
notice to the other side. Yes.
My lord, it is a mentioning for the inclusion in the list. It is highway matter of 2019.
Mention the 1st week of May, please.
Lordship,
Yes.
with regard to item number 139 of my lord's list today, your lordship, the urgency is, your lordship, the bank, I have taken a loan from the bank. I have given a letter for foreclosure, paying the entire amount. The bank is not considering that letter, your lordship. They might sell the property, your lordship.
Last cause of action?
Last cause of action, 16th of March, your lordship.
Come back with dates. Yes.
16th of March, 2020.
No, come back with dates. Yes.
May I mention on
Can't hear you.
May I permitted to mention on matter, my lord, that is item number 650 in the 3rd April's list, my lord. The urgency is that, my lord, the respondent authorities
I can't
does not
hear you.
allow me
Yes,
to
I
complete
can't hear you.
the registration procedure, my lord.
With a
Yes.
kind leave, this is a motion matter in respect
Microphone,
of
please.
in respect of family pension matter. I have mentioned before lordship for 3 times, and lordship was pleased to allow on February, my lord. But this is item number 277 of the monthly list dated 3rd April. But the urgency is that, my lord, the petitioner, the deceased husband, my lord, previous wife, my lord, being divorced, my lord, also my lord, had made a claim before the port trust that, my lord, she is entitled to. My lord, this is very urgent, my lord.
Yes, 28th.
Grateful,
yes.
my lord. Grateful, my lord.
May I have to,
My lord, this is item number.
Hurry up. If I can't hear you, then the next.
may I have
please.
permitted
Yes,
to mention
yes.
one matter, lordship, a matter is for non-prosecution, lordship.
Which year?
2022.
Yes, sometime next week. Yes.
My lord, this is a 2022 matter. My lord, this is running as item number 434 of my lord's today's list. My lord, the petitioner has been deprived of his only means of livelihood. My lord, kindly hear
Come
this
back with dates. Yes.
My lord, the last cause of action is 27th March.
Come back
my
with
lord.
dates.
My lord,
Yes.
may I be permitted to mention?
If I have to repeat that question, please, the hand up the mic to your next person.
My lord,
Yes.
may I be permitted to mention an assigned matter for inclusion in the list, my lord?
Which one?
My lord, this is with regard to Vishwavati matter, which was last heard by my lord on 14 December, directed to appear on 11 January. It appeared, but subsequently now it is not appearing in the list. So I'm praying for inclusion in the
No,
list.
has it, is it already assigned before this court?
Yes, ma'am. It was heard once after assignment. It was heard once by
It
my.
will not be taken up in the, before the 2nd week of May. All right? Yes.
May I hand over the slip?
My lord, may I be permitted to mention, my lord, item number 210 of the monthly list?
Yes, you.
My lord, by order dated 14th November 2022, my lord, the petitioners were declared willful defaulter, my lord, in terms of the master circular, my lord. Now, my lord, after we filed a writ petition challenging that order, my lord, after filing of the writ petition, my lord, on 13th of March to this year, my lord, 2023, my lord, the account has been settled, my lord. The dues has been cleared, my lord. So, my lord, we have filed an application file, my lord, for appropriate orders, my lord, for setting aside the order and disposal.
Application or writ petition?
The application in connection with the writ petition, my lord, because my lord, post filing of the writ
Yes,
petition, my lord,
next Monday, application গুলো কবে হয়? সোমবার? Next Monday, দিয়ে দাও।
My lord, may I permit you
New
to mention?
new motion for inclusion on the list, my lord.
What is the urgency?
My lord, private respondent forcibly trying to grabbing the petitioner fact for the purpose of the burial land.
Come back with dates, please. Yes.
My lord, may I be permitted to mention item number 210 of the monthly list? My lord, the forfeiture of the earnest money deposit was made on 23rd February 2023. The writ petition was taken out, my lord, in September 22nd, my lord, 2022. My lord, the urgency is, my lord, today they are, my lord, putting up the land for sale again, my lord. My lord, having forfeited the entire amount without, my lord, making
What do you mean by today they are putting up the land for sale?
my lord, not today, my lord, they are, my lord, proceeding to
Come
sell
back with
the
dates.
land.
Yes.
Lordship,
Yes.
I am aggrieved by non-disposal of my section 14 application, your lordship, which is pending since 11th March 2022. I gave a representation on 13 January 2023 to the district magistrate, but district magistrate did not pay any heed. Then in the last week of January, I filed this
Yes,
representation.
4th May.
There are 3 similar matters, your lordship.
May be permitted inclusion in the list, my lord. I am mentioning this matter. My lord, petitioner is old lady applied a passport in the year 2020, and she has called for verification in the passport office in 17th February 2020. But she didn't receive the passport till date, my lord.
When did you file the writ petition?
Yes, I have filed the writ petition on 6th March 2023.
So you waited for 3 years?
Yeah. 23, my lord.
Yes, mentioned in the second week of May.
Yes,
Yes.
my lord, it's very urgent, my lord.
You have waited for 3 years and then filed the writ petition. You're saying it's urgent?
No, because of the COVID situation, my lord,
Yes,
she
not
unable
before
to.
the second week of May.
Lordship, may I
Yes.
be permitted to mention one matter for upgradation 206 of this monthly list, Lordship? That urgency is that the citizenship card will expire in July, Lordship. And I had filed
What will expire?
citizenship card. This is a return of seized passport, Lordship. I have filed this writ petition in March 2022 and filed the demand notice, sent the demand notice in October 2021, Lordship.
So why did you not take steps to have the writ petition?
I had mentioned this matter in favor. It was running in the list. Therefore, after it was not running, thereafter I had mentioned this matter for listing, Lordship. In February,
second week of May. Yes.
Much obliged, Lordship.
The petitioner has paid all the OTS. The petitioner has paid all the OTS amount. On 10th of February, they have said to pay much more amount after the OTS. Then I have filed the writ petition on 17th of February. This is my second time of mentioning of this matter because they are not returning the original deeds.
Second week of May. Yes.
May I give the?
I can't understand. Yes.
May I be permitted to mention, my lord, in the monthly list, item number running is 240 and 241, my lord. My lord, the matter pertains to section 14 of the surfacing application, my lord. My lord, I have filed the section 14 application, but the order passed in 26 July 2017. My lord, after that, there has been no action from the district magistrate. My lord, the urgency is, my lord, currently
2017. You've been waiting for the last 5 years, 6 years.
My lord.
When did you file the writ petition?
My lord, I have filed the writ petition on 20th December 2022.
Yes, mention in May.
Would
Yes.
I mention, my lord, this matter your lordship directed to appear in the list on 11th January. But still now this is not appearing. My lord. Kindly,
What's the
this is
urgency?
an assigned matter. My lord.
Maybe. What is the urgency?
What is?
Yes. Yes. Yes.
Have your lordships, lordships kindly to mention item number 70 today. This was fixed on the 5th, considering the urgency, lordship was fixed on the 19th. The urgency is this pertains to deposit of a certain amount of money for execution of sand mining leases. During the pendency, my lord, we could not get the matter heard. It was fixed on the 5th. Now on 11th, they've made us sign the agreement on 8th.
Please, 11th April, I assume.
Sorry,
Please.
11th of
Yes.
April 2023. They
Yes.
make us sign the agreement. If I make the payment under the agreement, my writ petition will become infructuous. Your lordship has fixed it on the 19th of April of this year. Not, I only request if your lordship could give it some precedence on that day.
Because yes, 19th opor tule dao to.
I'm very
Yes, yes.
May it please, Lordship, this is a listed motion which is not in your Lordship's list. Lordship, the issue is after conversion of the land, Lordship, I had gone to fill the land after payment, completion of all formalities. That was in November. Thereafter, Lordship, I was obstructed by personnel of the BLLRO office.
No, who are you?
Lordship, I am the owner of the land.
Yes.
I had sought for conversion. Conversion was allowed. All formalities relating to conversion was completed. But then when I went to fill the land, then these people obstructed me, Lordship.
When was that?
I
Give
had-
me some
That
dates,
was,
please.
Lordship, that was in November, end of November. I filed this writ petition in January, Lordship. Yes, end of January, Lordship. And therefore, thereafter, Lordship, again, I had attempted to, because it's my land, everything is complete. I went to fill up again.
Yes.
Again, I was obstructed.
Yes, second week of May.
Yes.
May I be permitted to
Can't
mention
hear
that?
you.
May I be permitted? My lord, item number 310 of your lordship monthly list, my lord. I am for the private respondent number 8, my lord. Private respondent number 8 filed a application for recalling of your order dated 1st July 2022, my lord. Because of the pendency of this matter, the tower company is not in a position to install the tower in the land of the private respondent number 8.
Yes, second week of May. Yes.
Deeply obliged, ma'am.
May I kindly to mention, my lord, due to the illegal action taken by the builder, my lord, I had to revoke the power of attorney, my lord. Since the power of attorney was a registered one, my lord, I had to approach the register of assurance for registering the revocation document, my lord. They are not registering the document, no reasons assigned.
Some dates, please. Don't make submissions.
Date, my lord, 22nd February, my lord.
Come back with dates.
Lordship,
Yes.
mention this matter,
No,
my
no, I have the dates, my
No,
lord.
no. Come back with dates. I can't ask you questions like this. Yes, yes. Microphone, please. I can't hear you. Next person. Yes. I can't hear you. Yes.
May I will kindly to mention a new motion for inclusion of 2022. The writ petition was filed on 18 November 2022. It is regard to a tender matter. Your Lordship, the petitioner participated in the tender. The work order was issued. Subsequently, work was completed. Final measurement was done, but the dues of the petitioner has not been
Last
released.
course of action.
On 4th of July 2022, I made a representation before the
Yes,
authority.
mention in May. Yes.
Lordship, Lordship may I be permitted to mention one matter, Lordship, for upgradation of Lordship. The matter is running as item number 181 in the monthly list of dated 3rd April, Lordship. The urgency being the petitioner runs a kiosk operating service under the Chichura branch of Jhargram district, Lordship, of SBI Bank. On 23rd June, Lordship, the petitioner was served with a notice with allegations.
Come back with dates and years. Yes.
My lord, I appear for upgradation of the matter. Item number 131 of 2023.
Yes. Any other mentioning?
Lordship,
No,
I'd like
no,
to
no,
mention
no, no. Come back with facts. Yes.
Lordship, the petitioner intends to withdraw this instant writ application, my lord, and the
Yes, next day.
May I be permitted to mention one for inclusion. Matter is filed on 19th of December 2022. Until date matter is not appeared.
Yes, next day. Yes. Any original side mentioning?
My lord.
Original side mentioning?
Your lordships.
Next day.
One application matter.
My lord, one extremely urgent matter, my lord.
Original
My lord, one extremely urgent, my lord, leave matter, my lord. My lord, leave
leave
matter.
granted. Original side. Original side.
My lord, it is appellate side, my lord, of extreme urgency, my lord. Work order were issued, my lord, my petition will be infractions, my lord. We have come on March, my lord. Already technical bit has been opened, financial bit has been opened in spite of my objection. None of the financial bit has happened in vain because it's qualifications, my
No
lord.
dates. Yes. No, no. Original side mentioning?
This matter has been
Original side mentioning? Any original side mentioning?
appellate side.
Appellate for withdrawal of the matter.
Original side?
Appellate.
Yes. Call on the list, please. Call on the list.
Do we mention item number 2?
I am praying one matter. Well, I have filed my lord last
Yes,
month.
you have the
I am
petitioner.
for the petitioner,
Last
my
month
lord,
I have filed.
led by Mr. Devabroto Saharay, my lord.
For the respondent number.
This is an
Yes,
assigned.
you are the respondent.
My lord, I have been serving my lord.
No, no mentioning. Didn't you not? Can you not follow the instructions of the court? Please don't disturb the
I'm
court.
just come, my lord.
Yes, yes, you're for the petition.
I'm for the petitioner, my lord, led by Mr. Devabrata. This is an assigned matter pursuant to your lordship's last direction on 10th of April 2023. I have served notice upon the respondents. May I file the affidavit?
You're for the
of service?
respondent.
Three of the respondents, my lord. There are two my lord, private bodies of respondents, my lord. I'm one of them, my lord. And my lord, I have no.
Who is the
privity-
answering respondent?
Asking respondent the Central Warehouse Corporation, my lord.
You're for the Central
No, my lord,
Warehouse?
Food Corporation.
Food Corporation of India, my
When
lord.
did you serve notice to
My
them?
lord. May I file the affidavit?
Yes, the affidavit of service indicates that both the respondents were served on 11/4/2023. Stop. The Central Housing Warehousing Corporation is not represented. Stop. List this matter. What is the urgency?
My lord, it has been assigned before your lordship. As such, there is no urgency.
Very well. List this matter on 11th May.
My lord, kindly
2023.
record my presence, my lord. I'm for respondent number 2, 3, 2, 3, 6, and 8.
If you
my lord.
disturb the court, I will impose costs on you. List this matter on 12th May 2023.
Grateful.
Next.
Item number 3.
My lord, this is for withdrawal, my lord, and the instruction was issued on 28th February 2023, my lord, for not to press this writ petition, my lord.
Yes. A letter dated 28/2/2023 is from the petitioner is kept on record. Stop. The petitioner seeks to withdraw the writ petition. Stop. WPA 21588 of 2022 is accordingly dismissed as withdrawn. Interim orders, if any, shall stand vacated.
Grateful.
And all connected applications disposed of. Next.
Item number 4.
Your Lordship, this is an application filed against the West Bengal Public Service Commission, Your Lordship.
Why is it appearing as to be mentioned?
Your Lordship, this honorable court has the jurisdiction to hear
I
this
can't
matter.
hear you. Microphone,
Your Lordship,
please.
Your Lordship, this honorable court has the jurisdiction.
Why
to
is
hear
it
this.
under to be mentioned?
No, it is listed for release, Your Lordship.
Yes, this is filed under which group?
Group 9, Your Lordship.
Then why do you want release? I'm asking you.
I never.
Then why is it under to be mentioned?
Your Lordship was pleased to direct the court officer to list it for the
Court officer.
release.
This is the
Yes.
first time there's no order on record.
No order. Your Lordship, for the first time, it has appeared before Your Lordship on
Is
three
it an assigned
occasions.
matter?
No, Your Lordship. I had
What is
mentioned
the
it.
urgency?
It was filed in September, and the petitioner had requested for the inspection of the answer scripts, which was as per the direction of Your Lordship in June 2022.
Where is the order of June?
Yes, Your Lordship. It is at page 29, Your Lordship. '28 and 29, Your Lordship. Learned counsel appearing for the petitioner files a supplementary affidavit stating that the Public Service Commission has furnished all.
Yes, Mr. Mitro, what is your instruction?
Lord, Public Service Commission is the answering respondent. Public Service Commission is the answering respondent. They have their own sets of advocate, my lord. They would appear, my lord.
Very well. No one appears for the answering respondent, which is the Public Service Commission. Stop. Next, learned counsel appearing for the petitioner relies on an order passed by this court on 28/7/2022, by which the petitioner was given leave to file a supplementary affidavit. Stop. Have you done that?
Yes, Your Lordship.
The supplementary affidavit has since been filed. Stop. List this matter on 8th May 2023. Stop. council is requested to inform the Public Service Commission of the, communicate this order on the Public Service Commission.
Your Lordship, I had referred the application of the previous writ application, which was filed in 2022. And just because of the new cause of action, this writ petition has been filed.
Very well. Call on the next matter, please.
My lord, let a copy of the supplementary affidavit be served upon us.
Supplementary affidavit.
Yes.
Obviously,
Next.
Lordship.
Item number 5.
Item number 5, my lord, I am for the petition.
I am for the bank, my lord.
Yes,
In this matter,
yes, yes, I will dictate the order at 12:30. Next.
Item number 6.
But I may not beg to appear on behalf of the petitioner, my lord. Lordship, on behalf of Mr. Abhijit Mitra, Lordship, kindly passes it over for a short pass over for 10 minutes.
No,
my
no,
lord.
he was not available last time also. You sit and take notes. How much time will you take, Mr. Rahim?
Lord, I had almost concluded. I just want to wrap it up.
I just, yes, wrap it up, please.
Lord, your lordships are aware, not the ineligibility, my lord, of the respondent number 2, my lord, was in question, my lord.
Yes.
My lord, the entire writ, my lord, if your lordship will see, my lord, the prayers and the grounds, it was only on ineligibility, my lord, except, my lord, for one prayer, which was, my lord, malified exercise of power.
Yes.
Now, my lord, from the side of the respondents, my lord, what I could make out is, my lord, is that they are, my lord, submitting to the court that it is, my lord, only on malifieds. Now, my lord, the prayers are set out, my lord, and my lord, the grounds are also there. I can, my lord, read at least 6 grounds in the prayer. That, my lord, everything is based only, my lord, on ineligibility, my lord, and nothing beyond that, my lord. Now, my lord, if my lord, a holder, my lord, of a public office, my lord, is, my lord, ineligible, my lord, then, my lord, a writ of quo warranto would lie. And for that reason, my lord, I had, my lord, made a submission and, my lord, a prayer for amendment that although a certiorari, my lord, was prayed for, which was for, my lord, calling of the records to the notice of the court, for the court to come up and examine as to, my lord, the eligibility of the respondent number 2. But, my lord, it being an office of public nature, and, my lord, the act itself would show, and the nature of the act, as well as, my lord, the functions of the board, the members of the board, that, my lord, they, my lord, only discharge public functions. It's nothing beyond that. They don't discharge any private function.
So, Mr. Rahim, now I'm hearing the amendment application.
Only the amendment.
So initially the writ had been filed with a certiorari. Then because of the objection taken, you have now included a prayer for quo warranto.
Not only because of the objection, my lord, but because, my lord, I felt that since it is
No, I gave you the option and you said that you would like to amend the writ petition and
to include the prayer of quo warranto, my lord, because the office, my lord, the nature of the office, my lord, is such, my lord, which is of public nature, my lord. And, my lord, my lord, then gave details, my lord. In fact, I filed the volume. The volume 1 is here, my lord. I filed, my lord, a detailed volume as to, my lord, the scope, my lord, of Article 226, my lord. Your lordship, my lord, has taken down, my lord, the relevant paragraphs, my lord.
Volume of cases you mean?
Of the citation, your.
Yes, there is volume 1. How many volumes? Two volumes?
Volume 1 and then volume 2, my lord, I quoted only one, a single judgment by Justice Nageshwar Rao, my lord.
Yes.
Now, my lord, I just want to, my lord, very briefly, my lord, in fact, read the first judgment, which is State of Haryana, my lord, and the relevant paragraph.
Have you not placed these?
I have, my lord. I just wanted to read it, my lord, for 1 minute, my lord. Here also, my lord, in similar circumstances.
Don't place the decisions once again, Mr.
No, I will not. I will not.
Yes.
Except for this one, my lord, I will not.
Yes.
My lord, if your lordship has running page 7 of the compilation, my lord.
Yes.
The first one. The State of Haryana and versus Haryana. Lord, I'll just read this paragraph, my lord. The mere circumstance, if your lordship has that.
Yes.
That the first respondent did not in so many words ask for the writ of quo warranto cannot justify the argument that the appointment was being challenged collaterally in a proceeding taken to challenge the award. Considering the averments in the writ petition, it seems to us clear that the main and real attack on the award was the ineligibility of Shri Gupta to occupy the post of a judge of the labor court in the discharge of whose functions the award was rendered by him. The relief of certiorari asked for by the writ petition was certainly inappropriate, but by clause C of paragraph 16, the High Court was invited to issue such other suitable writ, order or direction as it deemed fit and proper in the circumstances of the case. And this is important. No? There is no magic in the use of the formula. The facts necessary for challenging Shri Gupta's appointments are stated clearly in the writ petition, and the challenge to his appointment is expressly made on the ground that he was not qualified to hold the post of a judge of the labor court. So almost, my lord, the facts are similar, my lord, that wherever, in fact, had I also not prayed for it, my lord,
Yes.
then also if your lordship felt, my lord, that this is an office of public nature, then, my lord, the question would have come from the court itself and to all of us that this office appears to be of public nature. Why should a writ of quo warranto, my lord, not be granted?
No, you're saying that even in the absence of
Even in the absence of, my lord, it my lord falls for consideration, my lord, because your lordship, that those judgments are read, the search for justice is important. So, my lord, it doesn't, my lord, bind the hands of the court, my lord, to, my lord, say and ask or inquire that why should a writ of quo warranto be not issued? This being an office of public nature.
Yes.
My lord, and there are sections, my lord, of the Waqf Act, which, my lord, amply demonstrate, my lord, and speak, my lord, that the members of the board, and they have to be a select few.
So, Mr. Rahim, are you saying that it is not even necessary to plead or pray for certain
No,
prerogative
pleading is
writs?
important, my lord. But if I miss out a prayer, my lord, then the pleadings itself will justify, my lord, the prayer and, my lord, the query from the court, because like I submitted last time, my lord, that it is only in the nature of an information. I give the information to the court.
Yes.
In a writ of quo warranto, my lord, it's of a technical nature. I give the information, my lord. I'm in the position of a my lord, a relator. And the court, my lord, orders an inquiry into it. That if the ineligibility is there in an office, essentially, my lord, the words are, my lord, substantive, liberty, and, my lord, franchisee. In my lord, the state of Mysore versus University of Mysore, my lord, versus Govindrao. That was the first case, my lord. If your lordship want, my lord, I have given the paragraph. Your lordship remember, my lord, of course, deeply, my lord. So, my lord, the wide powers are there. To, my lord, to search injustice is important. There is nothing malified here.
To reach injustice.
To reach injustice. So there is no malified here. Like Mr. Mitra saying, my lord, he's only on the malified part of it. Here there are no malifieds. Here the only test is, my lord, the ineligibility to a public office. Now, my lord, the judgment relied on by Mr. Mitra, my lord, with great respect, my lord, if your lordship has it, my lord. He read 1 or 2 paragraphs, but my lord, in fact, the University of Mysore was quoted there. If your lordship may see, my lord, that is, my lord, on the doctrine of futility. In Justice A. N. Ray's case, my lord, he was, my lord, a judge of the High Court, of the Honorable Supreme Court, my lord. And, my lord, your lordship knows, my lord, the historical background as to what happened at that point of time. Somebody, my lord, filed a quo warranto, my lord. What the Delhi High Court held, my lord, was that now because of the retirement or the resignation, my lord, of the 2nd, 3rd, 4th, and 5th judges, there is nothing, my lord, which, my lord, requires a writ of quo warranto because his eligibility is there. So the eligibility of Justice A. N. Ray, my lord, was there, being my lord, a judge of the Honorable Supreme Court. But, my lord, because of the subsequent resignations which occurred, my lord, during the time of the emergency, my lord, he, my lord, automatically came to, my lord, such a position, my lord, that he became senior most. And, my lord, that is where the doctrine of futility came in. Both the judgments relied upon, my lord. I'll just read for my lord, my satisfaction, my lord.
Have you distinguished the cases cited by Mr. Mitra?
No, I could not that time, my lord. That's why I'm saying, my lord, it was more on the principle of futility that those 2 judgments were there.
Have you filed a compilation or what?
There was a compilation by both, my lord.
I have not filed a compilation. I have handed up the judgment.
Very well. Yes. Which is this?
Lord, this is, my lord, I think civil writ, my lord, 671. They have given an SCC online.
Mr. Rahim, for distinguishing the cases, how many cases have you cited?
We have cited 4 cases. I believe.
4. You come back on any other day for distinguishing. All right.
Tomorrow, my lord, I can.
Tomorrow. Very well. Yes. Learned counsel appearing for the petitioners will distinguish the cases tomorrow. Yes. Next. Distinguish the cases cited on behalf of the respondents tomorrow. Next.
Remain, my lord, a little bit high on the board like today is my request, my lord. Day after tomorrow, I may go, my lord. A little bit higher on the board like today.
Let us see. Next.
Greatly obliged.
Next.
My lord, in this matter, my lord, lordship might recall I appear on behalf of the petitioner, my lord. Challenges with regard to
Yes, yes, I remember. Have you finished, Mr. Kundalia?
He was supposed to take instruction about the outer limit, my lord. Lordship was indicating.
Yes, yes. I can't hear you. Yes.
My lord had called upon me to address on the point of jurisdiction. My lord, on the point of jurisdiction, I said that the action is, the litigation here is barred by constructive res judicata. On that, my lord, I have placed my judgments.
I remember. I had asked you that what would be a reasonable period of time.
Reasonable
Yes.
period of time, my lord. I have taken instruction and they have said, my lord, if I may just,
Yes.
because there are my lord, 79 summons have been sent at the moment. Investigation is going on in that scale, my lord. More than 40 companies are being investigated.
No, I'm not really concerned about 40 or 79 summons.
My lord,
What
if
about
my-
the petitioner?
my lord, my
Who
lord,
is before the court? That's all.
petitioner is before the court. Petitioner's investigation, he hasn't come, my lord. He hasn't come.
Mr. Kundali, obviously, if the petitioner does not come or fails to appear, then the situation will change. But your instruction was to be taken only on the reasonable window.
Instruction, my
That's all.
lord, reasonable period vis-a-vis only the petitioner would be very difficult to say. It is very difficult to say because based on the overall, the investigation is of the fraud.
Yes.
And my lord, at any point of time, if my lord feels that my lord wants to enter into the main matter, my lord, then my lord will then allow me to address on the main matter and then because I have, my lord, question the maintainability, my lord.
Very well. Mr. Kundalia, you main matter, you were saying that the writ petition is not maintainable because of the Gujarat High Court orders. That is all. That was your limited. That was your.
That is what I was called on to argue on, my lord, on,
Yes.
on jurisdiction, my lord.
Yes. Mr. Deb, do you want to argue on the main writ petition?
Yes, my lord, but I have to meet with their point because today the 2 applications are pending before your lordship. My lord, those applications are to be disposed of, subject to what falls from your lordship. So let me, my lord, meet
Very
with
well. You can answer on the preliminary point and then I will.
immediately, my lord. I will
Yes.
not take much time, my lord.
Very well. Yes.
He has cited, my lord, his argument was, my lord, twofold, my lord, if I have understood him correctly.
On the maintainability.
On the maintainability regarding an order directing, my lord, the SFIO to conclude the proceeding within time-bound manner.
Yes.
First is, he says, my lord, my writ petition itself is not maintainable because of res judicata, doctrine of finality.
Yes.
That is his first point, and he has cited 4 judgments.
Yes.
With greatest of respect, my lord, my answer is, those judgments do not apply in our case.
So Deb, move the microphone, please. That's
Sorry, my lord. Lordship can hear me, my lord.
Yes.
My first limb of submission is, those judgments, my lord, do not apply. If lordship reads, my lord, section 11, my lord, of Code of Civil Procedure, that is what has been defined, the word res judicata. it has to be between the same parties or the parties under whom or any one of them claim.
Yes.
Second thing, the proceeding has to reach its finality. My first answer is good, bad, indifferent, SLP is pending, the order which he has shown. So it has not reached finality. Second, in this writ petition, Millard, we have made the official liquidator a party. Our case is that SFIO, Millard, the officers, they were not conducting the investigation in terms of the provisions as contemplated in the Companies Act. They have exceeded the power under section 217, power of the investigating officer, and also they have exceeded the power what has been contemplated on them under section 220, duty and the power of seizure. Our case is that certain documents are not with us. Documents are with the official liquidator. So we have made them a party. What is their point? They say, after I attended the hearing for 4 times, you are again required to come and give evidence. I have given evidence. To that I said, certain documents are with the official liquidator because company has gone into liquidation. And this is very important and admitted position, if I may say so. The official liquidator has filed an affidavit here saying that certain documents are lying with him and those documents have been handed over by them.
Official liquidator of one of the 40 companies.
Millard,
Yes.
Gujarati.
Very good. Yes.
Now that affidavit is there. So the parties are not the same. Official liquidator is not party to any of the proceedings pending in the Gujarat High Court. That he has not shown or pointed out, should have been done. My challenge in the 3 writs which I filed in the Gujarat High Court, 2 essentially for doing the investigation virtually because of my ill health. Third one, which he emphasized, my lord, that is that I have challenged the investigation procedure. That's true, I have done it.
Mr. Dev, the first point which you have to place before the court is 226(2).
Yes, immediately I would. Immediately. So, my lord, with regard to his point, res judicata and constructive res judicata, those judgments do not apply, my lord.
Yes.
For the first reason, not reach finality. Second reason, official liquidator is not a party. And that is the basic ingredients of res judicata or constructive res judicata. Though the constructive res judicata says point ought to have been taken. I had the opportunity, I have not taken. That is not here because I have taken all points. Now, my lord, with regard to the maintainability, what is from your lordship, the jurisdiction 226(2), I would satisfy your lordship. Kindly, my lord, come to the writ petition. Lordship says, before I pass an order, you just satisfy me that this court has jurisdiction or cause of action has arose in this court 226(2), partly or fully.
Yes.
Kindly takes up the writ petition, my lord, which I filed in this court, where, my lord, the 2 applications have been filed, WPA number 3607 of 2021.
Yes.
Application 3607. The other writ I am not placing, my lord.
Yes.
My lord, kindly comes to the relevant paragraphs which attracts the jurisdiction of this court. I will only show, my lord, those paragraphs and not others. Paragraph 3, lordship would kindly come to. Before that, kindly see the cause title once. That is important with regard to his point of res judicata. Respondent number 7 is the official liquidator.
Yes.
As I submitted before your lordship, my lord, my case, my lord, rests in this writ petition that investigating authority has not only exceeded the powers, but certain documents are with the hand of the official liquidator.
Yes.
Official liquidator is not party, as I submitted before the Gujarat High Court, not been made a party in none of the proceedings. Paragraph 3, lordship, my lord, kindly comes to, my lord. All on 226(2), my lord.
Yes.
The petitioner number 1 is one of the trustees of Giridhari Lal Arun Kumar Family Trust, hereinafter referred to as so-and-so. Giridhari Lal Arun Kumar Family Trust is the owner of office premises and Block C of 22 Kamak Street. The petitioner number 1 is one of the directors of so-and-so and other companies in Gujarat NRE Group having offices in Block C, 5th floor, so-and-so has leased out and rented out the office premises to Suraj Bari, and that the Suraj Bari, in terms of the internal arrangement, has allowed the following Gujarat NRE group companies to run their office in the office premises. That is within the jurisdiction. Now, paragraph 5.
Yes.
The respondent numbers 3 and 2 are the investigating officers, are designates of Serious Fraud Investigation Office being respondent numbers 2. The respondent number 8 has been appointed by the respondent number 7, being the liquidator of Gujarat NRE Coke Limited, to assist the respondent number 7 in liquidation, and thus the respondent number 8 reports to the respondent number 7 and carries on instructions of the respondent number 7. Then straight away, Lordship would kindly come to paragraph 28. There are certain documents I would also show.
Which page?
Paragraph 28, running page 17.
Yes.
Lordship has got it, Milord.
Yes.
The petitioners state that despite such prompt support and cooperation of the petitioners and their company, GNCL, since March 2019, with regard to providing documents and information as stated herein above, on 19 January 2021, all of a sudden, in the middle of COVID-19 pandemic, a team from SFIO comprising of about 12 to 15 people, led by so-and-so, the respondent number 8, barged into the office of the petitioners at around 1 p.m. on 19 January 2021 and started mishandling the staff present.
Please don't place it. What is the point of
Point is the cause of action, 226(2). What prompted me or compelled me to come before this court? This is the cause of action.
Yes.
And 226(2), my lord, Lordship knows, my lord, partly or wholly or in part, as defined in section 2. It's akin to section 20 of CPC. Cause of action partly or wholly arises. Then, my lord, again, paragraph 29. Same thing, my lord, I have pleaded. Paragraph 29. I'm not placing in the entire paragraph. The petitioners were later informed by the employees present that the SFIU officers, namely so-and-so, in excess of their powers, started abusing, threatening the staffs, and even assaulted them. The said team did not show any search warrant to the staff present there and illegally forced them to open the locks of the cabins, etc., which always remain locked. In the absence of petition number 1 and 2, Mr. Rajiv Agarwal, being the respondent number 8, was even instructing the SFIU team carrying out specific search of the various rooms, cabins. I say, my lord, these what the SFIU officials have done, that is, my lord, beyond their scope and power as contemplated in section 217 and section 220 Companies Act. This is the cause of action for filing this writ.
Very well. Mr. Deb, why did you then shift your jurisdiction or shift your base from Calcutta to Ahmedabad?
I tell you, Lordship, my lord, why? After filing this
was the first writ
this
petition.
was the first writ petition.
Yes.
Then, my lord, after that, my lord, since I presently reside in Ahmedabad, my lord, they issued summons that you come physically. Here, my lord, I have pleaded that 4 times I attended the hearing physically. Lastly, I had done it in December 2019. Thereafter, because of COVID pandemic and because of my ill health, as I could not go, I requested them to give time. Since summons were issued, my lord, that's why I filed the separate writ petitions in the Gujarat High Court.
Yes, I remember that decision cited by Mr. Kundalia, that the proceedings which attain finality in terms of adjudication decision, that will be taken as the relevant.
As the relevant erroneous jurisdiction.
Yes.
That, my lord, with greatest of respect, my lord, may not apply in this case, because attaining the finality means the litigation has come to an end. This is little what I understand. So long the litigation is pending in any forum, you can't say the litigation has attained finality. For deciding an issue, res judicata, my lord, not only the final prayers or issues relating to interlocutory prayers is also res judicata, 60 Supreme Court 941.
Very well. Your next point, Mr. Deb.
Now, my lord, the cause of action, my lord, certainly, my lord, has arisen within the jurisdiction of this court, my lord. There are 2 or 3 paragraphs I would just show to your lordship, my lord. Paragraph 32, paragraph 35. Kindly come to, my lord.
Yes, they made those raids.
Yes. Now, my lord, paragraph 47, again, I have pleaded. Paragraph 40 is also important. Kindly take note of it. I say they have not acted or complied with the section of section 207, powers given to an SFIO officer or official. Paragraph 40. Paragraph 40 of my writ petition.
Yes.
What power has been conferred and how this has been misused. This is what I have pleaded to attract the jurisdiction of this court. And admittedly, raid and search was conducted in Kolkata. There is no dispute. So certainly, my lord, if lordship sees or looks into section article 226(2), obviously this court has jurisdiction. There is no doubt. And I cite two judgments, my lord, on this proposition, though, my lord, the article 226(2) is absolutely clear. Judgment below the
So you're restricting your argument on the territorial jurisdiction.
territorial and cause of action, lordship says
226(2) territorial cause
yes,
of action.
and
Yes.
also cause of action. And there are certain 2-3 documents I would show, my lord. I would not waste your lordship's time, my lord, because I have already shown you the pleading. My lord, kindly come to page 51, the necessary documents. Even if I can show one document, that is good enough, my lord,
Yes.
to prove that this court has jurisdiction. Page 51, lordship has got it.
Yes.
Gujarat NRE Coke Limited, kindly see the registered office within the jurisdiction. Letter has been written, letter dated 28th August 2019, written by the company secretary, written by the IT manager, then addressed to the Gujarat NRE Coke Limited. Now, this is what they have informed. This is to inform you that from 26 to 28th August 2019, team SFIO, then my lord, certain names have been given, has copied the hard disk of all the users and they have said that. Then my lord, kindly my lord, comes to my lord. Page 50, my lord, once. Letter dated 15th March 2019. Written by the Deputy Director, lordship would find the address at the top. And kindly similar to whom it has been written, the official liquidator already in possession within the jurisdiction. They are saying that they would be investigating, and Government of India had assigned the SFIO to investigate. So all letters were written within the jurisdiction. There are other documents galore, I can tell your lordship. I can give you the pages, my lord, page 366, page 370.
Very well.
There are
Any other point, Mr. Deb?
my lord, the two judgments, if lordship wants, my lord, I can cite.
Yes,
My lord.
I will have to give Mr. Kundali a chance to rebut. Yes.
Now, my lord, before I cite, my lord, kindly, my lord, takes up, my lord, my CAN application, which is the subject matter of the issue at present, my lord, because I'm pressing CAN 1.
You have filed a CAN or Mr.
I
Kundali
have
has
filed
a CAN?
2 CANs.
Your CAN is for what?
CAN 1, the first CAN, directing the SFIO to file a report. Now, he has cited one judgment, my lord, Rahul Modi's case, saying that there is no outer limit to conclude the proceeding. And lordship has rightly said, if the judgment is read, my lord, lordship would find it says that if that is accepted, the outer limit, and if there is a direction given to conclude a proceeding within a time limit, that would be basically, my lord, denuding the power of the investigating agency. So that cannot be done.
I could not follow. What is the point?
My lord, he has cited, my lord, one judgment, Rahul Modi's case, my lord.
Yes.
Now, he had cited that judgment for the proposition that there is no outer limit prescribed in the Companies Act.
Yes.
Court can direct to conclude.
212.
Yes, 212.
Yes.
Now, I had read that judgments. It says that the provision is directory, not mandatory. But court decided that issue while interpreting, my lord, whether the power of the investigating...
This is Justice Lalit's judgment.
Yes. Whether it can be denuded, the power of investigating agency. I have no issues with that. But there is one catch. Kindly have a look at the Companies Act. This has been discussed there. section 212 once. I am not saying for a moment that the outer limit has been prescribed, but there is a catch.
Catch for who?
To conclude, within the time as notified by the central government, issuing the SFIO to commence the proceeding. 212 subsection 3. And in our case, initially it was 6 months I have annexed in my application. May I, my lord, read out this? Where the investigation into the affairs of a company has been assigned by the central government to Serious Fraud Investigation Office, it shall conduct the investigation in the manner and follow the procedure provided in this chapter and submit its report to the central government within such time as may be specified in the order. Now, kindly have a look at
Which order is this?
Yes, there is an order. Kindly come to page 28 of my CAN application. I thought that can be sorted out, my lord. This particular thing, the cans can be disposed of subject to what falls from your lordship. Running page 28. I have many things to say, my lord, on merit, but if I participate and if a time limit is prescribed, that you conclude with certain guidelines that I would be going there, I would take if necessary, a medical help because my health doesn't permit and I can't fly. I can't.
Going there as in Ahmedabad?
No, in Delhi. Delhi is their office where they will be interrogating me.
Yes.
So I am agreeable to go. Before that, I will just show page 28.
Yes.
Kindly see the date. Date is 28 December 2018.
Yes.
And lordship would find from paragraph 4, time limit was initially for a period of 6 months.
Yes.
That the inspector so appointed the director SFIO to investigate into the affairs of Gujarat NRI Coke Limited, so and so, last but one line, with a period of 6 months from the date of issue of this order. This is the order what was being quoted in subsection 3 of section 212. Yes, I accept subsequently time has been extended. So there was a time limit within which, my lord, you could not. Now, my lord, today what I propose, my lord, I don't think the judgments which I propose to cite after I showed you the averments really important because the Supreme Court judgments say, even if the cause of action partly arose, then obviously.
So you're saying that they were supposed to file a report within 6 months to the central government?
My lord.
That is what 2123 says.
Yes. Now, what he has said by citing the judgment, interim and final report, and kindly have a look at section 212. I'm grateful to your lordship, my lord, 13. Whether a litigant can approach the court seeking the court's approval to get a report, notwithstanding non-obstante clause, notwithstanding anything contained in this act or in any other law for the time being enforced, a copy of the investigation report may be obtained by any person concerned by making an application in this regard to the court. He says this has to be a final report, can't be an interim report. That is his interpretation after citing that judgment. Now, I have made a prayer in Can 1, direct them to file a report. Now, to that, their argument was that you did not participate after 2019, good, bad, indifferent, though I don't accept. They say you have deliberately avoided. Now, my lord, today what I submit before your lordship, subject to what falls from your lordship, lordship would direct them to, my lord, conclude the proceeding within a time, and, my lord, with certain guidelines. My lord, number one, that I should be, my lord, permitted, my lord, to take the medical assistance because my oxygen level fluctuates. My lord, so if necessary, he will be waiting outside. If I am not well, then I can take his help. I don't think he can object. If the interrogation continues, say, for about 12 or 14 hours a day, they should give me a break for about 1.5 hours. He says normal, very well. Now, my lord, they should give me a 10 to 15 days prior notice because I can't fly. I have to go by road. I would go without prejudice to my rights and contention in the writ petition, certainly because I have challenged the proceeding initiated by them saying that that is, my lord, non-est. I'm agreeable to show my bona fide. And can 2 is there. In can 2, my prayer is this should be done by way of a video recording. Supreme Court said that. There is an apprehension always in the mind of the person who is going to be
The Gujarat High Court Division Bench was a pre-COVID judgment.
post-COVID, I think.
Post-COVID.
Post-COVID. Pre-COVID, I approached. And there is a judgment I annexed in my can 2. I'm not saying I will do it virtually. I'm agreeable to go there physically, but kindly put an end to it. And there is one more reason why I say. There is an affidavit filed by, very important, Lord, SFIU, which I have annexed in can 1. Kindly come to this in Gujarat High Court. Because all conducts are to be looked into. Kindly, my lord, come to page 65, which is a part of the affidavit filed in Gujarat High Court, where my writ petition was not entertained. Page 65, 9.1.
Yes, the
Yes.
company has not engaged in any fraud.
No, yes. So these things are to be considered. And I say in this writ petition,
Company is which one?
company is Gujarat NRE. NRE Coke Limited, 5 lines from the top. For 6 lines, 1, 2, 3, 6 lines from the top. Investigation into the affairs of Gujarat NRE Limited, Lordship has seen. Then this averment. There is double no, but I would interpret, yes, nothing has been found.
Yes.
So even then I say I would go if Lordship passes this order without prejudice, and let that be recorded. Video recording should be done. That is the Supreme Court has said, and I annexed this judgment, my lord, in can 2. How the procedure or the investigation has to be conducted, Supreme Court has said, following a judgment of 2018, volume 5.3 SCC, and I annexed the latest one, my lord, in can 2, that it should be done by way of a video recording. And everything has to be
No,
preserved.
The investigation should be done, or you go and
No, I will go there physically. The investigation.
your
Absolutely,
evidence
only the
is-
investigation. That is my prayer in the can 2. This can be disposed of. A lordship can fix a date for hearing of this writ petition. In fact, this was heard. Affidavits are complete. Unfortunately, my lord, lastly, it was heard by Justice Bhattacharya, Shobhoshaji Bhattacharya. Written notes were invited, parties filed. Then, because of change of determination, it could not be heard. So the jurisdiction point, I think I have, so far as this court. Litigation has not reached finality. Res judicata do not apply. And the other decision is the erroneous judgment he has cited. That is an exception which has been curbed out. Section 11. Erroneous decision or a jurisdictional error, if an order is passed, that can't be res judicata. I accept that. So these things, Lord, I submit. And one more thing. Official liquidator is there. His affidavit is on record. He says certain documents he have got it, though they have denied. Kindly permit the SFIO or me, because they are the investigating agency, because certain documents I don't have,
But
to approach the official liquidator.
Mr. Dev, if I were to dispose of the 2 applications,
Lordship.
cans,
Yes.
what remains of the writ petition?
Challenge about the entire proceeding. I will participate without prejudice. My challenge is the procedure or the method or the measure you have taken. That is in violation of the Companies Act. My challenge remains. Yes, I would participate. In the meantime, if the inquiry proceeding is concluded, my writ will become infructuous. I would withdraw. If it is not, I cannot, my lord, given a go-by to my right that I have under the statute. Prima facie, that this has not been done in terms of the provisions of the Companies Act, not in contemplation. You have violated. Section 217 and 220 has been violated, misused by you. That challenge remains, but I would participate because my conduct is also important. This is a fact which I cannot deny. I approached the Gujarat High Court.
Which is the new judgment you cited, or you haven't
But
cited?
I haven't cited anything because I thought this cause of action part, no judgment is required. If you read 226.2, there are judgments galore, my lord. I don't want cause of action partly. And one, my lord, the affidavit of SFIO, 1 paragraph. Why I say a direction is necessary to the official liquidator to produce certain documents, because he has also argued. He says, he has asked me to come. I said, documents are not with me. This has been continuing, and this will continue unless this direction is given. Kindly see 1 page of the affidavit filed by official liquidator. He admits the fact after the company has gone into liquidation, he is holding certain documents. And these are the documents which he is asking.
Very well. Mr. Deb
can
and
be
Mr.
sorted.
Yes. Mr. Deb and Mr. Kundalia, just give me a 2-page just points
My lord, only on application, my lord, because
on the maintainability and the applications.
maintain.
Before that, my lord,
Mr. Yes,
before that, my lord, 2 or 3 things that
yes,
Mr. Dev has said just now. One is he referred to
Mike,
page 65
yes,
of the affidavit of the CAN application number 1.
yes.
My lord, may kind-
I'm sorry, my lord, one more thing. Since lordship is inviting a note, my lord, then my lord, I would cite my lord 2 judgments today just for 2 minutes, because let him deal with that.
Yes, yes, Mr.
Because
Kundalia.
just 2 judgments. I can do it right now or after he finishes.
Very well. Mr. Kundalia, you make your point after.
Just two judgments on this, my lord.
Yes.
2014, volume 9, SCC, page 329,
On which point?
cause of action, jurisdiction of the court. দেবো নিশ্চয়ই দেবো দাদা copy দাও. Just give me a minute's time. I'm extremely sorry, my lord. Kindly give me copy. My lord, it's handwritten, my lord. Kindly, my lord, pardon me, my lord.
That's all right. Yes.
2014, volume 9, SCC, page 329, paragraph 9 onwards, 14-19. একটা কপি ওনাকে দাও।
Yes.
Paragraph 9, it says, my lord, the interpretation given by this court, this is 226(2).
Yes.
Then, my lord, paragraph 10, my lord, it discusses about the jurisdiction or the cause of action. It says somewhere, my lord, that this is akin to section 20 of Code of Civil Procedure. Then paragraph 9, 10, 11, I'm only pointing out the paragraphs, my lord. Paragraph 14, 9 to 14. Paragraph 14, if I may place it, in Om Prakash Srivastava versus Union of India, this court referred to this gentleman. Answering a similar question, this court observed that on a plain reading of clause 2 of Article 226, it is manifestly clear that the High Court can exercise power to issue direction, order, or writs for enforcement of any of the fundamental rights or for any other purpose, if the cause of action in relation to which it exercises jurisdiction, notwithstanding that the seat of the government authority or the residence of a person again in any direction, order, or writ is not within the territory. In paragraph 7 has been quoted there, my lord. In order to maintain, the judgment has been quoted, 3 lines. In order to maintain a writ petition, petitioner has to establish a legal right claimed by him as a prima facie has been infringed or threatened to be infringed, by which the respondent within the territorial limits of the court's jurisdiction. Such infringement may take place by causing the actual injury or threat thereof. Then, my lord, this is all with regard to Article 226(2), my lord, the cause of action. Then paragraph 19. Because the challenge was the dismissal of a writ petition, paragraph 19. Considering the entire facts of the case narrated herein before, including the interim order passed by the High Court, in our considered opinion, the writ petition ought not to have been dismissed for want of territorial jurisdiction, as noticed above. At the time when the writ petition was brought for the purpose of granting of interim relief, the respondent, instead of raising any objection with regard to the territorial jurisdiction, opposed the prayer on the ground that the appellant writ petition was offered on land. This is something different, but he refused to accept the same and challenged the order of granting severance compensation by filing the writ petition. The interim order therefore cannot be sustained in the peculiar facts of the case, and the matter was again relegated. But sum and substance, my lord, is the jurisdiction if lordship reads, my lord, paragraph 9 to paragraph 14 and 19. Then one judgment, my lord, I cite, my lord, 2000 volume 7 SCC 640, which has been referred to, my lord, along with the other judgments, my lord. Dao. This is also, my lord, Article 226(2), my lord, apropos to what had fallen from your lord. Paragraph 17 to 22. 27, 30, 45, 46. Lordship can take note of this.
17 to 22. and
17 to 22, paragraph 27, 30, 45, and 46, my lord. There also a challenge was made when a writ petition was dismissed, my lord.
Yes.
And finally, Supreme Court, my lord, remanded the matter. Now, my lord, kindly sees, my lord, paragraph 17, sorry, my lord. From the provision in clause 2 of Article 226, it is clear that maintainability or otherwise of the writ petition in the High Court depends on whether the cause of action filing the same arose wholly or in part within the territorial jurisdiction of that court. In legal parlance, the expression cause of action is generally understood to mean situation or state of facts that entitles a party to maintain an action in a court or a tribunal, a group of operative facts giving rise to one or more basis for suing, a factual situation that entitles one person to obtain a remedy in court from another person. In Stroud's Judicial Dictionary, then what is cause of action? That has been defined. I am not troubling you, Muller. Then the words and phrases that has again been defined. Then paragraph 21, an earlier judgment has been referred to, and it has been quoted. What is jurisdiction? Paragraph 22 also an earlier judgment, Muller, has been quoted, Muller. Then paragraph 29. Lordship has got this, Muller. Considering in the peculiar fact situation of the case, we are of the view that the setting aside the impugned judgment and remitting the case to the High Court for fresh disposal will cause further delay in investigating of the matter and may create other complications. Instead, it will be apt and proper to direct the further investigation relating to complaint filed by so-and-so should be made by the Mumbai police. Accordingly, we allow the appeal, set aside the judgment under challenge and dispose of the writ petition with the direction that the complaint lodged by JB Holding Limited at Shillong, which is presently being investigated by the Special Superintendent of Police CID Shillong, shall be transferred to Mumbai Police for further investigation through its economic offences wing, so or any other branch. Then Muller, Justice Thomas Muller, concurring with the view 226(2) jurisdiction, Muller, he has added few things. So on this, Muller, I just cite two judgments.
Very well. Yes, Mr. Kundalia.
My lord, both the judgments that are cited, my lord, is something which is not dealing with my point at all. I have never said that this court doesn't have concurrent jurisdiction. But he has chosen another court.
Yes.
He has gone there and got his writ petition heard. He is seeking the same prayers before my lord. That is on that basis, I made my submissions and I have placed the relevant judgments which have not been dealt specifically by my learned friend. Now coming to the factual aspect that he has dealt with, my lord will kindly take can 1, page 65 again.
Yes.
Of my affidavit that he is referring to. My lord, it's interplay of words which has been put differently. My lord will kindly see that particular paragraph towards the end. Further, my lord is.
Yes, I have got it.
Further, it is submitted that the investigation is not based on reports of the banks. Rather, it is an independent fact-finding investigation. And till date, no such fact has been revealed by which it can be said that the company has not engaged in any fraud. No fact has been revealed.
I've read that. Mr. Kundalia, I will disregard this paragraph.
Thereafter, my lord kindly sees, contrarily, there are
Sir,
findings.
Mr. Kundalia, not necessary.
Well,
I will
that is-
disregard this affidavit of yours.
Now, with regard to the other fact that he pointed out was the order, which he showed at page 28, my lord.
Yes.
Which is dated 28/12/2018. Now, my lord will kindly see.
Yes.
This is the corrigendum of that.
My lord, I'm sorry, my lord. I have submitted
place
that
that.
time has been extended. This I submitted.
Yes.
Even after showing.
So controversy today is not that there is 6 months there and this report has not been given in 6 months. Now the question in Rahul Modi was that there was a specific direction of an interim report to be given within 6 months. And that report was not given within that 6 months, which is why it was challenged. The investigation proceedings were challenged. The court clearly came to a finding that this is merely directory and not mandatory. And even thereafter, investigation can continue, my lord. So now, but these are the 2 points. With regard to
So, Mr. Kundalia, you're saying that by the corrigendum, that 6 months was
Yes, my lord.
enlarged,
There is no time limit on that.
extended.
Extended. My lord, may I place one judgment only? One judgment only, since this point of investigation has been brought in, my lord. I'll only place, I will not take too much time, just the Arnab Goswami judgment, my lord. Amar copy to good.
Justice Chandrachud.
Well, Justice Chandrachud's judgment. My lord will only refer to para 47 and 48. Well, he cannot dictate the investigation, my lord. I will kindly take paragraph 47. It has referred to the Chidambaran judgment, Chidambaran case. It specifically says
Paragraph 47 is which page?
47 and 48,
Yes, I found
my
it.
lord.
Yes.
Relevant paragraph. And may I also, in the same line, give the judgment of Chidambaran, which has also been quoted here in Arnab Goswami, my lord. My lord, the relevant paragraph is paragraph 66, my lord.
Very well. Yes.
My lord. So, my lord, my respectful submission is that
No, what is 47, 48? What does
my
it
lord,
say?
47, so long as there is no violation of provision of law, it is not for the court to monitor the investigation, my lord. With regard to this is Chidambaran. Para 66 of Chidambaran, my lord.
Yes.
And with regard to Arnab Goswami, my lord, accused person does not have a choice in regard to mode and manner in which investigation be carried out. Line of investigation cannot be deleted or controlled by the persons
where
under
are you reading
investigation.
from?
Relevant paragraph 47 and 48, my lord.
Yes.
This is the gist, my lord. Well, may I?
Where does it say
May I
accused
place 40?
person does
May
not
I?
have
May I?
any
May I?
choice?
May I?
Where does it say that?
My lord. Paragraph 47.
Yes, I have found it. Yes.
My lord will kindly come to paragraph 48
Yes.
in the Niyamvadi case. Any observation which may amount to interference in the investigation should not be made. Ordinarily, the court should refrain from interfering at a premature stage of the investigation, as that may derail the investigation and demoralize the investigation. Of late, the tendency to interfere in the investigation is on the increase, and court should be wary of its possible consequences. But my lord, before that, my main point was that today he has chosen his forum. He has chosen his forum. He's failed there and he comes back here on the same points. And that is doctrine of finality, that is the abuse of process of court.
So you're saying that
the SLP that
you're saying that he can't wait for the Supreme Court to decide.
There's no stay, my lord. First of all, there is no stay. It will be the investigation will be therefore totally in the grip of the of this person and compromise. finality in that writ court, in that jurisdiction is over. And the division bench. Tomorrow, if some other judgment falls from this court, my lord, it may be possible.
Other judgment with reference to?
With contrary to what the Gujarat High Court. That is not something which the Constitution has
And the
envisaged.
petitioner had asked for a time-bound investigation over there as well.
Yes, my lord. I have given the prayers, my lord. The chart I have given, my lord,
Yes.
specifically dealt with it. And today he is not denying that. He is not denying today before my lord that he has not gone before the court. He is not at any point of time saying that question of jurisdiction was taken at any
Very well.
point.
Mr. Kundali, I've understood.
My lord.
You please also give your 2 pages, all
But
right?
just one, my lord, just half a minute. Kindly takes up the judgment, Chidambaram's case, my lord.
Yes.
Just one. I was just reading. I would indicate in my note, my lord, while distinguishing.
Yes.
He has referred to paragraph 66.
Yes.
Kindly read paragraph 67. Can it be an absolute proposition of law?
No, I've never said that.
Just wait. I just put this question to myself. Reading a particular paragraph from a judgment, I don't think it helps him. It refers to that paragraph 66. It says cannot be interpreted with but 67. Kindly see. It is one thing to say that if the power of investigation has been
Yes,
exercised.
I've seen where there's
Yes,
a abuse
yes.
of power. Yes.
Absolutely. And this has to be read with the decision of judgment of Justice Chandrachud also. I would find it out. But I would indicate all, my lord, in my note, my lord.
My lord, the principle of Chidambaram has been thereafter expanded in Arnab Goswami.
Microphone. You're for the?
I appear for the liquidator of Gujarat NRE, my lord. Just wanted to clarify as far as can 1 and 2 are concerned, my lord, there are no prayers against the liquidator of Gujarat NRE, my lord. So we are not we have filed an exhaustive
Yes.
affidavit in the writ petition, my lord.
Yes, learned counsel appearing for the petitioners. And this is only against the petition number 2. Yes, petitioners
Petitions.
and the SFIO have made their submissions. Stop. List this matter on 4th May 2023 for council to file their points.
Lord, one thing, my lord.
All the petitioners are directors of the company.
My lord, I have to take yes, my lord.
No, you have made, that's what I'm asking you, Mr. Dev. You have
My lord,
made so many
my lord.
petitioners.
Yes,
That's
my lord. Yes, my lord. Yes. And one thing, my lord, lordship would take note, my lord, that he has said when lordship asks a specific question, you can't give you the time. His answer is no. That's the important thing. Common 79 companies, no. My lord, 4th of May, lordship has fixed it, my lord, for file. I'm grateful to your lordship.
Call on the next matter, please.
Item number 8.
Well, may I please, madam, the petitioner. This is my affidavit of service.
You just, my lord, I made a mistake. My lord.
I can't hear you. What are you saying?
I made a mistake. I should have clarified. My lord, 2 petitioners, lordship asked whether they are the directors. Only, my lord, 1 petitioner. The lady, my lord, she is not.
Very well. Yes.
I got
Yes.
it. I'm grateful.
Yes.
Yes. Well, these petitioners earlier came before this honorable court, praying for enlisted their name as beneficiaries under Gitanjali scheme for providing the fund for preparing a house. Now, all of the petitioners belong to economically weaker section peoples.
Yes.
And my lord, pursuant to that order passed by this honorable
What is the Gitanjali scheme?
Gitanjali scheme is, my lord, to provide the fund for constructing residential house of the people living under below poverty line as economically weaker section people.
And who will give that fund?
Gitanjali scheme give the government of state government.
Yes. So
Now-
are you eligible?
Yes.
You're
So,
eligible.
Yes, my lord. Kindly
How-
have a
how
look,
do you
my
know
lord.
that?
Page 30.
Who is for the respondents?
Lord, I have sought,
Microphone.
state is the respondent. All
Yes.
respect. Your lordship, kindly have a look, page
for the state.
27.
What is the prayer?
Prayer, my lord. Now, your lordship, kindly have a look, page 27, I am coming.
What is the prayer? First, the court's question.
Prayer, my lord, to change the beneficiary's name from Gitanjali scheme to Bangla Abhas Yojana scheme, because both schemes are same. Now, no fund has been allotted by the state to the Gitanjali schemes
Yes.
of the beneficiaries. Now, government, my lord, introduce a new scheme under the name and style Bangla Abhas Yojana. Both the schemes, quantum of funds are same and eligibility criteria are same. And these petitioners, my lord, found eligible earlier for the scheme of Gitanjali. And my lord, the district magistrate concerned give an undertaking on a contempt proceedings, my lord, that when the fund will be available, the fund will be supplied.
No, but this is a different scheme. If you were eligible under Gitanjali, how can you say you're also eligible under what is Bangla Abhas Yojana?
Because, my lord, there is an undertaking given by the concerned district magistrate, as well as the aim and goal of both the schemes are same. And eligibility criteria are also same.
The district magistrate has said that.
Yes.
Where?
In contempt proceedings, my lord.
Contempt.
In the contempt proceedings.
Then why have you filed the writ petition?
Earlier writ petition.
What is the present writ petition about?
Present is nothing, my lord. Present is the first time appearing, my lord.
What do you mean by first time appearing? What is the relief you have claimed?
Pardon, my lord?
Yes, what do you have to say? I'm going to dismiss it with costs.
No, no,
Yes.
madam. Kindly
I'm going to
consider-
dismiss it with costs. What do you have to say?
Kindly consider, my lord.
No. What do you have to say?
My lord, they were eligible under the Gitanjali scheme. Now, this is a new scheme. This is a new scheme. A decision has not been made on whether they are eligible or not under the new scheme. So how can they ask for funds to be released under the new scheme when they
And
themselves?
what is the contempt which is pending?
Contempt not pending, no. Contempt disposed of. Contempt disposed of.
Just now you referred to a contempt
lord, that
proceeding.
was-
Earlier writ petition contempt proceedings was filed against the district magistrate concerned, and my lord, that contempt proceedings disposed of. Kindly have a look at the order passed by the
Then what is the case for your? There is no case. It's a different scheme. How can you say that they will extend the benefit
because
of
my
that
lord,
scheme?
my
Is there no? Is there an eligibility? Is there a different set of eligibility criteria in this new scheme?
No.
My lord, I'll have to take instructions
No,
on
no,
that.
no. As per
But
sufficient, no.
I have to be honest. I already asked the block development officer Manichak, who's responsible for this, for instructions 3 weeks back, and I've asked multiple times on the same eligibility criteria. They're not bothering to get back. So
Very well. Then costs on both of you.
my kindly
On Wednesday, 19th.
My lord, if I may, kindly could you direct the block development officer Manichak to personally appear and file a report?
Absolutely not. You not on your asking. You don't know how to address the court.
No,
Is the BDO a party to the writ petition? Very well. You first answer the court's question. Yes.
My lord, I'll come back with instructions.
If you are inefficient and you are incompetent to get the instructions, you want the court to take the cudgels on your behalf. Yes. The writ petition, it is arguable whether the writ petitioner has a case at all, whether the writ petitioners have a case at all before the court, since the benefit now sought for is under a totally different scheme. Stop. The writ petitioners claim to have been eligible under
Gitanjali scheme.
the Gitanjali scheme and now pray for a direction on the state respondents to extend the benefit under the Bangla Abhas Yojana scheme. Pray B. Stop. Learned counsel appearing for the state does not have any instructions in the matter and submits that the concerned block development officer / respondent number
6
6
Seven, my lord. Respondent number 7, money check.
Being respondent number 7 has not given any, has not got back with any instructions. Stop. How many petitioners are here?
My lord, there is, my lord,
Court fees paid?
31, no.
Court fees paid? No. Yes, list this matter on 20th April 2023. Court fees to be paid by 4 p.m. tomorrow.
My matter will appear. Wait for me.
Next.
Item number 9.
Your Lordship, Mr. Your Lordship, Mr. Biswajit Sarkar, on behalf of the petitioner, is not keeping well, Your Lordship. So we are seeking for a week's time, Your Lordship.
Yes, adjourn.
Can you see the last order? Can you see the last order?
Okay. Yes, the petitioner was unrepresented on several occasions, including the last time, i.e. 13/4/2023. Stop. The order recorded on that date states that the petitioner is yet to file the affidavit in reply. Stop. List this matter tomorrow as a last chance to the petitioner. Yes, now with sufficient warning that the court will proceed to dismiss the writ petition tomorrow. Next.
Item number 10.
Lord, I appear for the response.
What has happened to you, Mr. Bhattacharya?
I had a haircut, someone.
Very well. Yes.
Nothing has happened.
Yes. Yes.
Kindly do not hear the petition from the point of view of any adversarial litigation part or any public. We are.
Is the writ petition maintainable?
Yes.
It is maintainable.
100%. The petitioners here are 11 in number suffering from muscular dystrophy.
How do you know that the writ petition is maintainable, Mr. Bhattacharya?
Because, we are saying that, the government of India has promulgated a scheme, for the benefit of all these patients.
Yes.
All these persons who are suffering. Now.
From muscular dystrophy.
Yes. Admittedly, they are suffering, the certificates, everything are on record.
Yes.
Now, the scheme envisages, a center of excellence, to be the IPGMER here. It also envisages, a one-time grant of 5 crores to be given to the IPGMER for setting up of modalities for treatment of these patients suffering from this particular, very rare disease, if I may say so.
No, that rare disease is what?
DMD. Muscular dystrophy, there is a French term or some term, Duchenne, muscular dystrophy. Now, we are saying that because of the, this exchange of n number of correspondences between the state and the center, ultimately, what is happening is, these persons have a maximum outer limit, to live in this heavenly world, for 20 years.
In this what world?
In this world. They have their lifespan for these sort of patients is maximum 20 years in India. Maximum.
Why do you say 20 years in India?
Because in abroad, because of some better treatment, they may at times may not live beyond 20 and may not live even till at times may not till 40.
Yes.
Now, here, we are really suffering, all these parents, they are suffering because, this center of excellence, which is the only center in this eastern part of India, this has no practical infrastructure despite the central scheme existing, to cater to the needs and requirements of these patients suffering from DMD.
So if IPG-MER does not set up this center of excellence, then what happens to these people? Are you
these
saying that
people are helpless?
No. Are you saying that there is no other hospital giving?
No. For this sort of specified treatment,
No, but
because
muscular dystrophy does not have any
because,
treatment.
it is an expensive treatment. It envisages, initially the scheme envisaged 20 lakhs as a one-time, grant for the patients. Thereafter,
So you want the money?
No, money is an ancillary thing.
Then
I
what-
want treatment. Treatment.
But Mr. Bhattacharya, even if I am with you on this, setting up a center of excellence will take at least 5 to 6 years. Modest estimate. Then how?
Center of excellence, is it is not that it is not, it is functioning. What I personally think, all of us who are appearing on either sides, center, state, an all-out measure, in the light of, in the presence of my lord,
And it is
should
not
be
it is not a PIL.
It is not.
Why?
Why? Because I'll show your lordship from the documents and papers. Because there is a PIL at the instance of an association, of which the petitioner numbers 1, the father, Yuvan Singh's father, is happening to be the president, and that is a completely different analogy. The subject matter of the appeal is to find out the number of patients, the list of patients who are suffering from this very rare disease. Very rare disease. And there are the central scheme. I am not against anyone. Today, I only want, that the scheme in its letter and spirit, it should be extended to the benefit of these patients who are really suffering. What is happening, I'm telling your lordship,
Suffering.
Suffering in the sense.
How many petitioners before me?
As of now, 11.
11. So then, why is it not a PIL, Mr.? What is the relationship between these 11 people?
11 persons are seeking, extension of benefits arising out of the scheme, contemplated and conceived by the central government.
Then why have you not filed 11 writ petitions?
All these persons stand on the same footing. They are all equally suffering. Equally suffering. 11 petitions, these are all, I completely agree
Mr.
with you.
Bhattacharya, it is different from 11 students who have appeared for an examination, filing a writ petition to the court in a 226 court, saying that you please direct the whichever authority to publish our results within a certain time period. This is different.
I answer your lordship in my most humble way, in order to maintain a writ petition, one has to have a legal right and a corresponding legal obligation, which is cast.
There is no question that you have a right to file a writ petition. Whether 11 of you can group together and file one writ petition, that is the question.
The 11 of us, are suffering from the same rare disease, and we are all equally complaining that, the state has, the center has, the last annexure, if your lordship sees, recorded all our names and has written to the state that please do something about these persons. These persons require treatment in terms of our scheme.
So very well. You want the 11 lakhs. How much money do you want?
The money part is not important. What is important is, the treatment part. We are made to stand. These kids, this 7-year, 5-year, 8-year-old, and this is the disease is ordinarily suffered by a male child. Is ordinarily suffered by a male child. It is on record. I mean, the research has shown it. It's a genetic disease. It's a disease, and a very rare disease, where these muscles do not develop. They can't hold a pen. They are otherwise very intelligent, maybe.
And apart from IPGMER, there is
No other center in Eastern India. Delhi High Court has come to the rescue of one person. One person's name has been uploaded in the system so as to enable him.
Mr. Bhattacharya, I'm aware of that order, but in that case, there was only one petitioner who,
Yes,
who had come before
yes,
the Delhi High Court.
Undoubtedly. My lord, I will be only requesting your lordship, my lord, to kindly not look at it from, my lord, the point of view that we are against anyone, or we are, my lord, we want that, my lord, certain mechanisms to be developed by the Center of Excellence.
Yes, so who will do that? Who is the respondent?
State. My lord, just to show you, just to assist your lordship, my lord, just to assist your lordship, I need to show your lordship certain pages. My lord, if I may permit it. My lord, please come to the.
Show me the prayer, please, first.
Prayer. To register the names of the petitioners with the rare disease portal, that is digital portal for crowdfunding and voluntary donations for patients of rare disease, and further directing them to provide the appropriate treatment by arrangement of gene therapy, anti-oligonucleotide, or any other appropriate drugs to be provided to the children petitioners to save their lives and to enhance their quality of life.
Where is the French name?
No.
The Busain something?
Yes.
That is the name of the disease.
Yes.
Where is it?
My lord, please see one of the documents, page 65. My lord, this is the government institute. My lord, saying this is to certify that Ernest Shaw, date of birth such and such, son of such, has been diagnosed as Duchenne, or my lord, Duchenne muscular dystrophy. DMD for short. And the recommended therapy for the disease is this. Now, please see.
Very well. What is the prayer? You want them to set up a center of excellence?
Yes.
That is a long-term matter. What is the short term?
It is. Please, kindly do not, kindly, bears with me for 2-3 minutes.
Yes.
Page 151, please come.
Yes.
This is the National Policy for Rare Disease 2021. It begins at page 149.
Yes.
Now, please see 151. Ministry of Health and Family Welfare formulated a national policy for treatment of rare disease in July 17. Implementation of the policy, however, faced certain challenges. A limiting factor in its implementation was bringing states on board and lack of clarity on how much government should support in terms of the tertiary care. Public health and hospitals is primarily a state subject. Stakeholders' consultation with the state governments at the draft stage of formulation of this policy could not be done in an elaborate manner. When the policy was shared with the state governments, issues such as cost effectiveness of interventions for rare disease vis-a-vis other health priorities, the sharing of expenditure between state and central and state governments, flexibility to state governments to accept the policy or change it according to the situation were raised by some of the state governments.
Mr. Bhattacharya, are you getting the treatment now or not? Or are you not getting any treatment at all?
Technically, I am not getting any treatment. The pleadings.
What do you mean by technically?
Yes. Pleadings, kindly cease.
Mr. Bhattacharya, please don't place pleadings. Answer the court's question.
Certain tests like DXA scan was recommended. There is no infrastructure in COE. In the Center of Excellence.
There is already a Center of Excellence.
Yes, it is operating in terms of this scheme.
Very well. So what is the complaint?
The complaint is, they are recommending certain tests.
Yes.
Before uploading the names, in the portal, certain internal assessment has to be made so as to enable these persons to figure, these names to figure in the portal, so as to, ensure the benefits arising out of the said scheme. 1, 2 is, crowdfunding, which is a separate thing, but both are also a part of the scheme.
So your names have not been registered on the portal as
in the portal,
because you have not been found to be eligible for that.
No, because of the lack of infrastructure in enabling them to detect that I am suitable for this.
Has any name been registered on the portal?
Only one, the Delhi High Court, that boy. That only the person who approached the Honorable Delhi High Court.
Why will the Delhi High Court, because you're saying the eastern region?
Eastern region, but Delhi High Court's judgment, he somehow, roped in the jurisdiction of the Honorable Delhi High Court, citing maybe central government's, health department. But, Delhi High Court's order has been given effect to, and only one name in the country is figuring, one name insofar as Eastern India is figuring in the portal. And they say, orally, nothing in writing.
What is the interim relief you want?
Interim relief is, to set up certain mechanisms so as to ensure, what is happening, the persons go, they are said, stand in a queue. These boys, they need wheelchair. They are unable to stand for long. They have muscular, these are medical things, which I also do not.
So then you can't ask for a vague interim relief.
No,
when
I
you
am
say
saying
certain mechanisms, what is certain mechanisms?
Certain mechanisms in the sense, that they should have the mechanisms envisaged in the central scheme. The central scheme says that 5 crore grant has been made over to create that infrastructure, to create the machines, to purchase machines, to purchase these machines for conducting relevant tests. These tests are not done in the open market. It cannot be done in the open market because of the rarity of the disease.
Mr. Mukherjee, you look absolutely flabbergasted. What is your response to it? Yes, microphone, please.
According to the directions of the central government, Center of Excellence IPGMR, and kindly see medical board has been constituted. Kindly see that a report of the board. 9 doctors has been selected as members of the board.
When was this done?
Done at IPGMR. Institute of Postgraduate Medical
There's no point in asking you a question because you will always answer something else. Yes.
But as soon as the central government release the fund, 50 lakhs is necessary for 3 months treatment.
Have you got the 15 lakhs?
No, but only some, only received out of 135 cases detected. But
how much have you received? How much money have you got?
But only for 5 cases we have received.
Sorry?
5 cases have been. But the last line, can you see? Detailed clinical evaluation and planning of the relevant investigation are regularly performed for all the registered cases every week from 9 a.m. to 2 p.m. So far,
where are you reading from? I can't hear you. Microphone, please.
But kindly see the report of the committee. A detailed clinical evaluation and planning. Last sentence, last one paragraph. A detailed clinical evaluation and planning of the relevant investigation are regularly being performed for all the registered cases every week from 9 a.m. to 2 p.m. So far, 196 applicants from the parents of the children suffering from various rare diseases have been received at Center of Excellence in Kolkata. Out of 135 cases already been evaluated at multidisciplinary board of 35 have been uploaded in the.
Yes. So what do you propose?
For as soon as the central government release the fund, we will go on with the.
I'm asking you, how much have you got?
Only 3 persons, about 1 point something crores has been received from the central government. Central government as
1 point something crores.
1.5 something.
Out of how much? How much are you supposed to get?
Kindly see 50 lakhs per patient. 135 total cases have been informed.
Where does it say 50 lakhs per patient? Where does it say that?
That is at page 190.
190.
What Milord? I'll answer.
Please, Mr. Bhattacharya,
I'm
wait.
sorry.
190. And a similar matter is pending before the court number 1.
Similar matter, PIL.
Yes, public interest litigation.
Yes. So what is the prayer in that?
That the committee may be constituted, a board may be constituted, and the free treatment should be given to them. And we have been asked to file an affidavit. We have ready with the affidavit, and matter is appearing today also in the list. Item number 15.
Petitioner is part of that group.
Yeah. Yes.
No.
Yes.
Yes. Petitioner father in the public interest litigation.
Very well.
Petition
Yes,
number
Mr. Chakraborty.
On the last occasion, kindly
Microphone, please.
kindly remember on the last occasion, they submitted and handed over a copy. And if your lordship kindly produces, possibly it is before your lordship the order dated 20th March 2023 of the division bench.
Yes.
My lord, my learned friend, Mr. Bhattacharya did not submit that the identical matter. This is muscular dystrophy for the appropriate action at the end of the state authorities. The identical matter is pending. This is item number 15. The other matter is there, Poribar, Bengal and another. Therefore, my lord, this has to be adjudicated on a public interest litigation on the question. Secondly, it is his prayer that their cases are not registered in the portal. If under the scheme it is not registered in the portal, they are not entitled to any benefit. Thirdly, the petitioners have joined together, but petitioner number 1 has made a representation. That is pending.
Mr. Chakraborty, microphone, please.
Yes. The
Yes.
petitioner number have joined together, but the petitioner number 1's representation is pending. And that is his cause of action. The representation is not being considered. The only representation that I have made. Kindly come once in the list to page 181.
Yes,
This para 3, has your lordship got it? Para 3.
yes.
The procedure for release of funds. The procedure to be followed is proposed as under. Application for financial assistance shall be submitted in the prescribed pro forma by the patient or parents of the patients or guardians of the patients to the COE where she approached for the treatment. The pro forma should be duly signed by the treating doctor of COE. A rare disease committee to be constituted in each COE. The nodal officer for rare disease of the COE will be the member secretary of the committee. COE may also
Mr.
for an
Chakraborty,
outside
this part, I
expert.
don't know how it's relevant. Where is that part
unless
that
these are constituted, these committees are constituted.
so that has already been done?
No, this is possibly, this is his case. He's neither registered in the portal nor the committees has been
Show me that part, that if you are not registered, then you don't have a relief. Please, show me that part.
portal. No, I am showing to you portal.
That is what is relevant to your submission.
That is his prayer, my lord, in the prayer A.
Show me the part of the scheme, please.
No, portal registration. My lord, this is actually, may I just press your lordship before this? Portal ta kotha? My lord, page 170. I'm grateful to my land friend. Page 179.
Both of you are on the same page.
Yes.
Both of you.
No, page 179.
Relying on the PIL, both of you.
Yes, because the
So
identical
178, which part? Which part?
financial assistance, maximum financial assistance admissible under the scheme will be up to rupees 50 lakh per patient. The financial assistance per patient will be given to the concerned COE while the patient is getting treatment, admitted for treatment. The financial assistance shall not be given to the patient directly. My respectful submission is that it is too premature application. They have neither been registered.
Mr. Chakraborty, show me the part that if your name is not registered on the portal, you are not entitled to any other benefits. Show me that part, please.
No, I'm sorry, that part.
If you make a submission, it must be backed up by something on record.
Department is only for the financial assistance.
No,
I'm
this
giving the matter. Yes.
Portal registration is required for the financial
Very
assistance.
well. I'm keeping the matter tomorrow. Please get ready, Mr. Chakraborty.
But
Tomorrow,
I-
come back. Come back and show me the scheme where you're relying upon. That because that is what the petitioner's case, I presume, that 11 of their names have not featured on the portal. So if that is the case, then they cannot come to the court to ask for any other reliefs. Show me this on the scheme.
May I just draw your lordship's very kind attention to page 306.
Mr. Bhattacharya, go back to the division bench.
No,
And kindly allow us to place the order.
I don't know why you can't wait for the division bench to decide.
Because division bench, the matter is completely different. It's not on a different pedestal altogether. Here, we are questioning certain, my learned friends have said a lot of things. Please see the policy decisions envisaged in the scheme. It says that
Show me the prayers in the PIL, please.
Yes. Before that, if I may show your lordship only one thing, 169 kindly comes to 169 for a
Wait.
moment. I'm sorry. Copy দাও।
তোমাকে নিয়ে রাপিয়ার করা কখনো হবে না আমার দ্বারা। What is? ভোটার রেজিস্ট্রেশন না হলে টাকা পাবে না, সেটা কোথায় দেখে 1000 বার বললাম, দেখে বের করে রাখতে। ভোটার রেজিস্ট্রেশন না হলে টাকা পাবে না, কোথায় বলা আছে? কোথায় বলা আছে? কোথায় বলা আছে? তুমি বারবার বকছো। কোথায় ভোটার রেজিস্ট্রেশন? কথাটা টার্মটা ইউজ করুন, ভোটার না অ্যাপ্লিকেশন যেটা হবে
Mr. Bhattacharya, PIL.
May I?
The question is not whether the prayers are identical. They need not be. The question is, if you get a relief in the PIL, will you continue with the present writ petition?
I will. I
No, you will
show
not.
your lordship, page 169 for a moment.
কতগুলো পেশেন্ট কনসিডার হচ্ছে?
Yes.
168 conceived centers of excellence, 169, 9.3. The proposed COEs shall be given one-time financial support up to a ceiling of ₹5 crore for procurement of equipment as per individual centers' need, for strengthening patient care services, for screening, diagnosis and prevention of rare disease based on a gap analysis. The list of equipment which are likely
What is the point?
the point is, this grant has come, or the state has to write to the center for this 5 crore, or at least a ceiling of 5 crore for procuring machines. The treatment is not taking place of these individual patients. The pills issue is different.
Mr. Bhattacharya, the treatment will take place only after your name features on the portal. Not everyone will come, not everyone will be benefited.
This correspondences only are being exchanged by the center and the state, and ultimately, who is at the receiving end is these helpless victims of this rare disease. They are not getting this.
So don't make all these vague submissions, Mr. Bhattacharya.
May I make only one submission?
Yes.
My lord, if your lordship kindly looks to the order of the division bench, my learned junior is appearing in the division bench matter also. The entire Eastern Zone patient's case is being considered by the division bench on muscular dystrophy. My learned friend is completely misleading, and he submitted that the petition number one's father is the president of that association.
And I said,
Yes.
I told you, Lordship.
So why is he saying it's not similar?
Mr. Chakraborty,
There's no question of misleading.
Mr. Chakraborty, please. Every council has a right to make submissions his or her own way. The court will decide whether the council is trying to mislead or not.
Oh.
Yes.
Kindly, tag this matter with the bill. Then
What tag?
Then this matter should be heard along with the bill.
Why?
Kindly do not dismiss the matter.
I will just give you liberty. I'm disposing of the matter. The matter will not be in my list. I will give you liberty to take your prayers in the existing PIL. That's all. I don't know why you don't have faith.
There's no question of not having faith.
In the
I wanted, what I wanted, I'm telling your lordship. A judicial mechanism so that, these boys who really do not have very much left, so that they get something maybe out of nothing. This crowd fund, everything, this fund, 50 lakhs will not come directly to their parents. It will be sent to the department for catering to these sort of patients.
You want crowdfunding?
No.
For the diseases?
I want treatment, not anything else apart from treatment. Again, I repeat, Milord.
Very well. Mr. Chakraborty, tomorrow you show me the scheme that if a person's name is not registered on the portal, nothing further remains. Only that part. All right?
And
Yes.
kindly allow us to place the division bench latest order if it is passed on item 15.
There's an order after 20th March.
Yes, today it is appearing as item number 15.
Today,
in the
very
list of the
well.
honorable acting chief.
Yes, the learned ASG appearing for the Union of India, as well as learned counsel appearing for the state, submit that the division bench presided over by the acting chief justice of this court is considering a public interest litigation involving substantially the same relief. Stop. council submits that the father of the petitioner before this court, the father of the first petitioner before this court is the, what did you say, chairman?
President of the association.
What association?
That is Muscular Dystrophy Patient Welfare Society and another. That is
Is the president of the Muscular Dystrophy
Patient Welfare Society and another.
Patients Welfare Society and is a party in the PIL. Stop. Next, list this matter on day after tomorrow, 19th April 2023.
Lord, would it be Lordship's pleasure to place it on any other day?
Tomorrow?
Wednesday? Tomorrow, yes.
Tomorrow. List this matter tomorrow, i.e. 18th April 2023 for the learned ASG as well as learned counsel appearing for the petitioners to inform the court of the PIL. Stop. The relevant part of the scheme shall also be shown to explain whether the petitioners have to explain whether the writ petition is maintainable or not. Stop.
We shall produce a copy of the writ petition filed therein and the latest order.
Very well. Next.
Item number 11.
That I appear for the petitioner.
I was for the union. I am for the union, Manot, and the SFIU, Manot. May I have Manot's kind leave to file the affidavits, Manot.
Yes.
And Manot, I will be paying Manot for some accommodation, Manot. But I need to go through the
You have filed the reply, Mr.
Yes,
Treasurer?
yes, I have filed that.
What is this matter about?
Lordship would recall, my lord, the writ petition was challenging the lookout circular. My lord, at the ad interim stage, my lord, Lordship was pleased not to grant an ad interim order because, my lord, the bank had submitted that CBI is also investigating the matter.
Yes.
Later, of course, that instruction was found to be incorrect and the learned advocate, my lord, immediately thereafter came and informed the court. But,
Yes.
my lord, at present, my lord, I don't have any interim order. Now the
SFIO, my lord, which is actually
now the affidavits are complete. The SFIO, the Serious Fraud Investigation Department, also, my lord, they have said in their affidavit.
we have used two affidavits, my lord. One on behalf of the Bureau of Investigation, Immigration, my lord, which is a standard affidavit, and the other one, my lord, is by
So,
the.
my lord, it is
SFIO.
really whether it is in compliance with that or not. So, my
Very
lord,
well. So SFIO proceedings are pending.
SFIO only investigation, my lord. This is happening since 2020, and I have myself disclosed it in the
Very Chaudhary, if Mr. Bhattacharya does not want to do you want to do the matter today?
Yes, yes. My lord, only thing is I am not enjoying any interim order, my lord. He was supposed to go for business
Tomorrow,
purpose.
Mr. Bhattacharya,
Tomorrow,
day
day
after?
after, any
Day
Day
after,
after?
tomorrow.
Day after?
Day after.
Very well. List this matter. The learned DSG appearing for the Union of India seeks an adjournment. Stop. List this matter on 19th April 2023 as prayed for.
And I have filed, my lord, the two affidavits.
Affidavits are opposition and reply.
The affidavits in opposition and reply are taken on record.
Lordship.
Grateful.
Mr. Bhattacharya, give your learned friend a chair to sit, please.
No, there is a chair.
There is a chair? Yes, very good. Yes.
Item number 12.
My lord, in item number 12, kindly permit me to appear through online, my lord.
Who is this?
My lord, I am Debashish Shah, my lord, I am appearing on behalf of the bank, respondent bank in this matter.
Lordship,
Yes.
actually, Lordship, whatever Lordship last occasion asked me to argue on the point of maintainability. My junior state me that there is some documents which is relevant for argument of maintainability. He wants to rely the same through a supplementary affidavit. Lordship, he has prepared that, but he does not affirm, Lordship. Would your Lordship kindly allow me to sometimes, Lordship?
Yes, yes. When do you want to come back? Mr.
Next
Paul?
week, Lordship, next Monday, Lordship.
Very well.
Actually, I have not seen that supplementary
Yes,
affidavit
yes.
also.
Learned counsel appearing for the petitioner seeks to file a supplementary affidavit on the point of maintainability. Stop, list this matter on 24th,
Lordship.
24th April 2023 as prayed for.
Much obliged.
And please give a copy to your learned
Lordship,
friend.
Lordship, proud.
Deeply obliged.
Grateful to.
Item number 13,
Please, your lord. I am being led by Mr. Shaktinath Mukherjee and Mr. Shoptangsu Basu. Short points to the Judge Sahib,
Mr. Mukherjee will appear online.
supposed to be online. Yes, Mr. Mukherjee is there.
Very well, you start, Mr. Bhattacharya, please.
Lord, we are looking at an order. This is in connection with a hotel in Kolaghat. Lord, the allegations raised by the private respondent number 7, were before the tribunal, before the National Green Tribunal, my lord, Kolkata bench. My lord, first submission to your lordship is that the writ petition at the instance of the petitioners here is maintainable, my lord, in view of a Supreme Court judgment.
Are you not enjoying an order?
We are enjoying an interim order, my lord. The interim order is still 30th April 2023. And my lord, the affidavits insofar as.
And that was an order staying demolition.
Yes, my lord, kindly sees, if your lordship wants, my lord, the interim order made by this honorable court on 12th of April 2022. My lord, the submission is recorded. My lord, our principal point is, my lord, this hotel is functioning since 2013. The first complaint is beyond, my lord, this period specified in the NGT Act to maintain a complaint. My lord, there's a limit, there's a time limit prescribed, and my lord, that time limit has been given a complete go by. Allegations have been made regarding violation of coastal zone management regulations, and it has been contended that there was violation of CZ, coastal zone regulations, CRZ regulations, I'm sorry, CRZ regulations. Lord,
R stands for?
Coastal regulation zone.
Regulations, yes.
Now, this CRZ regulations, my lord, they alleged violation.
Yes, Mr. Basu.
Mr. Basu is.
One note I have prepared, my lord, one note, one page note I have prepared.
Micro.
Yes.
This is a one page note for my lord. Mr. Mukherjee will arguing, but there will be a gap. But this one page note.
Mr. Mukherjee, I can't see him on the screen.
Yes, he is on screen. Audio is off.
I believe now your lordship can hear me.
Yes, Mr. Mukherjee.
Lord, kindly turn to page 61, my lord, to just appreciate the magnitude of the problem. Page 61.
Sound ke badate bolo. Yes.
My lord, on the last occasion also, this is a page, my lord, in which there are several photographs. Can you turn to the bottom right-hand corner?
Mr. I can't hear you.
My lord, your lordship will kindly turn to the page 61.
সামনেই আছে মাইক তো নয় এটাই আছে
Mr. Basu, I'm not audible.
একটুখানি বাড়াতে হবে ভলিউমটা আপনার
Yes.
Lord, kindly turn to page 61, my lord.
Yes.
On the right-hand corner, bottom, there is a photograph. This is a photograph of the hotel involved in, before your lordship. Hotel Sonar Bangla. The order has directed the district magistrate to demolish the offensive part of this hotel. Why this offensive? Your lordship will kindly turn to the order under challenge. Your lordship will find, my lord, what is the offense I have committed. That order is annexed to the brief, but I was suggesting for lordship's kind consideration, we have supplied a separate copy of the order. That will be more convenient. It does not bear the stamp of the
Our petition slightly illegible. Not your lordship may take the order.
No. There is another copy we have supplied to the last occasion, to your lordship.
ঠিক আছে দুটো যে কোনো একটা হলেই হবে
Yes.
My lord, kindly turn to that order, my lord. This is on the basis of an original application filed by a gentleman from Noida. The complaint is about the hotel in Howrah. The
Page?
complaint is, my lord, page 9 of that.
Page 2.
Yes.
Mr. Bhattacharya, kindly find out the page.
Yes.
May I read out the order, my lord, some portion? May I read out for your lordship?
Yes, Mr. Mukherjee, but not limited portions, please. Yes.
Kindly first to paragraph 2.
Yes.
The original application has been filed by the applicant's allegation.
Mr. Basu, why don't you give me the paragraphs of the order? I
Paragraph
will read
2.
it.
paragraph 2 is the
Very well, because I can't hear Mr. Mukherjee at all. Yes, paragraph 2 and
Paragraph 2, my lord, then, my lord, kindly turn to paragraph 5.
yes,
Kindly compare these two paragraphs. Paragraph 2 indicates that this is on the basis of an original application. And the original application contained the complaint that this is in violation of the coastal zone regulation. Paragraph 2.
paragraph 2 is the application, the grievance, and paragraph 5 is the answer which has been given by the answering respondent therein.
very well. And you were the respondent.
I am the respondent. This is not my affidavit. This is answering respect government affidavit, which says it is
Coastal zone
not
management.
coming.
No, respond number 6 is who? The coastal zone management.
Management
Authority of West Bengal.
This is offending
Coastal
the coastal
Zone
zone
Authority of
regulation.
West Bengal.
They say it is not coming.
Very well. Yes, what is the point now, please?
Kindly take the
In spite of this statement by the Coastal Zone Authority, the Green Tribunal has directed the demolition of a portion of my hotel. Only if it offends the Coastal Zone Authority regulation. Complaint was that it offends, and the authority coming and submitting on affidavit before the tribunal that the Coastal Zone regulation do not apply to this area. There is no ambiguity about it. Your lordship, you can have a look at the affidavit also.
So the finding is that it is 30 kilometers upstream
yes
from the coastal zone regulation,
far away.
Yes.
far away. But wasn't a submission made on the last occasion that because of that Amphan,
That is another. That is
No,
another.
that is another aspect of the matter, my lord, because the boundary is shifting.
This is not Kolaghat.
What? It is in Kolaghat, my lord, because of Amphan and other catastrophe, the boundary is shifting. We can't maintain the boundary.
ছোট করে দিই আমরা।
My lord,
Yes.
there is another aspect, my lord, kindly turn.
you are not enjoying any interim order in this matter?
Yes, yes.
You are.
Yes, enjoying it. Enjoying.
Yes.
Complainant is not here.
Huh?
Complainant is not appearing. Last occasion they also not appear.
My lord, there is another aspect of the
The
matter.
interim order is till which date?
30th April. Kindly make it absolute.
No, I will not make it absolute before the complainant is given one more chance. And then, yes, complainant is respond number
My lord, he says one.
7. And how is the complainant related to this matter?
No, he is nobody.
He's in Noida.
He is
And
captured
the same.
because of the public. as you have stated.
And the
Saying that,
property is in,
That is offending CRZ.
yes, saying that the hotel is right on the river.
Right on the river, so it is offending CRZ. That is his allegation in the main writ petition.
affidavit বলেছে ওর
And-
occupation business.
His occupation is business, so he's a busybody. That is apart from that, when he has filed an application that is beyond the period of limitation, that your lordship find in the note, one page note we have prepared, my lord, that will suffice the entire matter.
Very well. Yes, Mr. Mukherjee, I am keeping the matter. The interim order is till 30th. So I am keeping the matter.
after the vacation, my lord, beyond 30th will take us to May. And from 19th of May, either before, twice they didn't appear.
Very well. The petitioner, the petitioners are protected by an interim order passed by this court on 21/3/2023. Stop the interim order. No, the petitioners continue to remain protected by an interim order dated 7th April 2022, which was extended on 21/3/2023 by this court. Stop. The interim order is till 30th April 2023. Stop. The private respondent is not represented. Stop. As a last chance to the respondent number 7/private respondent to argue its case before the court, his case before the court, comma, list this matter on 24th April 2023. Stop. Next, learned counsel appearing for the petitioners is requested to communicate this order on the respondent number 7.
As you know.
By 18th April 2023.
In April.
Yes, next.
Get to lordship.
Thank you.
হ্যাঁ এরকমই তো আসছিল এইবারে ওটাও আসছিল এ বন্ধ হয়ে যাবে বন্ধ করে দিয়েছি
Pass over matter item number 5.
I will dictate the order at 2. All right. Yes. Call on the next matter, please.
Item number 14.
Lord, I have submitted my bullet. Mr. Dotto is for the petition. I have submitted my bullet points.
I can't understand, Mr. Vikhosh, what you are saying. Yes, microphone, please.
Milord, by an order of Milord, we had concluded the submissions by an order of 30th of March 2023. Lordship desire was, Milord, that I should put in my bullet points.
Yes.
So, Milord, on by 13th. So I gave to my Lord's court officer on 13th. Since I am without affidavit, I relied on Milord 8 Milord documents that have made a part of my note. If Lordship wants Milord to tear it off, Milord, I'll do that.
I can't understand what you said. Please speak clearly into the microphone.
Milord,
you have filed your bullet points.
yes, I have filed my bullet points. With Milord, the documents, Milord, the pollution control certificate, because that was given in a scattered way, I have given Milord, as well as the judgment, Milord.
No, but how do I know that has the petitioner
But those are there. Lordship can check it up from the file, Milord. Because, Milord, I am without an affidavit, Milord. It goes in a scattered manner. Except, Milord, the long plan.
Have you served these documents on the petitioner?
Yes, yes, I have.
Whatever you have
Time of
annexed with the note.
But
Have
written notes that we have not been favored with.
No, written notes are just the
These
documents have you
documents,
given?
yes, pollution control certificate, automatic renewal, I have given him at the time of hearing, Milord, which was going on. And the big Milord plan which had Lordship Milord said, since I am saying Milord, it's ECL road, Lordship is taking that as true and correct. That I have not annexed, Milord. Because Lordship, I haven't shown it to Lordship, Milord.
And what is this order which you have, this 28/6/2016? What is all this?
Milord, these are the judgments, Milord, on alternative remedy, refusal to bank guarantee.
No,
Milord.
this is this is an order of 28/6 of the West Bengal Pollution Control
Yes, that
Board.
I have shown your lordship, Milord, that pollution is automatic, renewal is automatic. As per the, Milord, the guideline that is in lordship's file, lordship can see that. It's going for it for quite a long time. It's pollution, Milord, he said 5 years. So, Milord, it's impossible to work. I gave, Milord, the regulation and, Milord, the certificate saying, Milord, the pollution is automatic. For the pollution, Milord, extended automatically. And I favored my learned friends junior with a copy also.
Milord, the document which my learned friend refers to as an automatic renewal, this is under a different statute altogether.
Very
That is
well,
under the
very well. Have you said that in your
yes,
points?
in my written notes of argument, Milord, I have said so. This, if your lordship may kindly take, Milord, page number, though nahi to kono. Milord, I'm so sorry, Milord, it's the 4th page of my written notes, point number 5. Or point number 4 in the previous page. At the bottom, where I'm so sorry, it's not paginated, the 3rd page, point number 4 at the bottom, this is what my learned friend has submitted. If required, extension can be granted to the writ petitioner to complete the work. To that, Milord, my response is on the next page. The clause for extension to time to complete the work has become redundant in view of the restrictions imposed by the Ministry of Environment, Forest and Climatic Changes in its letter of 1st of September 2022, which is page 530 of the writ petition. And the next one is point number 5. Environment clearance dated 19/3/2015 of MOEFCC does not restrict the project tenure to 5 years. This is what my learned friend has handed up. To that, Milord, my submission is
No, the document annexed to the writ petition is of 28/6/2016.
yes.
What is that? Where have you dealt with that? Very well, Mr. Ghosh,
Yes.
supply the copies, furnish copies which you have
May I
annexed to the
get
writ
his note
petition.
also? Because I don't
Yes,
know.
to the petitioner.
May I get his note also, Milord? I don't know, Milord, what is.
You cannot follow what the court is
I'm
telling you
giving
to
it
do,
here.
not the note. The documents which you have annexed to your note to the writ petitioner.
I'm giving it here.
What is this? You file a note with the documents, you have to cite them, you have to place them during arguments.
Lordship will kindly look at Lordship's file, Milord.
Yes,
These are all there, Milord.
there appears to be a controversy as to whether the documents annexed to the note of the respondent was placed during the course of submissions, was placed in the course of submissions. Stop. Next, the documents annexed to the note should hence be made over to the petitioner by 19th April 2023. List this matter on 20th April 2023.
Milord, I'm handing him here.
Next.
I'm grateful.
Grateful.
Milord, kindly record, Milord, I have submitted the bullet points today, Milord. Hand it over
Yes,
to
the note of the petitioner is taken on record.
Great.
Mr. Dotto, you do something. You file both your notes on the same day. Otherwise, one will get misplaced.
Well.
Last line, next.
Item number 15.
Lord, I appear for the state respondent. Lord, I have taken a preliminary objection of the maintainability of the writ petition on the ground of suppression. Milord, Milord, I had made my submission on the prior occasions, Milord. May I take my lord's 2 minutes of valuable time?
Yes. You want the writ petition to be dismissed?
My lord.
On the ground of suppression?
Suppression. Milord, since the matter was heard on quite some time, Milord, may I show the praise in the public interest litigation for once. 1 minute, Milord, my lord's valuable time I'll take.
Yes.
Milord, I have handed up, Milord, the public interest litigation being WPA P413 of 2022.
Yes.
The prayers have handed up. I will kindly turn to the second page. Prayer A, Milord, writ
issue a writ in the nature of mandamus commanding the respondent, their main agents, and assignees to forthwith or immediately prevent the respond number 4. It will be 5, my lord. 5 is the petitioner before your lordship, who was the private respondent number 5 before the public interest litigation, in the public interest litigation, from disposing biomedical waste in common dumping area, since it is in violation of biomedical waste management rules 2016 and guidelines. Prayer B, my lord, issue in the writ in the nature of mandamus commanding the respondents, their main agents, assignees to forthwith immediately inquire into the illegalities carried on by the respondent number 5 and 6 and stay the work order issued in favor of the respondent number 5. Prayer C, my lord, issue a writ in the nature of mandamus certiorari during the
And
respondent.
the petitioner is who before the court?
Petitioner before your lordship is the respondent number 5 in the public interest litigation.
Very
Lord, prayer C, my lord, their main agents and assignee immediately certify transmit before this honorable court all records and or documents in original pertaining to this case, so that conscionable justice may be done by staying the work order issued in favor of the respondent number 5 and carry on inquiry into the glaring illegalities. My lord, prayer D, my lord, issue a writ in the nature of prohibition, prohibiting the respondent number 5 to carry on reckless disposal of biomedical waste. My lord, thereafter, my lord will kindly turn the page, my lord, prayers for interim order. Prayer F, issue an interim order of injunction restraining the respondent number 5 from carrying on.
What does this mean, to carry on reckless disposal of biomedical? Do you want the waste to be disposed of or not?
No, my lord, the public interest litigation was filed alleging that the biomedical waste which is to be disposed of in a certain manner are not disposed of properly by the private respondent. So these prayers were made to stop the private respondent from carrying on the contract which was awarded to the public, to the writ petitioner before your lordship. Lord, in my humble submission, my lord, thereafter this public interest litigation was taken up on 29th of August. My lord, the Honorable Division Bench was pleased to direct state as well as the private respondent to file affidavits, their respective reports and affidavit. My lord. In the meantime, my lord, my lord, state has thought it fit to cancel the work order which was given in favor of the private respondent in the public interest litigation, that is the petitioner before your lordship. He approaches against the order of termination, my lord. He approaches this honorable court and gets an interim order of stay. That stay, my lord, we are suffering till date. My humble submission, my lord, before this honorable court is that, my lord, he ought to have disclosed it. He should not have.
I've got your point.
Yes.
So the PIL was filed by you against the petitioner, who is respondent number 5?
I am the state, my lord.
Very well. The respondent number 5 was the petitioner before this court?
Absolutely, my lord.
And affidavits were directed. And then during the course of the PIL, you terminated the contract?
Absolutely, my lord.
Petitioner came and filed a writ petition in this court and got a stay on the termination.
Absolutely.
That is what is
Absolutely. One line more, my lord. Lord, my senior friend said, because I do not want this court, my lords, your lordship, to go into the merits of the public interest litigation.
Yes.
My learned senior friend has submitted on the previous occasion, it is unfair on my part. In one hand, my lord, I am taking the court to the public interest litigation. On the other hand, I am not allowing, or I'm not wanting the court to go into the merits of the matter. Exactly my point, my lord. I do not want the writ court to go into the merits of the public interest litigation. What I am on is, my learned, the petitioner ought to have disclosed before the honorable single bench that yes, there is a public interest litigation, maybe not according to him, maybe it was not directly linked with this present writ petition.
So you're saying that the writ petition should be dismissed
Milord,
on the ground of suppression?
Milord, I have also placed a judgment of the Supreme Court which says, Milord, if you keep some cards in your pocket and disclose others, you're not your matter is not entitled to be Milord, decided on merits. the Honorable Red Court should not go into the merits of the matter if the petitioner has not suppressed certain facts.
Very well. So what have you relied on? That Chengalvaraya Naidu? What have you done? 1994.
Just a minute.
There's another one, Maya or something, Maya Shipping.
They have handed up. They couldn't like to. It is Dalip Singh, my lord.
I think he has referred to 2010
10
volume 2 Supreme Court cases 114.
But I have handed up to your lordship.
And the Supreme Court says that you can dismiss it. Dismiss the
Absolutely,
writ petition.
Para 7, may I read for your lordship, my lord?
Very well.
To your lordship, within- Patient.
Very well.
Your
Yes.
lordship has got it, me.
Yes, yes. Yes, Mr. Dotto.
My lord, I have filed a supplementary affidavit.
Also, my lord, one last 1 minute, my lord. Lord, there is a stay on a subsequent judgment of the subsequent order of the division bench in the public interest litigation, whereby the Honorable Division Bench was pleased to grant the state liberty, pleased to observe that the interim order has been passed by this court because the Honorable Division Bench's order was not shown to the court. Today, my lord, there is a stay on order dated 14th of September 2022. Nevertheless, my lord, the Supreme Court, Honorable Supreme Court has, my lord, held in its judgment that the single bench, my lord, your lordship need not, my lord, may I read it, my lord? The pendency of the Supreme Court case, SLP, as well as the division bench judgment that the 14th September order, my lord, should not be a factor while your lordship is considering the vacating application or vacating of interim order. Praise for vacating of interim order, my lord. I'm grateful, my lord.
Very well. Yes. Yes.
But I filed a supplementary affidavit. Please have a look to that, my lord. My lord, this supplementary affidavit, my lord, has a copy of the writ petition of the public interest litigation which my learned friend refers to. That is from page 33 onwards. But for the present, my lord, I don't trouble your lordship with that because my learned friend has placed that. But in the public interest litigation, my lord, an order was passed on 29th of August 2022, which your lordship will find, my lord, at page 72.
What is the status now? It's going on. The PIA.
pending, my lord.
Very well. Yes.
It's pending. Now, my lord, this is an order passed in the public interest litigation at page 72, 29th of August 2022. Now, please take, my lord, the second page of the order at page 73, running page, the paragraph, my lord, in the middle of that page.
Yes.
Learned counsel for the respondent number 5, that is my client, has raised a preliminary objection about the maintainability of the petition by submitting that earlier unsuccessful bidders had filed WPA, etc., by challenging the contract awarded to the respondent numbers 5 and 6, which were dismissed by this court. Having examined the present petition, we find that the scope of the present public interest litigation is different, and in the present PIL, mainly the issue, this is very important, mainly the issue relating to treatment and disposal of biomedical waste has been raised. In the earlier writ petition, number so-and-so unsuccessful bidder has challenged the tender process, whereas the issue raised in the present PIL is different. Learned counsel for the private respondent has referred to prayer clause C, but we find that prayer clause C has been made considering the larger issue relating to non-performance of the duty provided under the rules. Hence, the preliminary objection is rejected. Therefore, my lord, their lordships were pleased to consider my objection and specify that the PIL was relating to treatment and disposal.
And what is the earlier public interest litigation?
With the previous litigations were challenging the contract awarded in my favor.
Very well.
Now,
Yes,
my lord,
but this does not refer to the present writ petition.
which does not refer to the present petition, but in my very respectful submission, the PIL is on a different point, which the Honorable Division Bench notes at page 74 top. Now at page 74, my lord, towards the bottom, kindly take the last paragraph. Hence, the Respondent Pollution Control Board is directed to file the report in the form of affidavit in respect of the allegations made in the PIL as also performance of duties by the Pollution Control Board as prescribed in serial number 3 of the Schedule 3 of the rules. Now, my lord, in terms of this order, the Pollution Control Board files a report, which my lord will find at page 56. But assuming that PIL, my lord, has got some connection to this writ petition, please have a look to, my lord, the Pollution Control Board's report, which starts at page 56. The relevant portion, my lord, your lordship may kindly take, my lord, page 59, paragraph 6. This is where I'm working. Well, assuming for argument's sake that the PIL is related to the cause of action over here. Paragraph number 6 at the bottom.
Very well. Mr. Dotto, you come back at 2 or some other date, please.
And maybe come back at 2, my lord.
Well, whichever, whatever.
Yes, 2, I will be dictating an order which will take me about half an hour or 20 minutes. So
Well, please, then we have to accept tomorrow some other day. my lord.
yes, learned counsel appearing for the petitioner will continue with his submissions on 20th April 2023. Stop. Call on the next matter, please.
We are grateful, my lord.
Item number 16. Melody Night. Melody, item number 16, I beg to appear for the respondents, my lord, on, if your lordship kindly recollects, my lord, on the last occasion.
Yes, Chittaranjan Locomotive
My lord,
Works. Yes.
your lordship directed me to take instruction as to the hierarchy, my lord, of officers, my lord, that is required to be followed, my lord, in the matter of delisting the farm, my lord. What I if your lordship kindly recollects, my lord, I place before your lordship that both of us, my lord, are relying upon a vendor purchase agreement, my lord. And as per that agreement, my lord, the at page 169 of the writ petition.
Yes.
At page 169 of the writ petition, my lord, paragraph 6.4.6, my lord.
Yes.
It says, my lord, the PCEEs, that is the Principal Chief Electrical Engineer's approval will be taken for delisting of a farm.
Yes.
This is one, my lord. And next I beg to take your lordship to page 174 of my lord. That is paragraph.
Yes.
Paragraph 7.8, my lord. That says, my lord, the appeal can be made in case of delisting only and within 30 days of issue of letter for delisting whenever the vendor is not satisfied with the action taken, he may appeal to GM, who, after seeing the merit of the case, may decide or dispose of or refer the case to the committee consisting of PCEE, CLW, PFA, CLW, and PCMM, CLW. The committee gives their observation and recommendation. The committee will verify that the case has been dealt with as per the procedure, or otherwise the same will be put up to GM for disposal of the appeal. My lord, with all humility, I submit, my lord, what was the submission before your lordships by my learned senior friends was that it suffers from bias, my lord, since the...
No, 153. 153.
175, my lord, I place before lordship.
No, 153. Come, that was the one which was being placed. 153.
Yes, my lord. 153, my lord. I apologize. 153, that is what they, my learned senior friends placed before your lordship, that it suffers from bias. Since the PCs, it was taken the principal order, my lord, the principal order of delisting was passed with approval of the PCCE, and now in the appeal, in the hearing committee, in the matter of hearing the appeal, the PCC is part of the committee, my lord. With all humility, I submit, my lord, since we are bound by this agreement, my lord, and this is as per the petitioners, it is true to their knowledge as per they have stated in the affidavit. So, my lord, I humbly submit, my lord, it was within the knowledge of the petitioner farm, my lord, that it has to be delisting has to be done with the approval of the PCCE, and the PCCE will also be part of the hearing committee, my lord. This is my one limb of submission before your lordship.
And without a hearing, that is what you're saying?
No, my lord, hearing was given, my lord. Hearing was absolutely given, my lord. That was, they have not contradicted that also. My learned senior friends have not contradicted. Hearing was given. Only point, my lord, that they place, so for my understanding, they, my learned senior friends place before your lordship that the GM has made a one-line order, my lord, at page 153.
Yes.
That I agree with the recommendation of the committee, my lord. Now, my lord, I humbly submit before your lordship that the recent order, my lord, the hearing, my lord, the minutes of the hearing, my lord, that starts from page 153 to I apologize, 148 to 153, my lord, of the writ petition. That is absolutely an elaborate hearing was given to them. My lord, they were present, an elaborate hearing was given to them. That is one, my second point of submission. And my third point of submission, no, without notice it was done, and without notice it should not have been done without notice, but only, my lord, as I placed before your lordship on the last occasion, my lord, that the very purpose of giving a
No, you're
notice,
saying hearing was given, but what was done without notice?
the principal order, my lord, principal order of
Very well, but
delisting.
hearing was given, but the order was done without notice. What does
No,
that-
my
what
lord,
does
no
that mean?
hearing, the principal order, in the case of the principal order, no hearing was given.
No, you just said page 148 shows elaborate hearing.
Yes,
they
my
were
lord, that
present.
is the appeal, my lord. That is the appeal.
Yes, but the first order, you're saying that there was no hearing given.
No, my lord, no hearing was given, and notice was not given, my lord. It was incumbent on the part of this Chittaranjan locomotive work to have given a notice,
Very well.
my
So,
lord. But
what happens if the first order is vitiated? Then what happens to the others, the subsequent orders?
only, my lord, as we, I humbly leave it to your lordship, only as regards the point, as regards the first order, my lord, I have admittedly, my lord, that was done without notice, my lord. But what it appears from a conjoint reading in my
Very well. Miss
understanding,
Doctor, you want to come back after 2?
whenever your lordship directs, my lord.
So then you have to. It has to be after 2:30. All right. I
lord.
will just dictate one order.
My lord, as your lordship directs.
And how much time will you take? Another 5 to 10 minutes, not more than
Maximum,
that.
my lord.
5
not more-
minutes.
5 minutes, my lord.
Yes. 2:30 সময় রাখো এটা।
Deeply obliged, my lord. Item number 5.
The respondent bank has filed an application for vacating an order passed by this court on 29/3/2023 in a writ petition filed by the in the writ petition. Stop. By the order impugned, comma. The court had held that clause M, choto m within brackets, of the sanction memorandum, capitals, dated 16/3/2022, may be construed to mean a concessional rate of interest at 6.70% to apply for housing loans, for the housing loan sanctioned and disbursed within 31/3/2022, and the said rate would remain till the loan completes 3 years from the date of disbursement. Stop. Next, learned counsel appearing for the bank, respondent bank. / Canara Bank places the documents in the affidavit in opposition to submit that the relevant clause should have read as 0.20%, relevant clause M, of the terms and conditions of the sanction memorandum dated 16/3/2022 should have been read as 0.20% and not as 6.70%. Stop. Council also relies on on the rates of interest on the on rupee loans and advances -RLLR with WEF 12/2/2023 at 9.4%. Stop. What did you say? This repo lending?
Repo linked lending rate.
RLLR आगे लिख दो, repo linked lending rate within brackets RLLR, close brackets, page 27 of the AO. Stop. Council also places a notification dated 4/9/2019 issued by the Reserve Bank of India, which states inter alia that all new floating rates shall be benchmarked to one of the following, that is the Reserve Bank of India policy repo rate. Stop. One minute. Page 26, what did you rely on? Page
Of
26?
the affidavit in opposition, my lord?
Yes, yes.
Page 26, just a moment. 26 is the statement of accounts, my lord. And the next page is the current rate that he is paying, 9.40.
Very well. Yes. Next, it is evident that the petitioner's grievance for filing the writ petition is on the increase of the concessional rate of interest from 6.70% to 9.40%. Stop. This would be reflected from the prayers in the writ petition, which is for a writ of which is for a command on the respondent bank to deduct the monthly installments from the petitioner's account in the rate and in the manner as provided in the sanction memorandum dated 16/3/2022. Stop. Next. The sanction memorandum indicates that indicates on the first page that the RLLR rate was 6.90% and that the concessional rate was given as 0.20% as per circulars to the petitioner for the concerned housing loan. Stop. The said column clearly mentions that the interest rate is linked to RLLR, quotation marks. The interest rate is linked to RLLR, page 24. And that, quotation marks are pore, and that the RLLR and the actual lending rates are subject to review and variation from time to time as per RBI guidelines, and also subject to any changes in the financials of the borrower. Stop. The clause further provides that the changes in the RLLR and the actual lending rate will be notified in the notice board of the bank from time to time. Stop. This document, this clause should be read in tandem with clause choto m, where the concessional rate of interest of 6.70% was stated to remain till the loan completes 3 years from the date of disbursement. Stop. The concessional rate of interest was 6.70% as on 16/3/2022. The sanction memorandum cannot be seen in isolation and must be seen with the housing loan agreement, which clearly mentions in the annexure that the interest type would be quotation marks floating. এটা quotation marks এ হবে। Apart from this, comma, the notification of RBI dated 4/9/2019 also states in clause 3.1 choto a that the floating rates for personal or retail loans to MSMEs extended by banks from 1/10/2019 shall be benchmarked to any of the following factors, including the RBI policy repo rate. Stop. The policy repo rate shown in page 27 of the affidavit in opposition as of 10/2/2023 is 9.40%. Stop. Upon considering the documents annexed to the documents relied on by the respondent bank, comma, it is evident that the petitioner availed of the housing loan through the sanction memorandum, capitals, dated 16/3/2022 on a floating rate basis, and further that the concessional rate of interest, which was relevant as on 16/3/2022, i.e. 6.70%, was subject to change according to the RBI, according to the changes in the RBI repo rate. Stop. Since the rate of interest as on 16/3/2022 increased from 6.70% to 9.40%, comma, the respondent bank cannot be held frozen to 6.70% for all times to come. Stop. The concession given to the petitioner of 0.20% remains unchanged, and the petitioner shall continue to get the benefit of the concessional rate of interest, which would also be evident from the sanction memorandum. Stop. Next. The above factors persuade this court to vacate the order dated, now at a line, next line. It is also evident that the respondent bank does not have a hand or any control over the RLLR, which would determine the rate of interest charged by the bank, as the rates are fixed by RBI. Stop. Next, the above factors persuade this court to vacate the order dated 29/3/2023. Stop. Yes, what remains of the writ petition, Mr.
Nothing remains, but
Mr. Shah?
no. But in the memorandum and also the principal.
Microphone, please.
In the memorandum and also the principal sanction letter clearly mentioned rate of interest is 6.70, and that is for a period up to 3 years from the date of disbursement. After 3 years, it would be floating. That is clearly mentioned.
Very well. Since it is also made clear that the construction given to clause M, Choto M of the sanction memorandum
And also the sanction letter.
was without the documents annexed by the bank, without the documents which were subsequently placed by the bank. Stop. Next, since according to the writ petitioner, comma, nothing further remains of the writ petition, comma, WPA 2444 of 2022 is accordingly disposed of in terms of the above. All the connected applications are also disposed of.
Grateful, Your Lordship. Deeply obliged.
Next.
Item number 17.
I beg to appear, my lord, on behalf of the petitioner. The IDBI Bank, my lord, is the respondent, my lord, was represented, my lord, on the last one occasion.
Yes.
Lord, page 144 of the writ petition is, my lord, an OTS scheme, which is, my lord, floated by, my lord, the respondent bank. And, my lord, this scheme was floated, my lord, on the 59th, my lord, foundation day of the bank. My lord, the scheme required, my lord, the bank, my lord, to individually intimate each of the eligible borrower, my lord, the amount to be, my lord, paid, the amount payable under the OTS scheme, and, my lord, the time within which, my lord, the amount is to be paid.
Yes.
My lord, as for the OTS scheme, my lord, the first range, the first installment of, my lord, the OTS amount was to be paid, my lord, on or before 28th of February 2023.
Yes.
My lord, I was intimated of this, my lord, on 1st of March. So, my lord, I had no occasion, my lord, to pay, my lord, the
Yes,
first.
where do I get it? That
My
you
lord,
were-
will kindly have a look at page 145 once. My lord, you kindly see 145, my lord, on the left hand side, my lord, at the top. My lord, the date is 1st of March. Now, if my lord kindly takes, my lord, the document which is, my lord, attached to this email, my lord, at page 146. This is backdated, my lord, I say so because, my lord, this was delivered to me only on 1st of March.
146?
146 is, my lord, the document attached, my lord, to the email of, my lord, 1st of March.
Yes.
My lord, this is, my lord, a sanction letter for one-time settlement of dues under, my lord, this scheme. My lord, you kindly take me the second paragraph. In this connection, IDBI Bank would like to inform you that the following loans advances availed by you and classified as NPA are eligible for OTS under the scheme towards full and final settlement, subject to your absolute and unconditional acceptance. Now, if my lord, kindly take the pen, my lord, to turn over the page. Kindly, my lord, have a look at page 148.
Yes.
My lord, this is how, my lord, I was required, my lord, to make payment of the OTS amount. Upfront payment and timelines for payment. My lord, this amount was payable on or before 28th of February 2023. Then, my lord, another amount by, my lord, 31st of March, my lord, 2023. And then, my lord, the summation which was, my lord.
No, the last date is 31st of
But
March.
that is, my lord, the second installment.
Yes.
With the first installment, my lord, 22,55,183.30. My lord, this was payable on or before 28th of February. Then, my lord, another amount of 20 lakh and odd was payable, my lord, on or before 31st of March.
And you got this letter on 31st
1st of
January.
March. 1st of March.
How do I know that?
My lord, you kindly again, my lord, come back to, my lord, page 145.
Yes.
My lord, this is an email of, my lord, 1st of March from, my lord, the bank, my lord, abhishek@idbi.com, my lord, to me. The subject is sanction letter. Date is 1st of March, my lord, in the morning. Dear sir, rescinding, my lord, this rescinding word is incorrect. Rescinding the sanction letter as requested. There was no request, my lord, for rescind because, my lord, it was never sent before this. My lord, I wrote a letter, my lord, immediately after having this. My lord, I wrote a letter at, my lord, page 154.
1st of March, and you waited for 27 days after that.
For 154, my lord, I wrote a letter, my lord, 22 days after that. My lord, I wanted to pay it off.
My lord, 31st March was the last day.
Mr. Banerjee, what remains of the writ petition? The scheme was till 31st March.
Well, they were under an obligation, my lord, to do something, my lord, to me, my lord, so far as the scheme is concerned. They did not do it. So, my lord, in my most humble submission, my lord, the judgments of Justice Hemant Shah, my lord, possibly won't stand in the way because, my lord, Justice Shah has held that, my lord, the OTS scheme, this cannot be
No, I
excluded.
remember you're saying that you were entitled to the scheme, but if the scheme has gone, then what remains?
The scheme has gone because of, my lord, the latches on the part of the
Very well. So
bank.
the scheme is no more in existence. What relief can I give you?
My lord, can direct, my lord, the bank to accept the OTS amount. It's because of their fault that, my
No,
lord,
no,
they have-
no. Accepting the OTS amount is one thing.
Yes.
And giving you the benefit of the scheme is something else.
My
What
lord,
is the prayer in the writ petition?
the prayer is, my lord, a direction upon the bank, my lord, to receive the OTS amount for closure of my loan account. My lord, page 19, my lord, the prayer starts.
Yes, C is for the scheme.
Correct.
C is for the
Bank
scheme.
has said, my lord, I was entitled, my lord, to all the benefits under the scheme. It's because
Very
of
well,
the
but
bank's delay.
Yes, but the bank gave you the mail on 1st March. You filed the writ petition on 28th March.
My lord, after writing to them that, my lord, I want to pay, they refused. Then, my lord, I had no other option but to
Very
come to your
well.
lordship.
Yes, no one appears for the bank, for the respondent bank. Learned counsel, next learned counsel appearing for the petitioner. Petitioners relies on a letter dated 31/1/2023 from the bank, which states that the petitioner number 1 is eligible for OTS under the Amrit Mahotsav ঋণ এটা দেখে নিও তো ভুগতান যোজনা 146 towards full and final settlement. Stop. Council submits that this letter was, however, sent to the petitioner by mail on 1st March 2023. Stop. And hence, and hence the petitioner could file the writ petition only in the end of March 2023. Stop. The petitioner in the meantime, also asked the bank to close the OTS, also asked the bank to accept the OTS amount under the scheme by way of a letter dated. When did you?
24th of March 2023 at page 154, along with a check which is still lying with the bank.
24th March 2023, along with a check which is lying with the bank. Stop. Next, no one appears for the bank. Stop. List this matter on 24th April 2023. Stop. Council is requested to communicate this order on the bank. Stop. The bank shall be represented on the next day. Stop.
My lord, may there be a, my lord, restraint order upon the bank, my lord, not to take quasi measure in the
No.
meantime.
Next.
Grateful, man.
Item number 18.
I beg to appear.
And I'm appearing for the respondents.
But may I file my affidavit of service?
ডাকো তো একে, নাম কি এর?
Subject matter of challenge in this writ petition is withholding and non-payment of
I can't hear you. Yes.
withholding and non-payment of third running bill
Yes.
in respect of the work which has duly been completed, and till today no allegation, no reason has been assigned. The facts in a nutshell is this: in 2014,
What is the relief you want?
for release of the third RA bill,
I can't understand what you're saying. Microphone.
for release of the third running bill, which has not been paid which has been withheld without assigning a reason by the university authority.
Yes, and when did that cause of action arise?
Cause of action arose in the year 2019 when work order was issued for completion of the second phase of the work. I started my work. My first running bill was paid. My second running bill was paid. My third running bill was withheld in the last part of the December 2019.
2019.
29. I'm coming to that, madam.
And
After COVID situation, pandemic
wait, you
situation,
filed the writ petition after 4 years.
consecutive representation has been made before the authority concerned.
Last one is dated.
But till date, my lord,
Yes, you are appearing for who?
my lord, page 69 and 70.
You are appearing for who? I can't hear you. Microphone. Who are you appearing for? Microphone. Yes, so your representation was dated when? 2022?
2022, 2nd November 2022 and 23rd of November 2022. This is the demand justice, my lord. Till today, no reason has been assigned.
And you are who?
I am the petitioner, a contractor, sole contractor.
Contractor for what?
For the tender was floated, participated in the tender process. Color merchant of acknowledger. Thereafter, my lord, my bid was accepted. Formal work order was issued.
Work order for what?
Work order for completion of the painting works in and around the university.
What is
campus.
the claim in the writ petition?
The claim is the writ petition is the second phase of work.
How much is the money? What is the monetary
8 lakh
claim?
something. That has been stated here in the note sheet.
Yes,
They have collected
why have you not paid this amount?
7 lakh 50.
You are the University of Burdwan. Why have you not paid this amount?
Well, from the very beginning, there are irregularities. It is done by the engineer in charge.
But you have paid the first and the second
Totally
tranches.
keeping the higher authorities in dark. Totally violating the policy
Have
of the
you
government.
made any payment to the petitioner or not?
No,
No,
no.
not paid a single penny to the petitioner. Is that
He has
correct or
been
not
paid
correct?
out of 34 lakhs, 27 lakhs has been paid.
Then why-
7 lakhs has been prevented. When they came to know that they invited the tender in 2014 without following the government policy. Government asked them to invite tender.
Then out of 34, how can you pay 27 to them?
University might have paid from their own fund.
Very well, pay 50%.
My lord, let me
50%. 50% by 24th
Mine.
of 8 lakhs of the remaining amount.
My lord, I will use an affidavit in opposition.
Of course, but 50% before
Yes,
the affidavit in opposition.
I am agreeing to pay.
Yes. You are agreeing to pay, then pay 100%.
No, 50% your lordship will, as lordship will direct, we will pay. But the engineer in charge should be punished.
Punished?
Yes.
For what?
For manipulation. Totally manipulated. The tender, all the things.
Very well.
Work
100
order.
Very well, 100%.
Quotation notice.
Yes, the claim in the writ petition is of a contractor who was engaged for painting and other works in the University of Burdwan sometime in
First phase 2014, second phase 2017. Page 63.
sometime in 2014. Stop. The work was performed in 2 phases in 2014 and 2017. Stop. Of the total rupees 37 lakhs. Is that correct?
In first phase, 1 crore 29 lakhs. And in the second phase, 1 crore. Total tender, total amount of the
What
work.
are you saying? Have you paid or is it due?
1 crore 29 lakhs have been paid earlier in 2014.
My lord,
Very well.
Then they got an work order in 2017 for a amount of 1 crore. Out of which
it appears to be admitted, comma, as submitted on behalf of the university, comma, that of the 34 lakhs, comma, the petitioner has already been paid approximately rupees 27 lakhs. Stop. 8 lakhs is due. Stop. Council submits that the petitioner was not paid the remaining amount of 8 lakhs since the petitioner failed to comply with certain government, certain conditions in the tender. Stop. Next. This court is unable to comprehend the reason for non-payment of 8 lakhs which stood outstanding to the petitioner as of 2017. Stop. The work was done by the petitioner. Stop. The non-payment obviously appears to be an afterthought and prima facie without any basis. Stop. Next. Before affidavits are called for, comma, the university shall pay 50% of the outstanding due of rupees 8,75,553 within 24th April 2023. Stop. Affidavit in opposition, how much time?
3 weeks.
Affidavit in opposition within 2 weeks, reply within a week thereafter. List this matter after 3 weeks. And do you know how to pay him? What is the mode of payment?
50% of the, what was the payment? Whatever payment was being made, what was in whatever system, I will.
Does the university know the mode of payment to be made?
Mode of payment, university knows very well. They have calculated the bill.
Yes, it is submitted by council that the university is aware of the mode of payment since the first 2 tranches, since the university has already made substantial payment to the petitioner.
Extremely.
Next.
And this is barred by limitation also.
Very well.
Development.
If your lordship kindly goes through the entire documents, your lordship will understand what manipulation has been done in inviting the
understand
tender and
after
awarding the contract.
Yes, I return back.
Pass over matter item number 16. I beg to appear for the respondents, my lord. My lord, your lordship, my lord, I apologize. Your my lord, your lordship was pleased to ask me whether, because the no notice was served upon the respondents.
You said first order, no notice given.
My lord.
At the second stage, hearing was given.
My lord.
Petitioner was heard, and then the second order was passed, which was approved by the general manager, whoever he
My
is.
lord,
Yes.
my lord, my lord. And my lord, only as regards the my lord, that no notice was non-issuance of the notice, my lord. I only on my 1 point submission is this, my lord, that if your lordship kindly comes to page 167, my lord, that page 167, paragraph 6.4.2 and paragraph 6.4.2 that says, my lord, 6.4.2b that says, my lord, that whenever any malpractice or unethical practice adopted by the firm comes to the notice of the deputy HOD or railways, the case for delisting of firm's name from the approved list may be initiated. And my lord, if your lordship kindly comes to page 169, paragraph 6.4.3, my lord, it says, my lord, the delisting shall be considered after communicating appropriate technical reasons with reasonable notice period, minimum 1 month to the firms for compliance. In cases where firms are not in a position to overcome the shortcomings in a reasonable given time, it will be advised to CLW for delisting. With all humility, I submit, my lord, that although, my lord, as an officer of the court, I do not advocate non-issuance of the show cause notice, my lord. But here, my lord, the non-issuance, the issuance of a show cause notice, my lord, would have been a mere formality. Humbly submit. And
the charge was of malpractice.
My lord, it was of malpractice, and my officer was arrested two directors of the farm, my lord, they were also arrested. And the malpractice was that my officer was bribed, my lord, for obtaining a particular facility, my lord, opportunity. And now, my lord, I humbly submit a conjoint reading of these two paragraphs I place before your lordship, my lord, shows, my lord, that this 1 month notice, my lord, was required, my lord, only to make good the shortcomings, if any, on the part of the farm, my lord. Now, my lord, I am not debarring, CLW is not debarring the farm because of any technical shortcomings, my lord. My lord, it was only because of
Debarring the fund.
farm, my lord. Farm.
Farm.
I
Yes,
apologize,
yes.
my lord.
No, that's why don't say apologize so many times. Yes. Yes.
My lord, it was because of that particular malpractice I placed before your lordship that it was debarred. And my lord, my another point of submission on this count, my lord, is this, my lord, when the appeal was made before the appellate authority, that is the general manager, my lord, there was no whisper as to this, that there was no prior notice.
Yes.
There was no prior notice before passing the first order, my lord. And third, my lord, I beg to bring your lordship to this particular point, my lord. It is at page 140.
Just tell me something,
my lord.
The whatever procedures you take against anybody, including the petitioner, must comply with the rules framed by you. Where
My
are
lord.
those rules?
My lord, these are the rules, my lord. These are
page.
My lord, this.
Yes, starting from 161.
Not
154.
154, my lord.
Very well. Yes.
154,
So
my
did
lord.
you follow those rules or not? That's it. That's the only question.
I
Did you
follow.
You
I
followed.
followed my lord. So far as giving notice is concerned, no, my lord, I did not follow the rules, my lord. But only I humbly beg to place before your lordship, my lord, that this was the reason I did not follow that particular rule, my lord.
Very well. So if you did not, if the admitted case is that you did not follow the
My
rules,
lord.
does the rules provide? Do the rules provide for a kind of an escape route?
No, my lord. It
by
does
which
not
you
provide.
cannot give, or by which you are not required to give that
My lord,
notice.
only as per my humble understanding, my lord, only this point, my lord, 6.4.3, my lord, at page 169.
Yes.
Since it says, my lord, that this minimum 160 1 month notice, my lord, is required in cases, and it says that in cases where farms are not in a position to overcome the shortcomings in a reasonable given time, it will be advised to CLW for delisting.
Very well. So the second condition must be met, that there's a benchmark. When you satisfy that benchmark, then you're saying that you can waive the 1 month notice period. That is what you're saying.
It is as per this humble,
Very well. So
this 6.4.
So that means you're required to come to a finding that that this is a case, the petitioner's case fits into the second scenario, that petitioner was not in a position to overcome the shortcomings. It's very vague.
I
shortcomings?
have given that in the reasoned order, in the appellate, before the appellate authority, when the hearing was done, my lord, this reason was given, that
Yes,
is why we have.
what is the shortcomings which is being spoken of here?
My lord, no shortcoming was there. So far as technical problems are concerned, there is absolutely no shortcoming. That only reason, my lord, why we debarred the farm, my lord, is that of bribing
For
the
6.4.3, you're saying that the notice period there was no requirement on you to serve 1 month's notice on the petitioner, provided the second part of 6.4.3 is fulfilled. Now you're saying there's no shortcoming?
No, my lord. Possibly, my lord, I am not being able to place my case properly. The farms are, in cases where farms are not in a position to overcome the shortcomings in a reasonable given time, it will be advised for CLW for delisting. And the first part says.
I'm asking you, what is this shortcomings?
No, there was no shortcoming. That is what I want to place before your lordship, my lord. Delisting shall be considered after communicating appropriate technical reasons. Kindly, my lord, I humbly pray before lordship. Kindly have a note.
I'm asking you, what shortcomings is contemplated in 6.4.3? What shortcomings?
Technical shortcomings, my lord. technical shortcomings. My lord, kindly see the first part, my lord. Delisting shall be considered after communicating appropriate technical reasons with reasonable notice period, minimum 1 month, to the firms for compliance. Now, there was no technical problem on their part, my lord. The only problem on the part of the firm was that two directors of the firm, they were arrested by the CBI after they tried to bribe an officer of the CLW.
Very well. Yes, your next point.
And my lord, I beg to place one as before your lordship, my lord, at page 141, my lord. My lord, 140 from 137 starts this appeal on the part of the petitioner firm, my lord.
Yes.
And the relevant portion I beg to place before your lordship, my lord, is at page 140 and 141, paragraph 8. We don't understand that under what circumstances and under what compulsion the other party allegedly took our company's name, director's name. We suspect there is some ulterior and nefarious motive designed, perhaps someone to defame our company, perhaps to kill the competition or to take some vengeance. We completely deny the alleged charges. And point 9, paragraph 9, my lord, says, two directors of the company are falsely implicated in this matter. As per CLW letter number such and such, stated that unethical practice has been committed by our two directors, even though the matter is sub judice in nature and subject to the outcome of the trial. I humbly submit before your lordship, my lord, that the firm, my lord, they have at no point of time they have stood against the directors, my lord. They have rather stood by the directors, my lord, although there has been a commitment of a malpractice, my lord, for which the CBI had arrested the directors, two of the directors.
Please don't confuse me further. Just tell me that the rules are there, whether you have complied with the rules, that is all. You,
My lord,
according
only
to you,
for this reason,
yes.
it was not complied with, my lord, because the point of malpractice, my lord, that could have been
Very well. You're relying on 6.4.3 and saying that notice, 1 month's notice was not required to be given.
My lord.
That is all you're saying.
My lord.
Very well. Mr. Kapoor, will you come back on some other day to give the reply? Just 5 minutes.
Please, your lordship, please. Or I can do it just now.
Very well. Yes, please.
I'm not able to understand what my learned friend says, but the fact of the
Microphone, please.
matter is, the fact of the matter, please, your lordship, is that an FIR was filed and straight away they delisted me on two different departments delisted me. So I went to the Punjab High Court, and the Punjab and Haryana High Court directed them to give a hearing afresh and deal with the matter altogether. Normally, they gave a hearing.
Yes.
Gave a hearing, but if your lordship will kindly see, read from me, with me from page 153. I'll put it very briefly. From the reading of the grounds for delisting, it is clear that whenever the firm is delisted for the reasons regarding technical deficiencies or contractual failure of the firm, once they take remedies for those deficiencies and submit status action taken by them to improve their technical deficiencies, their submissions are considered for a period of 2 years. Now, she talks of 6.4.3, etc. But the committee itself rejects the 6.4.3 point altogether. How does it do so? However, in the instant case, the delisting was done on account of malpractice, unethical practice. Then, without notice, without show cause, relying on the FIR, they've all done all of that. So that is the first point. Nevertheless, further, the case is sub judice. When the case is sub judice, there's no conviction. I've handed up the document to your lordship saying that office memorandum saying that without conviction, there cannot be delisting. Without conviction, cannot be delisting. Your lordship has seen that. And the only ground is it is not possible for the CLW to decide a time frame for which legal procedures are to be completed. Therefore, they were delisted. This is the ground. This is the only ground, and it's meaningless.
Mr. Kapoor, 169,
Lordship,
6.4.3, what is your interpretation of the second part?
if your Lordship just want kindly reads with me 6.4.3, it has no relevance
169.
whatsoever.
Yes,
If your Lordship kindly goes to
169.
page 169, delisting shall be considered after communicating appropriate technical reasons. Now, my lord, if there's a default in working, some technical reason with reasonable notice period, minimum 1 month for the terms for compliance in cases where firms are not in a position to overcome the shortcomings in reasonable time, it will be revised. So delisting is only because of technical grounds. In this case, the committee itself admits, and the appellate committee also, admits that delisting has been done not for technical reasons. So 6.4.3 has no relevance at all. She concedes that.
Yes.
And it is meaningless to refer to 6.4.3 because delisting is the question of notice. I have a right, Millard. If the appeal period I came up in the appeal period itself, and I have a right, Millard, to complain that without proper grounds, showing proper grounds, and only on grounds of malpractice, I was delisted. Now the court said you give them a hearing. Now the position is the case is sub judice, not possible for CLW to give a time frame. It will be completed. Therefore, the representation is that the delisting period of the firm is under.
Mr. Kapoor, which clause are you relying on for
I'm
the
relying on
for the notice?
Notice, Millard, the judgments that I have already submitted in the note, but delisting, Millard, kindly consider this. Delisting has
Civil consequences.
no civil consequences.
Yes.
I've given the judgment, and Millard, kindly just come. The
That
core
is
of
that Erasian.
yes,
Yes.
and Millard, Erskine and other cases.
Yes.
But Millard, the core of the controversy lies in this: the GM. There's no hierarchy. There's a bench of coordinate officers who are to do the job. The principal chief electrical engineer and the principal chief marketing materials engineer, and the third, the principal financial advisor. They are a recommending authority. Now they purport to give a decision. They have no right to give a decision. And Millard, at the end of it all, your Lordship will kindly read the notice of the GM. I agree with the recommendation of the committee. It's a meaningless.
And the rules or whatever you're relying on does not provide for a hierarchy. That's what you're saying.
The rules do not provide for a hierarchy. Rules do not provide for a hierarchy. They are officers in a coordinate situation of equal competence, and only the hearing committee is constituted, and the hearing committee is a recommendatory committee.
Yes. And so you don't, because what about 175, Mr. Kapoor?
175 Millard is kindly see
174, 175.
Kindly go to 174, please. Kindly
Yes.
provision for appeal. The appeal can be made in the case of delisting only within 30 days of the issue of the delisting. Whenever the vendor is not satisfied with action, he may appeal to the GM, who, after seeing the merits of the case, may decide or dispose of the case of the meeting and consisting of the so and so. The committee will only verify the case, etc., as per and the committee will verify the case has been dealt with as per procedure, not otherwise. And the committee will only, kindly see, committee only gives their observation and recommendation. Now, in this case, the committee has purported to give a decision.
It is decided.
You're saying that they are precluded from coming to a decision.
They are precluded. Your Lordship will kindly remember the case of L.K. Ratna. Your Lordship mentioned two decisions. I remember that case just when the hearing was going on. L.K. Ratna's decision, two things were said. A a initial failure at the appellate stage does not justify matters being dealt with in appeal. L.K. Ratna's case, 1987, Supreme Court, page 71. Judgment of Justice, Chief Justice Pathak and Justice, Justice Sabyasachi Mukherjee. So, Justice Meghani's judgment is quoted that if an opportunity is not given at the first stage, it is worthless giving a man opportunity in the second stage, and particularly in such a case when malpractice or wrongdoing is perpetrated. So, but Millard, if I may say, the core of the controversy rests in page 153. Just kindly take this. I agree with the recommendation. It's boiled.
Yes.
Without reasons.
Yes.
It is boiled without reasons. One line order. Unreasoned. And Millard, for all of these defects, the GM's action is invalid. If the GM's action is invalid, Millard, following all these features that I've criticized, the deficiency, decided, etc., etc.
Yeah, so you're saying that if the foundation is vitiated, then the superstructure falls.
Exactly, please, Your Lordship. Exactly, please, Your Lordship. And the one-line order is a meaningless order. It must give reasons. It doesn't purport to give reasons at all. It says, I agree. Agreeing is nothing. No application of mind by anybody at all at the GM stage. So, Millard, it's full of nullities, may I say, with respect. 643 has no application. The committee purports to, the committee admits it has no application. And the FIR, following the FIR, straight away, malpractice is alleged. Now, conviction, without conviction, there cannot be any delisting. So all of these, cumulatively, all of these points aggregate to Millard, the justification. I'm submitting respectfully that Millard, the delisting should be barred. And
that is the final prayer in the writ petition.
Yes, in the writ petition.
And you're not on the quantum of this delistment.
No, I'm not interested in the quantum because Millard, quantum is nothing. 1 year, 2 years. I am submitting before Your Lordship that there cannot be any delisting on the grounds of an FIR. Kindly, there can be no kind of delisting. Kindly come to page 40 of the prayers.
Yes, Mr. Kapoor, I've understood.
Please, Your Lordship.
Yes, Miss Dotto, is this a new case you're handing up? No.
No. Just
That's the office
memorandum.
the office memorandum.
That's right.
Can be debarred only when.
Yes. Miss Dotto, how much time do you want for your just 2 pages, just points, not notes?
My lord, I can come back any day except 26th whenever your lordship directs.
Yes, Mr. Kapoor, your notice points are already with me.
Millard, Mr. Mitra has given that note. I don't want to trouble Your Lordship with a further note. Kindly.
This is submitted by Mr. Mitra.
That is submitted by Mr. Mitra, and I Millard
12 points. Yes, learned counsel appearing for the Chittaranjan Locomotive Works / respondent is requested to indicate her points on by 28th April 2023. Stop list this matter on 2nd May 2023.
Deeply obliged, my lord.
Millard, Your Lordship's interim order kindly continue until
That is still 30th.
That's it till the 28th. So kindly extend that, Millard.
By which order?
Lordship's.
Yes, I found it. Yes.
Lordship.
The interim order is till 28th April 2023. Semicolon. The interim order shall be extended till 19th May 2023.
Lordship.
Deeply obliged, my lord.
Yes, call on the next matter, please.
Item number 19.
Well, I'm for the petitioners.
Yes.
Most of those. Then. Other side.
Not an ideal state of affairs, Mr. Shandal.
No, it's not an ideal state of affair.
Yes.
No, my lord, pursuant to your lordship's last direction, I am supposed to, my lord, submit a short notes. But I have prepared that, your lordship, but I have not circulated amongst them.
Not required to.
May I circulate? My lord, my lord, your lordship's query was that, my lord, on the order dated 11th April 2023,
Yes.
my lord, I just the relevant portion. However, this court is of the view that the petitioners must satisfy that the petitioners are registered under the 1972 Act in the capacity of an association. Now, my lord, in regard to answer this, my lord, with regard to answer this question, my lord, I tell your lordship, the petitioners before your lordship is not a registered association under the 1972 Act.
Yes.
My lord, 1972 Act initially was optional. My lord, according to my submissions, my lord, after 2016, this has become, my lord, mandatory by interpretation. Because, my lord, initially there was a clause for withdrawal of the registration. My lord, if there is a provision in the Act itself for withdrawal,
But isn't this housing complex after 2016?
after 20, no, this is after 2016.
So that is what I'm
But
saying.
that-
So
no, I
there
tell you,
was
the
no, there
housing
was,
housing
it was mandatory for you to register.
no, housing complex is from 2010.
Yes.
But we have purchased in 2010 to 2012, the villas, the owners, the petitioners. My lord, this was, my lord, the housing project started in 26.
Yes.
Now, my lord, 2006. Now, my lord, therefore, your lordships, when the association was formed for flat owners management company under the Companies Act, my lord, this was optional. Now, your lordships, in 2016, after that, some of the my lord, villa owners authorized my learned friend's client for getting it registration in accordance with law. My lord, according to us, my learned friend got it registered by a fake document, which was according to the provisions of the Act and the rules has to be satisfied.
Mr. Shannal, why don't you worry about your own locus? Whether they are registered under a fake document, that's a secondary question. Are you registered under the 1972
No,
Act?
my lord, I tell your lordships. That's why my lord, repeatedly I'm submitting with your lordships, my lord, indulgence.
No,
of
no,
course.
I can't understand. You're under what is the source of your power to act as an association of villa owners or whatever owners in that particular complex? What is the source of your power?
My lord, under the registration under the Companies Act.
Companies Act.
Exactly, my lord.
Is that permissible? No.
My lord, this was still permissible unless it is registered. I tell your lordships why I'm saying it. My lord, registration under the 1972 Act has to be done within 3 years from the date of issuance of the completion certificate, not before that.
Very well. So what is the date of the completion certificate?
Not that as of today, there is no completion certificate by the Panchayat. How could it be registered? That's my point, your lordships.
No completion certificate?
No completion.
Mr. Shannal, from what I have understood, your point is to attack the rival association. Is that correct or not correct?
No.
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 That's the prayer in your writ
My
petition.
lord, that's what I'm saying, your lordships. I'm questioning the registration. I'm not against them. If the registration is of
Mr. Shannal, please. The two comes to the same thing. You're saying you're not attacking them, but you're questioning their their registration. Very well. I accept your point. You're questioning their registration. What about your own locus? What about your own registration as a writ petitioner before the
my lord,
court?
I tell you, lordship, my lord, that's I'm answering. Unless the completion certificate is issued, my lord, the registration under the Companies Act will continue. My lord, kindly
Are you
consider.
also praying for a direction on the Pradhan to issue that completion certificate?
I beg your lordships.
Have you asked for a direction on the Pradhan to issue that completion certificate?
Not in so many terms.
Then-
Your lordships can ask. No, my lord, I tell your lordships. That's why authority was given to my learned friend's client. you procure it in accordance with law and submit it.
If you claim to be the association of that complex, then how can you give the authority to your learned friend?
I tell you,
to
Lord,
get that,
I tell you, Lord,
petition?
Malad, this was registered, Malad, in the 2010 under the Companies Act when the act was optional. Malad, after that, we thought we should be registered under the 1972 Act for certain benefits. Malad, we accordingly, some of the owners, I can say, Your Lordship, the majority of the owners gave a power of attorney to my learned friend's client. He is one of the villa owners.
Who is learned friend?
Malad, the respondent numbers, I think 8.
7 and 8.
7 and 8.
7 and 8.
7 and 8. The most of Malad, at least 75 to 80 owners gave him the power of attorney. 70. Malad, out of 125. That forms the majority. Malad, procure the documents relevant.
It's a fight between two groups who want to be associations.
Malad, kindly do not have this Malad, impression. Kindly do not have
And
it.
why should I have any impression? That's
Malad,
rare
that's
in
your-
a petition.
Malad, that's your lordship's, Malad, somehow because of submissions your lordship is getting it.
The
That's a
prayer, the relief, that is what. it was
relief
for.
I am playing your lordships that unless it got it registered properly, Malad, this registration cannot come into force. Malad, according to them, he has to procure a document. He has not done it. And what is doing your lordships as
So it's against the private respondents.
it is the problem. And it, Malad, the authority, my learned friend state appearing for the competent authority says, kindly see, Malad, this is a peculiar submission. That the state authority.
Are you going to take a point of maintainability or not of the writ petition?
Absolutely, that was my point, my lord, that it is alleged that the respondent association has obtained the certificate, registration certificate under the West Bengal Apartment Ownership Act by using a forged document. Lord, it was my submission on the very first day that we cannot decide on if a document is forged or not. It is the appropriate civil code that can only embark on such issues, my lord.
Malad, may I answer to this? It's Malad, it appears to me very ridiculous.
Today, my lord,
Malad, very ridiculous. It's a competent authority under the act. Malad, my case is before him. He's conducting the hearing for at least 4 or 5 days.
Tell me, which prayer are you pressing? Which prayer?
Malad, kindly have a look at Malad, prayer C.
Shashorarai.
Malad, prayer C at page 32. Mandamas.
Prayer C is Shashorarai.
D is Shashorai, Malad, if I'm not wrong.
Yes. Sorry,
No, Mandamus.
that's E, my mistake. Mandamus.
C.
So you want a direction on the competent authority?
Exactly. Malad, I tell you, Lordship, what my learned, kindly Malad, visualize the submission of my learned friends. I am saying that these documents were forged. My learned friend can say, Malad, this, I cannot determine it. He can ask the authority who is supposed to issue the document, whether the document has been issued by them or not. That much. I need not go to the civil court for that.
Very well. Mr. Shannal, even if that is done, I will not give you any interim relief
Malad,
and say that the other authority cannot act. All right?
Malad, your losses can direct them to decide it with them, because at least I am told, Malad, there are documents annexed. At least 4 days hearing has no document. For the last 1 year, pursuant to the earlier direction of the Honorable Court. My learned friend's client, being the competent authority under the Act, has to come to a decision either way. Malad, kindly have, Malad, does it require any other direction upon them?
Where is the last direction passed by the coordinate bench?
I tell you.
Which page?
Malad, if I'm not wrong, your lordships, Justice Bosch. Just a minute, I'm giving.
78, page 78.
Just a minute, I'm giving. 78, your lordships. Malad, the second page is the material response, Malad, material, page 79, internal page 2, the second paragraph.
And you were the petitioner before the coordinate bench?
No.
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 Who was?
Malad, we were the lordships before the Malad, the state opposition. Yes, I'm the petitioner. I'm the
Petitioner.
petitioner.
Both you and 6 and 7 are going by the same name.
No, a little difference. Little difference. So far as the allegation of incorporation of a society wrongfully is concerned, the petitioners can avail of their remedies before the appropriate forum in accordance with law.
Very well. When did you make that application?
Malad, we made this application, Malad, page 84.
Just give me the date, please.
my lord, just a minute. 13 September 2021. Our last order.
Yes, and it's pending since then?
Since then, my lord, at least, my lord, 4 days hearing has been done. 28th May 2022, the last hearing, my lord, was given to us by the competent authority.
You and the 7 and 8.
7 and 8.
Yes, Mr. Chatterjee, do it. How much time?
As your lordship pleases, my lord.
You've been waiting, you've been
2 weeks,
hearing
Lord.
them since 2021.
2 weeks, my lord. But my lord will kindly note my submission.
Very well.
My lord,
Yes.
permit me to place two relevant facts, my lord. What Mr. Shanal is
Are you before the competent authority or no?
My lord, I was before. My lord.
Yes, so that's enough.
My lord, kindly
You will be
see
heard.
the association against whom the prayer has
Yes,
been sought. My lord, he
after
has not been
hearing
made a
learned
party.
counsel appearing for the petitioner, the state, the competent authority and the private respondents, it appears that the state, it appears that the petitioners in an earlier writ petition of WPA 11958 of 2021 were given the opportunity of exploring their remedies before the appropriate forum in accordance with law. Stop. This is the order on record of 3rd August 2021. Stop. It is an admitted fact that the petitioners applied before the competent authority under the 1972 Act. Under the 1972 Act on 13 September 2021. And the competent authority has already heard the parties 4 times, the last of which was on 22nd May 2022. Stop. The private respondent numbers 7 and 8 are also before the competent authority. Stop. Capitals of the competent authority. Stop.
Well, that would be 20th May 20, my lord, not 22.
20th May
2022.
20th May 2022. Stop. Next. Although, learned counsel appearing for the competent authority / state raises a point of the authority not being competent to quotation marks not being competent to go into the issue of fraud, this court is of the view that the concerned authority shall complete the hearing which started from 13 September 2021 within a period of 3 weeks from today. Stop. The petitioners and the private respondents are already before the authority. Hence, no additional directions are required to be passed on that count. Stop. Next, WPA 7330/2023 is disposed of with the direction as stated above. Stop. The competent authority shall pass a reasoned order after hearing all necessary parties within the time directed and shall make a copy of the order available to the petitioners within 1 week from the date on which the reasoned order is passed.
Lord,
Stop.
only one thing-
Needless to say, the 1972 Act and the relevant rules shall be taken into consideration by the authority.
Lord, one thing, Lord, Lord, it is my instruction. What my instructions are, the competent authority is not authorized to deal with is Lord cancellation. So my lord will kindly indicate, because after my lord this order, my lord, it will be presumed that lordship has.
Cancellation? What cancellation?
My lord,
You mean issuing of the certificate?
what I am on, my lord,
Yes.
my lord will kindly observe that lordship has not gone into the question whether the application is maintainable before the competent authority, because it is my case that the
Very well. It is made clear that this court has not gone into the question of whether the application made by the petitioners before the competent authority is maintainable.
I'm very grateful, my lord. I'm very.
Next. Can't hear you. Next. Next.
Item number 20.
Yes, call on the applications, please.
Before your lordship take up, my lord, the application item number 23, my lord, interim order is expiring today, my lord.
23 to Lakoto. Who is the other side?
Mr. Torun Jyoti Tiwari was appearing. My lord was hearing this matter, my lord, with regard to, my lord, subsidy scheme, my lord, technology upgradation.
Very well. Kalketa upore kore do. Yes. Next. Applications.
Application item number 171.
May it please you.
Mr. Chidambaram, can you just wait for 1 minute, please?
Very well.
Yes, Mr. Shaha, why are you looking so restless? You and Mr. Ray.
Well, the item number 21 is that writ petition, my lord, that your lordship had fixed today. My lord, I understand that Mr. Ray is, my lord, not available tomorrow, neither am I. So, my lord, we were wondering whether if your lordship could keep it on the 19th, my lord.
20 to Dakoto.
21.
Item number 21.
Yes, when are you available, Mr. Ray and Mr. Shaha?
Well, the day after tomorrow, my lord.
Yes, since learned counsel representing the parties are not available tomorrow, list this matter on 19th April 2023 as prayed for. Yes, applications.
Application item number 171.
May it please your lordship.
Yes.
Look, what is listed is the application.
There is a writ petition pending of
Writ petition is
2021.
pending. Writ petition is pending.
Yes.
It was heard, orders were passed. The other side took it up in appeal. Orders were
Mr.
passed in
Microphone,
appeal.
please.
Orders were
Have you filed the application? It's before the
orders
court.
were passed in the appeal and then sent back to the learned single judge to decide all objections as well as on merits.
Yes.
That is where the matter stands today. My lord, what is listed, I'm told, is can number 5.
Can 5. Can 5 to kothay?
Can 5.
Can 4.
But in order to appreciate can 5, would your lordships kindly have
Just 1 minute. Let them find out the application.
My lord, there are other cans also pending. But by Reserve Bank of India, can number 3 by Bank of
I'm going to
Baroda.
say that. I'm going to say
Yes.
that.
So,
Mr. Chidambaram, I will come to you in a minute. What is the prayer in the writ petition?
Prayer in the writ petition, would your lordships kindly have? There are number of prayers. Kindly have page 60. 60, paragraph 76.
Writ petition টা কোথায়? বলে সরো। Yes.
Written the nature of mandamus commanding the respondents to act in accordance with law to appoint an independent auditor to have regard to the master directions and master circular of respondent 4, which is the RBI, conduct an audit and assessment of the credit facility and interest levied thereon. There is a brief history, what happened before the learned single judge and the division bench. I will come to that behind this prayer. And then written the nature of mandamus directing respondent 4 to act in terms of the audit report. C, written the nature of certiorari commanding the respondents to produce all the necessary
What was the
documents.
threat or the apprehended action before you at this point of time?
Abipan?
What was the apprehended action which made you come to the court?
There's no apprehended action. It's actually inaction.
Very
I'll tell you, Lordship, the facts in 5 minutes.
Yes.
Just give me 5 minutes. There is a list of dates, but please don't trouble yourself. Just keep the list of dates with you. Just give it. Please keep the list of dates. Please don't trouble yourself.
Yes, yes.
If necessary, I'll invite your lordship to 1 or 2.
Yes.
I'm a not-for-profit society
Yes.
registered under the West Bengal Societies Registration Act, who has set up a medical hospital and a college. But please underline not-for-profit. I applied for a loan and got it from respondent number 3, who's Axis Bank. That is my only banker. R1 and R2. R1 is Bank of Baroda. R2 is the erstwhile Syndicate Bank, now Canara Bank. Let's call it Canara Bank. Wanted to participate in the loan arrangement.
Yes.
They expressed an interest, and therefore an agreement is signed whereby R3 downsold one-third of the loan to the 3. So each one is lending me 70 crore, 70 crore, 70 crore. Point 1. Second fact, I am a standard accountant even today. Standard account even today. I'm not an NPA. I'm servicing my account. Statement number 3. R3, the head of the consortium originally, is charging the agreed interest rate. Even today, I have no grievance against R3 at all.
R3 is Canara Bank.
Axis Bank.
Axis Bank.
Axis Bank is continuing to charge the rate agreed upon in the original agreement. R1 and R2 arbitrarily raise their rate in contravention of the master circular of RBI, which your lordships have held are binding and enforceable, and kept on increasing in violation of various conditions of the loan agreement. I will come to that at an appropriate time. Now, fortunately, in the course of this litigation between 21 and today, R2, that is Canara Bank, has seen reason and has reduced the interest rate. We have agreed to a settlement, and I have withdrawn my writ petition as against R2. So what remains is only R1. R1 continues to charge me today 17.52%, where the agreement rate is far lower, access rate is lower, and the agreed rate between me and Canara Bank is also much lower. Now, on the eve of this hearing, R1 has written me a letter, which is on 4th of April 2023, which is at page 61 of a supplemental affidavit I have made, offering to reduce the interest rate to 11.25%, but only from September 21.
No, from what rate to 11?
He is willing to reduce it from 18th of September 21.
No, what was the interest rate which was being charged?
17.52.
17 point, and now reduced it to
11.25.
11.25.
But prospectively. But they arbitrarily increase the interest rate on 2016. October 2016. They arbitrarily increase the interest rate from October 2016. They are offering to reduce it from September 21, which is not acceptable. I've told them this is not acceptable.
And what was the original interest rate before it was raised to 17.5?
Original interest rate was 11.55. I'll tell you, Lordship, the principles of the manner in which this interest rate is fixed. There was, under a master circular, called a base rate. Base rate plus the spread. Spread indicates the credit rating of the borrower, and the base rate indicates the cost of funds of the bank, and the spread indicates the credit rating of the borrower and the tenure of the loan.
Yes.
All three had between 11.5, 11.4 and 11.55. One had 11.4, one had 11.5, the other is 11.55. I concede that. There could be a marginal variation between the two, between the three. Now, there are three inviolable conditions. One, there is a initial interest preset date, reset date, which is before a particular date, you cannot revise your interest. That date is 31/3/2018.
And where do you get that date from?
It is in the contract. I'll show that.
Very well.
It is there. Now, R1,
We are on remand on the basis of an order passed by the division bench.
I
At
said
the
that.
first instance, my learned friend will obtain an order, mandatory order, appointing, Lord, directing RBI to appoint an auditor to go into the accounts. Lord, we preferred an appeal. The division bench, Lord, permitted us to prefer an application before your lordship, seeking, Lord, recall of the order. And Lord, that order needs to be considered, and I have filed an application pursuant to the order of the division bench.
So then what is CAN 5?
CAN 5 is his application, which he has filed subsequently. Now, seeking a same order, but in a different form. He says that court should appoint an auditor.
Lord, I'm
This is
willing
the
to
prayer.
argue all applications.
But my application, I should argue first, because your lordship's order, kindly look at my lord's order, dated 24th June 2022.
It's your lordship to decide which application will be taken up. I'm here.
Yes, Mr. Chidambaram, but I don't want to take the risk without knowing anything of the matter.
That's what I'm trying
what
to
happened
explain to
before?
your lordship. I've given you.
Please look at the second page. Regarding CAN 2 and 3, this is the order that your lordship passed. CAN 2 and 3 are applications of Reserve Bank and Bank of Baroda respectively. These applications require affidavits to be filed. Let affidavit in opposition be filed within 3 weeks. Reply thereto be filed within a week thereafter. Lease these CAN after 4 weeks. So, Lord, this is the order that was passed. And Lord, now.
So CAN 5 was not there at this point of time?
No.
CAN 5 is
CAN 5 was filed
subsequently
later.
And what about CAN 4?
CAN 4 is disposed of because, Lord, they didn't want to proceed against the Canara Bank.
Very well. So 2 and 3 were directed to be listed, and then 5 was filed subsequently.
I'll tell you, lordship, why 5 was filed. Because RBI filed an affidavit saying that it has no authority to appoint an external auditor. If necessary, the banks may appoint an external auditor. So without prejudice to that prayer that the RBI should appoint an external auditor, I have now filed CAN 5 saying that the bank should appoint an external auditor. Or the court should appoint an external auditor.
Mr. Chidambaram, let me see the division bench order, please.
Yeah, please see the division bench.
Please come to
Division bench order.
CAN 3, page 40.
Page.
CAN 3 to the
Page.
First volume.
Page
40.
Page 33 of CAN 5. Give it to me.
This is an order dated 4th March 2022.
Yes.
Please come to the operative order part, Mala. Paragraph 7.
Yes.
Having heard the learned counsel, it is noticed that undisputedly application of the instance of RBI for recall of the impugned order is pending. Learned counsel of the RBI has also categorically stated the RBI will not be taking any steps for appointment of independent auditor in terms of the impugned order till the application for recall is decided. Appellants of the grievance of the impugned order has been passed without giving them opportunity to file affidavit in opposition or without giving them full opportunity to place their stand. In such a case, proper remedy available to the appellants is to place their stand on record and make an appropriate.
Appellants was the Bank of Baroda. Very, yes.
Appellants were both Bank of Baroda and Canara, because Canara settled later.
Very good. Yes.
If such an application is filed by the appellants, learned single judge will duly consider it in accordance with law, having due regard to the material which may be placed on record by the appellants. Learned single judge has not gone into the rival contention of the parties. Therefore, entire issue is now open, which can be gone into by him. Since the counsel for the RBI has already stated impugned direction will not be given effect to till the decision of the application for recall. Impugned order needs no interference at this stage. Hence, the appeals are disposed of. Single judge will duly consider. In view of RBI stand that I will not appoint an auditor, let the banks be directed to appoint an auditor, let the banks appoint an auditor. I file CAN 5 saying, let the bank appoint the auditor, or in the alternative, your lordship may appoint an auditor. Eventually, my lord, my prayer is there should be an external auditor, an independent auditor to look into the account in the light of Axis Bank from the very beginning agreeing with my case, and subsequently now Canara Bank agreeing with my case. The one who's standing out is Bank of Baroda, which now makes an, according to me, half-hearted offer.
Which page is the first order of the first court's order? Which page?
First court's order.
That your lordship will find.
15, my lord, 1-5.
Here, your lordships will find it at page 28.
No, in CAN 5 is same application will be 15.
CAN 5, I don't know. My learned friend will point out.
No, that's what you're referring, November 18 order?
My lord is asking for the first order that was passed, 18th November.
Yeah, 18 November is at same volume, page 15.
Yes. Where is the operative part?
It's a longish order. Now kindly come to page 19. 19.
Page 25, last paragraph. RBI to
No,
appoint.
no, the first order,
No, the operative part of that
Look,
order.
the order had some some minor
Internal
corrections.
page 5, internal page 5. last
May
paragraph.
I answer the question, please?
But I thought that, Lord, my application will be heard first.
My lord says.
Mr. Kaur, I will decide that.
Yes.
I just want to see the, I have to understand
No,
the
the
flow of.
order was originally passed. There were some errors in the order. The order was corrected. The corrected order is at page 21. Page 21. Therefore, kindly see the corrected order.
Very well. Yes.
Most of the bulk of the order is the same, my lord. Some technical, some errors in typing were corrected.
Very well. So page 25 is the operative part.
No, kindly come to page 24.
Yes.
Last two paragraphs. To appreciate the contention is there. First, the charge of penal interest. Secondly, the initial interest spread reset date. To appreciate the said two yardsticks, detailed evidence is not required, since such clauses of the agreement and communication between the parties clearly makes it evident. Since such apparent irregularities have been pointed out to the petitioner, it would only be fair that the Reserve Bank of India, which is the governing body of the country and whose master circulars of statutory effect and law, should look into the matter by appointing an independent auditor. Mullah, I'm skipping a few lines. All that, bringing a complete picture, transparency, etc., etc. As such, the respondents are directed to file their respective affidavits on opposition within 3 weeks from date, reply if any. The matter shall next be enlisted. In the meantime, Reserve Bank of India, being the respondent number 4, shall appoint an independent auditor of its choice for the purpose of conducting an audit and assessment of the credit facility and as to the propriety and legality of the rate of interest and penal interest levied by respondents 1 and 2 banks in respect of petitioner number 1. Auditor appointed by the Reserve Bank, etc., etc. Then last but one paragraph, it is made clear that this court has not gone into the merits of the respective contentions and the question of maintainability, etc. The party shall act on. Now, RBI, as I said, will not appoint an auditor. Fair enough. RBI filed a counter affidavit, which a learned judge said will be treated as the counter to the writ petition. So the RBI's position is very clear. R2 has settled the matter. We have agreed to a settlement now. R1 remains. If RBI is not appointing an auditor, according to me, and I'll make good my submission, the court on the facts of this case should appoint an auditor, because apparently or obviously, R1 is not willing to appoint an auditor, independent auditor. Therefore, I'm saying the court must appoint an auditor. Based on the report, your lordships will take a decision.
But the concern is of the penal interest levied on you.
Concern is actually threefold. One, can you reset the rate prior to the initial preset rate, number one. Number two, then there is a periodical reset rate, which is 12 months. Can you reset the rate multiple times or frequently, even within 12 months? Number three, can you charge penal interest? And if you are allowed to charge penal interest on the construction, can you charge penal interest on the whole loan amount or only on the defaulted amount of any? These are the three aspects of the case. Now they are charging me a higher rate of interest before the initial preset rate. They have, I'll show, they have, or now it only, not they. They frequently increase the interest rate even before the 12-month and without giving me 30 days notice. And three, they're charging the penal interest on the whole loan amount when my account is standard. And I'll show their own document that my account is standard and I've fulfilled all the preconditions. Therefore, my lord, there are two master circulars. One, the master circular, which on the basis of which the initial agreement was entered into, a base rate master circular. Then by the time the...
Mr. Chidambaram, sorry to interrupt you.
Yes.
What is the difficulty if I hear the vacating application, that particular can, for vacating the coordinate benches order first, and then I hear you?
But my prayer now is that the court will appoint an auditor. If the RBI has
Yes,
declined
and that, of course, that question I will put
if the
to
RBI
your
has
learned friend.
declined to appoint an auditor, and if the court is willing to hear my application, the RBI application becomes infructuous.
Yes,
I'm not.
Mr. Kaur,
So the
what
real
is-
issue is can 5, my lord.
Yes, Mr. Kaur, what is the difficulty if the court appoints an independent auditor?
Lord, the issue is, Lord, provided there is a dispute. After all, Lord, the grant of loan is based on a contract between the bank and the constituent. Lord, the charging of 17.15%, which has been charged by the bank, is strictly on the basis of the contract. I'll show your lordship the contract. Because, Lord, the applicable rate is 14.15%. Then, Lord, there is a 2% charged extra because of the default. The contract provides for that. Because they have failed to, Lord, provide the security which they were otherwise, Lord, obliged to do.
And is there a lock-in period for the rate of interest to be charged?
There is no lock-in period. So long the default continues, it will be charged. They have not made good. They have not made good the mortgage, Lord, that they were supposed to do. That was the contractual obligation on them. After taking the loan, they conveniently, Lord, forgot about the mortgage. And they sought extension of time, extension after extension. I'll show those letters. I've annexed every letter, Lord, which is relevant. Now, Lord, what had happened is, if your lordships looks at the prayer made in the
So, Mr. Kaur, according to you, there cannot be any prayer even for appointment by the court.
I tell your lordship why. Kindly, Lord, take the Banking Regulation Act once. Please come to section 21A.
Yes.
Please have a look at section 21A. It says, notwithstanding anything contained in the Usurious Loans Act or any other law relating to indebtedness in force in any state, a transaction between a banking company and its debtor shall not be reopened by any court on the ground that the rate of interest charged by the banking company in respect of such transaction is excessive. Even if it is excessive, here, my lord, it is strictly in accordance with the contract. So, my lord, question is, on the first day, without the affidavit, this mandatory order was passed allowing the prayer B of the writ petition. That was our grievance. That's why, my lord, we moved the division bench. And the division bench said, very well, you go back and make your points. Lord, there are many points that I want to argue. This is, Lord, the one simple point where...
And your application is for vacating simpliciter.
Vacating simpliciter, and Lord, hear out the writ petition. I have no objection. Hear out the writ petition. We have filed. We have filed an affidavit.
No, they have not filed the They have not filed the reply.
We have raised an issue of maintainability in this application for vacating itself. Apart from, Lord, the question of the appointing of auditor, Lord, the dispute, this is pure and simple contractual dispute. Whether it can be raised in the writ petition.
I'll argue all those points. Yes. I'm aware of that.
Mr. Chidambaram, let me hear since the division bench only had 2, 3 and 4 subsequently settled, that's Canara Bank. 2 and 3 before the division bench says that you file your opposition, learned judge the first court will hear. 5 came later on for a prayer to the court for appointment.
2 is no longer relevant because I'm accepting for the time being that RBI cannot appoint an auditor or is unwilling to appoint an auditor.
Very well.
And I'm asking the court to appoint an auditor.
Very well.
I'm willing to argue the writ petition. I'm willing to argue that the court should appoint an auditor. I'm willing to argue both. I'm willing to
Yes.
argue all his objections.
Yes, but if you are enjoying or if an interim order had been passed in your favor,
There's no
and
interim order in my favor.
there's no interim order.
No.
Very well.
Because
So then,
that order, RBI said, your lordship saw the division bench. RBI
Yes.
is not inclined to appoint, and therefore there's no need for interference with that order. There's no independent auditor appointed today in the light of RBI's position. Now keep that aside. If I persuade the court that the court should appoint auditor, the CAN 2 is no longer material or relevant.
but Mr. Chidambaram, if a maintainability argument
I'll
is
argue
being raised.
maintainability. I'll show that it is maintainable.
Yes. But then for you to answer, I will have to first hear Mr. Kaur,
Lord-
who is saying that the writ petition is not maintainable, and then you give your answer to that.
Entirely for your lordship. Some courts ask the petitioner to say how the writ is maintainable. Some courts ask the objector to say.
I'm
how
only
the-
trying to help you, Mr. Chidambaram, so that you have all Mr. Kaur's points when you answer.
No objection. I'm entirely at your lordship's pleasure. If your lordship wants me to argue maintainability, I will argue. If your lordships would rather hear him.
Do you want to take up that point, Mr. Kaur?
I tell your lordship, since my learned friend now says that there is no interim order so far as he is concerned, and he wants Lord Court to appoint an auditor, which he has filed by way of a CAN in like CAN number 5, then Lord vacate the earlier order, allow my CAN number 3, keep the point of maintainability open. I'll file a writ, affidavit to the writ petition because I have not filed an affidavit to the writ petition as yet.
Very well. Yes, Ms. Chidambaram.
Although
what
they
is
have
your-
been directed before to file the
No,
reply,
I will give them a short time.
they have not
But
filed the
if,
reply.
according to you, Mr. Chidambaram, there is no interim order which inures to
There's
your
no
benefit.
interim order which is effective and
Very well, I
operative
will
today.
record that.
It's not
Whatever you have
effective and
said.
operative, and I have made another prayer. If that other prayer is granted, the first one is no longer material. I don't have to battle with RBI. I have to only battle with my learned friend's client.
Very well. I will just record that the interim order granted by the first court is by the coordinate bench is no longer there because of what RBI said subsequently.
In fact, the division bench notes that point, and therefore he says we don't have to, the division bench says we don't have to interfere with that order.
What is CAN 1?
CAN 1? CAN 1, I think, CAN 1 taking about CAN 1?
For modification.
Oh, CAN 1 was blood for modification of the original order that has been disposed of.
Very well. There are presently 4 cans pending before the court. Stop.
I won't be allowed to.
Counsel submits, a learned counsel appearing for the Bank of Baroda submits that CAN 1, which was filed by the petitioner for modification of
The order, correction of the order, first order.
which was
18th of
filed for
November
correction of
first order.
the
November,
first order
dated November.
passed by the coordinate bench on 18 November 2021 has already been disposed of. Stop. CAN 2 was filed by the RBI,
Yes,
was filed by the RBI for vacating,
for recalling of that.
for recalling of the first order dated, first order or second order,
Modified order, 30th November.
for recalling of the modified order of the coordinate bench dated 30th November 2021. Stop. CAN 3 is by the Bank of Baroda, which is which appears to be the only interested respondent in the proceedings as of now. Stop. CAN 3 is for vacating of the modified order passed by the coordinate bench on 30th November 2021. Stop. Can 4 is an application by the Canara Bank, which no longer which has subsequently become infructuous on the stand taken on behalf of Canara Bank for reduction.
Application was filed by the
And for is
petitioner.
my application.
Petitioner.
For-
Petitioner,
On the ground that since they have settled it, the writ
Very
they
good.
don't want to proceed against Canara.
Can 4 is an application taken out by the petitioner for modification of the order. Modification?
No.
For recalling.
For recording that they don't want.
Recording
For
No
recording.
longer a dispute.
Yes,
with.
for recording the changed stand taken by the Canara Bank in terms of reduction of the rate of interest. Stop. Can 5 is an application taken out by the petitioner for seeking a direction seeking appointment of an independent external auditor for conducting an audit assessment of the petitioner's credit facility. Stop. After the facts, the orders on record is the first order of a coordinate bench dated 18th November 2021, which was modified by a later order, LETR, later order of 30th November 2021. Stop. The Bank of Baroda and the Canara Bank challenged the modified order before the division bench, and the division bench, by its judgment and order dated 4th March 2022,
At page 35, Miller, paragraph 7.
sent the matter back to the first court for considering the effect of the impugned order, within brackets, the order dated 30th November 2021, close brackets. After filing of affidavits. Stop. The appellants, within brackets, the Bank of Baroda and Canara Bank, close brackets, were also given leave to seek recalling / review or modification of the impugned order before the first court. Stop. Next, after hearing learned counsel appearing for the petitioners and the Bank of Baroda, it appears that the interim order passed on 30th November 2021, directing the RBI to appoint an independent auditor, cannot really be construed as giving relief to any of the contesting parties before the court. Stop. This is by reason of the fact that RBI, this is in view of the fact that RBI, where did it before the division bench took the stand?
Yes.
That RBI,
And also by an application.
yes, RBI declined to appoint an independent auditor and made its stand apparent before the division bench, as also by an application
Can 2.
filed by RBI /Can 2. Stop.
And instead suggested that the banks appoint.
RBI further suggested that the banks should appoint an independent auditor in place and stead of RBI. Stop. As stated above, comma, Canara Bank is no longer a contesting party by reason of its willingness to reduce the interest rate. Stop. The who was the other one? Axis Bank, comma, the other respondent bank, comma, has also set what?
No, they have never increased the interest rate.
Very well. The Axis Bank, comma, which is the other respondent in the matter,
I had
comma,
no dispute at all with that.
is also not part of the dispute. Stop. Hence, comma, the only, hence, comma, the Bank of Baroda is the only respondent which is contesting the writ petition. Stop. Next, the important point is that the interim order granted by the coordinate bench on 21st November 2020, on 30th November 2021 has lost its force, comma, so to speak. Stop. This is by reason of the fact that RBI has expressed its reluctance to act in accordance with the direction passed by the coordinate bench. Stop. Next, it can therefore be recorded that there is presently no interim order which can inure to the benefit of any of the parties before the court. Stop. Next, the writ petition is required to be heard. Stop. Learned counsel appearing for the contesting respondent bank / Bank of Baroda takes a point of maintainability on section 21-A of the Banking Regulation Act, 1949, on the ground of the dispute being entirely private in nature. Stop.
And Lord, I also say that it's a contractual dispute. Therefore, Lord,
On the dispute being contractual and entirely private in nature. Stop. Next, affidavit in opposition within
2 weeks.
Within 2 weeks. Reply, Mr. Chidambaram.
How long? 2 weeks thereafter.
Within 2 weeks.
1 week thereafter.
Within 1 week thereafter. Stop. List this matter after 3 weeks. Stop. The point of maintainability shall be taken in the affidavit in opposition.
I'm sorry to ask this as a question. Would your lordships be hearing the writ petition and Can 5 together? Because the same arguments.
Can 5 can be disposed of, Lord, keeping the point open to be taken, Lord, in the writ petition. Can 3 is disposed of.
I don't have the prayer in the writ petition.
If I argue Can 5, he will say this is not maintainable. And this is contractual.
I'm saying
so I'll have
writ
to
is
argue
not-
that in the
Very
writ
well.
petition also. So Can
uh,
5 and the writ petition will be
yes.
heard together.
Yes, list this matter. List this matter on 8th May 2023 for hearing the writ petition as well as Can 5 of 2022.
Much obliged.
The lordships are keeping it on 8th May, Miller. 8th May?
Yes.
8th May.
Very well.
It is a holiday, I think.
Yeah, 8th May is fine. No, 8th May is not a holiday. 5th May is a holiday. You check. 8th May is
That's
a
the week before our summer break starts.
Instead of 8, could it be on the 10th?
Yes, Mr. Chidambaram, since you will be traveling, 10th is all right with you?
No, 10th is fine, Miller. I'll argue on 10th.
10th, good.
Much obliged.
Anyone else waiting for the appellate side matters? Mr. Shah, original side.
But
Yes.
appellate side, next matter is mine, my lord, that application, my lord, I was addressing the court on the last day, my lord. Recalling of an order, my lord, I had 2 points, my lord, I took 2 points. One is that's an appeal
Mr. Dev, tomorrow.
tomorrow.
Yes, original
Grateful.
side. Kuntal. Mr. Dev, Monday, I take up applications only on Mondays.
If this can appear on Monday, my lord, I have.
Very well. Actor Dakoto, matter to Dako actor.
Item number 172.
Yes, list this matter on 24th April 2023.
Grateful, my lord. For further hearing. I have not concluded.
Yes, original side. Mr. Shah, will you move the microphone? Because usually if I can't see, I can't hear also. That's what. Yes. Yes.
On last occasion, my lord, I have submitted on behalf of the railway. But my lord, due to shortage of time, my lord, I could not be, my lord, produce the 2 documents, my lord. My lord, kindly allow me to, my lord, rely to, my lord, the judgment of the Supreme Court, my lord.
2 documents. Why is
Sorry,
it
my lord,
documents?
not
2
2
judgments.
2 documents, 2 judgment, my lord.
Yes.
My lord, Afcon Infrastructure Private Limited versus Nagpur Metro Railway Corporation Limited.
On which point?
My lord, it is reported in 2016 9 SCCK 033, my lord. And I relying paragraph
No,
12,
but
13 and
please
15.
give me the citation, a proper citation. What is this?
My lord, 2016 9 SC CK 0033. My lord, I have
9
given copy.
SC?
my lord. 2016 9 SC CK
No.
page double.
Give me a SCC online, SCC or SCC online citation, please.
My lord,
Because then I have found that when I do my own research, none of the paragraphs match. Please give me a recognized citation.
Well, the STC, my lord, parallel
2016
citation.
16 SCC page 18, my lord, paragraph, my lord, 11 to 15.
2000?
2016, volume 16, SCC, page 818.
Yes.
Yes.
Page, paragraph?
Paragraph, my lord, 11 to 15, my lord.
But will the paragraphs match?
My lord, in this judgment, my lord, the citation is also here, my lord.
Can't you understand? I don't
No, my lord.
accept
No.
any
No,
citations.
no, no.
apart
All
from
the
SCC.
paragraphs are not same, my lord.
Then I don't accept any citations which do not match SCC online or SCC or maybe AIR at best. No other citations. I don't accept. Get the citation on the next day, please. Proper citation. And what is this? Indian Kacheri? What is Indian Kacheri? Kacheri?
Court Kacheri. Court Kacheri. I have never heard of this before.
Court Kacheri. Get a proper citation.
অন্য জায়গাটা কি দিয়ে দিন একটা কপি তাহলে ডিল করতে পারবো
Mr. Shah, You ask your junior to get out the case and
Yes,
get your citation.
Yes,
What are you asking him for?
He said he rely on two decisions, but if I could have copies of both the decisions,
You want another court kacheri decision?
I'll find out the parallel SCC, my lord, citation.
And my lord,
So that I
another,
can answer the question, my lord, on the next day without, my lord,
and
again.
my lord, another is 1993, 1 SCC, page 445, my lord.
On which point? That you can cite. Give me.
My lord, this is on the, my lord, the same.
What same?
This, আমি বইটাও এনেছি। কিন্তু well, my lord, I have also booked, my lord, but that is, my lord, only one
Very
copy,
well. You
my lord.
please get it. Yes, learned counsel opinion for the railways seeks to rely on decisions. Stop, list this matter. When will you come back?
My lord, tomorrow, my lord.
Tomorrow, my lord, is a little inconvenient. Day after then, my lord.
List this matter on 19th April 2023 as prayed for. Next.
Item number 2, Mrs. Hooghly Building and Investment Company.
It's my petition, my lord.
Yes.
My lord, the petitioner here has challenged, my lord, the
In this matter, I am appearing on behalf of the Board of Awqaf.
Yes.
Initial stage, I, my lord, raised the maintenance of the writ petition.
You have raised already.
My lord, on was, my lord, on 23rd February, perhaps you
No,
before
just
Lord's.
tell me what is the point of maintainability?
Just, my lord, before my learned friends, just to recap
This is
the
not
facts
maintainable.
for 1 minute, my lord. We have challenged, my lord, a notice, a show cause notice issued by the Waqf Board under section 54 of the Waqf Act, my lord, saying, my lord, trying to, my lord, evict me out of my possession of a Waqf property. My lord, my contention in the writ petition is that in view of the pendency of proceedings before the Tika Controller Act under the Tika Controller Acquisition Act 2001 and, my lord, a pendency of a civil suit, my lord, the Waqf this particular board under section 54 does not have the jurisdiction to issue this show cause notice because of a bar in the Tika Controllers Act. That was my short sum and substance of my submission. Now, my lord, your lordship will
Yes.
hear.
What is the maintainability?
My lord,
Microphone, please.
my lord, on Nawab Jibun Nesha Begum, my lord, created a Waqf.
No, no. What is the maintainability point? Are you answering on merits?
Yes,
No, you're saying that the writ petition is not maintainable.
yes. When the matter relating to the Waqf property, then it has initially, my lord, the jurisdiction is the Waqf tribunal, not the any other court except, my lord, the Waqf tribunal.
So you're saying
According to the provision of the Waqf Act 1995, section 83, clearly stated, if any dispute arises in any Waqf or Waqf property, then it has to be, my lord, filed before the Waqf tribunal. And on the several matter, lordships came before this honorable court and the honorable apex court also. So I have brought the judgment also. If your lordships kindly take section 83 of the Waqf Act.
yes.
Married lordship, constitution of tribunal. The state government shall, by notification.
No, no.
in the-
Which one? Which one is relevant? Don't read the whole section, please.
No.
I thought it's.
Tribunal
I thought it's
it may
85.
think fit.
I thought it's 85. Why are you saying 83?
No, 83, the constitution of the tribunal.
Yes.
The constitution of the tribunal.
I thought 85 has a bar.
85 also bar. The bar of the civil court. Any court other than the Waqf tribunal.
Very well. So 83, where is the bar?
My lord, may I read lordship? The state government shall, by notification in the official gazette, constitute many tribunals as it may think fit, for the determination of any dispute, question, or other matter relating to a work or work property, eviction of a tenant, or determination of right and obligation of the lessor and the lessee of such property under this act, and define the local limits and jurisdiction of the tribunals. So the property, if the property is the connected with the work state, then lordships, the dispute will be settled by the work tribunal. Another lordship, section.
Why do you say that the relief claimed here can be settled by the tribunal?
Yes.
By the tribunal?
Yes, yes.
Don't say yes, yes. Why do you say that?
Well, if your lordships kindly, well, section 6 also.
6
of the Tribunal Act.
What Waqf Tribunal Act?
Tribunal Act. No, lordship, Waqf Act 1995. Section 6. Dispute regarding Waqf. If any, have you lordship got?
Yes, yes, yes.
If any question arises, whether a particular property specified as Waqf property in the list of Waqf is Waqf property or not, or whether a Waqf property specified in such list is a Shia or Sunni lordship, and any person aggrieved may institute a suit in a tribunal for the decision of the question, and the decision of the tribunal in respect of such matters shall be final. And so many matters came before this honorable court as well as the honorable apex court. This this court also, lordship, held that the first you have to go tribunal, then any other court. May I?
What is the relief prayed for here?
He challenged the notice issued by the Waqf board
For eviction.
for eviction.
Yes.
That's why, lordship, my lord, I started that the one Nawab Jibun Nisa Begum created a Waqf estate. This is the property of Waqf. How my learned friend, my lord, submitted before lordship as a Tika tenant. How it will come under the Tika tenant?
Please restrict yourself to the maintainability.
Yes.
Otherwise, let me hear Mr. Ghosh.
The maintainability. Then, lordship, may I place the judgment also?
Could not even understand your point. Yes.
On unreported judgment, Anjuman Yadgar Hussain, lordship, it is clearly stated that the Waqf tribunal is the remedy for any dispute regarding Waqf property.
Yes, give it. This was a case of unauthorized construction.
Maybe, lordship, that is my.
I'm asking you. Don't say maybe. I'm asking you. You're placing a decision. Place it
Lordship.
properly, please. Where does it say? Hurry up, please. Which page?
Lordship, second page, lordship. Last paragraph. So far as the other issue in respect of the irregularity or transfer of right of concern, the petitioner has a remedy by approaching Waqf tribunal in terms of section 83 of the Waqf Act in 1995. The Honorable Supreme Court in the matter of Board of Waqf West Bengal and another versus Anish Fatima Begum and another reported in 2010-14 SCC 588, considering the scope of the section 85.
Not section 85, 83.
83.
Very well. Anything else? Yes.
Well, this were reported in CHN CAL 2013-4, page 701. 2013-4 CHN CAL 701. Amiruddin Ahmed versus Board of Awqaf.
Yes.
Hmm.
Which page?
My lord, paragraph 10. Paragraph 10.
Yes.
In our opinion, all matters relating to works should be filed in the first instance.
Paragraph 10.
Lordship.
The last.
Paragraph 10.
Last is 8. Last paragraph is 8.
No, Lordship, if your Lordship, it active. Lordship.
You're taking so
I
much
have
time.
marked. Well, kindly, my lord, excuse me. ওইটা দেন, ওইটা দেখি। আছে মনে হচ্ছে।
There is no paragraph 10 here also. What are you saying? Yes, learned counsel appearing for the respondent Waqf board seeks to take a point of maintainability. Stop.
This is the paragraph 10.
List this matter on when do you want to come back? You're not ready in the matter. When do you want to come back? Wasting so much time. Yes, when?
Lord, may I just make two submissions, my lord?
1 minute, please. List this matter on 20th April 2023. 21st April.
Can
Yes.
come up tomorrow, my lord. I appear for the Mutwali, my lord. Your lordship's last order.
Microphone.
What is your lordship's last order? Now, this is, my lord, a premature writ. What my learned friend argued the other day was that a chief executive officer of the Waqf board cannot, my lord, under section 54, cannot even issue a show cause notice because, as per him, the property is thika. Now, my lord, when did it become thika? How did it become thika? Nobody knows. There's nothing on record. There's not one scrap of paper which says that the property is thika. So it's all an imagination. Now, your lordship may kindly see what you argued on the first day, section 54 of the Waqf Act.
Yes.
Because, my lord, this is, my lord, a central act. And the chief executive officer, my lord, is under a statutory obligation to, my lord, issue show cause notice to encroachers. Now, if your lordship may just see, my lord, 54, I'll read it very fast. Whenever the chief executive officer considers whether on receiving any complaint or on his own motion that there has been an encroachment of any land, building, space, property, etc. of Waqf property, he shall cause to be served upon the encroacher. My lord, what was not read was, and there was a specific query by this court as to who is an encroacher. Now, if your lordship may kindly see 3EE of the Act.
Yes.
Lord, 3EE says, my lord, if your
Yes.
lordship has it, encroacher means any person or institution, public or private, occupying Waqf property in whole or in part without the authority of law, and includes a person whose tenancy, lease or license has expired. Now, my lord, the admitted case, my lord, of the writ petitioner is that my lease expired in 2003. That's an admission. In fact, there is a court order which is given on consent. The court order says that the lease will not be renewed. Page 38, if your lordship see, my lord, it is passed on consent.
Yes.
Now, my lord, once he becomes an encroacher, then,
Yes.
my lord, the only remedy, my lord, under the Act, and, my lord, for what the CEO has to do is to, my lord, give him a show cause notice to quit. Now, if he gives a show cause notice to quit, my learned friend says that the property has become Thika because I have somehow put some amount of rent over there. There is no determination by the Thika controller that the property is Thika. Now, my lord, once a property is Waqf, it remains as a Waqf. And my lord, three authorities are now on facts. Three authorities, if your lordship may kindly see page 117 of the writ petition.
You are appearing for who?
I am for the Mutawalli. I am fighting a suit. He's occupying 4 bighas and not paying any rent.
Very well. Yes, next.
My lord, at page 117, my lord, it's absolutely, it's crystal clear. Three authorities sat down, just 1 minute.
Yes.
Bighas, 4 bighas of land. And how
Yes.
does it, the state doesn't say it's become Thika land. How does he become a Thika tenant?
Yes.
Well, your lordship may kindly see 3 authorities, and that is why when I appeared, my lord, on that day I said that the KMC, my lord, is a necessary party. Now your lordship may kindly see. These 3 authorities are, my lord, the Thika controller, page 115, the Thika controller, the chief executive officer, if your lordship has this correspondence.
Yes.
Then, my lord, also the KMC right at the top of the page. So the KMC, they had a meeting, called the Kolkata Thika controller and the board of Waqf. And my lord, in this meeting, my lord, page 117.
Yes.
I'll read, my lord, after the 4th line, para beginning from the inquiry report. From the inquiry report of the board of Waqf, it appears that premises number so and so are Waqf property, including vast land. Some portion is occupied by the manager so and so for his
Very
personal
well.
gain.
Mr. Rauf, only, Mr. Rahim, only on the.
My lord, they say, though from the submitted documents, the quantum of land situated under 1 Chitpur dot net
Anything else
cannot
on
be
the
assessed, but it is
Anything
crystal
else
clear.
on the maintainability?
On maintainability, I say, my lord, is that, my lord, it is premature. If
Yes.
that, if he wants, the act, my lord, prescribes the mode, my lord, the chief executive officer has to give a notice. And my lord, nothing has started. There has to be a proceeding in a civil court where he can come up and say that, look, this is the act, this is section 21 bar. So the maintainability issue can be decided. But
Yes.
you can't preempt a notice to be issued, which is required to be given under the act.
Yes.
There is no proceeding has been initiated yet in a court of law. If any proceeding is initiated in the Waqf tribunal, then he can come up and say that, look, this land is Thika. Or
Very
if it is initiated in a,
Very well. Mr. Ghosh, tomorrow, and I will pass the order. All right?
Tomorrow, my lord, yes.
Yes. Learned Counsel appearing for the Waqf board and the Mutawalli have raised a point of maintainability on several provisions of the Waqf Act, 1995. Stop, list this matter tomorrow
My lord.
to hear learned counsel appearing for the petitioners. Next.
in fact, I would still say that the KMC is a necessary party. They have all the records, my lord.
Yes, counsel appearing for the Mutawalli renews his submission that the KMC is a necessary party to the writ petition. Stop.
They can they serve the KMC, my lord? If they serve today the standing council, they can appear tomorrow because they have all the records. And they have asked for a writ of certiorari, calling for the record. Let the records come.
My learned friend, my lord, will restrict to the papers. The
I
order,
don't want to.
please,
I don't want
the
to.
order that he is referring to has been set aside. I have the order of the High Court itself, which has set aside that order of municipal commissioner. Municipality has nothing to do with this. I will satisfy my lord on the basis of my petition.
Very well.
Kindly hears me. My lord, instead of tomorrow, can it be day after tomorrow? I may not be there.
19th. Next.
19th.
Greatly obliged.
Item number 3, Green Ply Industries, my application.
19 তারিখ
এটা নিয়ে যা my application. Look, this was the matter where Lordship needn't be troubled with the papers now. This was the matter where we came up saying that the MSME, I'm the buyer, supplier, the MSME council is proceeding in a manner that is foreign to the Arbitration Act. When I said this, my learned friend, to actually help my case, furnished a copy of some proceedings that were held on the 10th of January.
Yes.
But could I just hand it over, my lord? My learned friend, he's been kind enough to share with
Yes.
us also. Please don't be troubled by it now. I'll just indicate. My lord, this order, 4 dates kindly make a note of, my lord. Before I take your lordship to the papers and this order, just 4 days kindly make a note of. 27th of July was a year of 2022, I'm sorry. A hearing was granted by the Facilitation Council.
Yes.
25th of August 2022,
we file a section 16 application.
Yes.
First date is 27th of July 2022. A hearing is given by the in the arbitration proceeding.
Yes.
25th of August 2022, a section 16 application is filed. 20th of July 2022 is a letter which is disclosed in this writ petition.
After 25th August, why have you gone back to July?
I'm sorry, my lord, before that is the 20th of July,
Yes.
which refers to letter of the respond number 4 for recalling of some order
Respond
of
number
which
4
we
is
don't know. Respond number 4 is the private respondent.
Yes.
The claimant there. Next date is 30th of December 2022, where we are scheduled given a hearing to be held on 10th of January 2023.
Yes.
On 10th of January 2023, virtually my junior here in court had logged in. Orally, he was told that a section 16 application is not going to be maintainable. He had to make a submission on merits. In 5 minutes, he was logged out. The Facilitation Council closed the thing on him. And thereafter, this recording of proceeding of 10th of January is before us, which has, your lordship has been handed that over.
Yes.
Is what is there. Now,
10 January to contact?
10th of January is what has just been handed over.
Yes.
And this was given to us on the last day by my learned friend who's appearing for the claimant in the proceeding. This has never been served. None of the minutes or dates of hearing or orders passed have ever been served upon me.
Yes.
I'm the respondent there. My fate of section 16 application is decided from what it appears from the proceedings of 10th of January. Is decided on the day I'm told, and I'm told that you have to argue on merits. I don't get an opportunity to file my statement of defense. The purported ground is that I have been delaying it. Now, in this backdrop, kindly have a look at it. This order, decision of the council, because right now no award has been passed.
Yes.
This 10 January only says that we are contemplating passing of an award because we are of horrible conduct and we've always delayed it. Where is the delay? What is the conduct that I have? My conduct is that I have not appeared in the facilitation. Because, I'm sorry, in the conciliation. Because I have not appeared in the conciliation, my conduct is dastardly. And now they say that we will pass an award. My only prayer before your lordship is that we be allowed to file a statement of defense. Till then, this be stayed. And my statement of defense be considered and the proceedings be conducted in accordance with the Arbitration and Conciliation Act, which is the dicta of the Supreme Court in the Urja Nigam case. And most importantly, whatever minutes are being drawn up by the council, they being served upon us. Even if it's served on my lawyer, it will do. This is all that I pray for before this court.
No, but doesn't 18.3 say that if the conciliation fails, then arbitration will start?
Automatic.
Then what is the problem?
Once the arbitration proceeds, then the arbitration will have to happen in terms of the Arbitration and Conciliation Act of 1996. So once I have a 16, I'm entitled to know what happens to my 16.
So you're on equal treatment?
I'm on equal treatment.
18.
18 under the Arbitration Act. And I'm also on the ground that these proceedings are not being conducted in accordance with the Arbitration and Conciliation Act of 1996. And that is recorded in this order of 10 January. The council returns a finding that the proceedings under the MSME Act is quite distinct and different from the proceedings under the Arbitration Act. Well, this is firstly absolutely contrary to the mechanism that the Act contemplates.
But I thought Silpi Industries made it very clear that the MSME Act will prevail over the Arbitration Act.
100%. MSME Act will, Shilpi's MSME Act, the statutory arbitration will prevail over a private arbitration clause. And Shilpi also gives us the right to go and file a counterclaim there. Before that, there was a divergence of opinion. There was difference passed by our High Court. There was different orders passed by the Bombay High Court. Shilpi now crystallizes all of that. So private arbitration, now statutory arbitration will prevail and a counterclaim is maintainable. That is Shilpi. This is Urja Nigam that I wanted to cite, my lord. If your lordship kindly allows me to just rely on this, this 2021 SCC online, SC 1257. Because once the Arbitration Act is incorporated by reference, then it is the provisions of that act which will have to be given effect to. Correct. The 9 onwards, if I may just place.
Yes.
May I move? Only on the ground that even after receipt of summons, the appellant has not appeared, the council has passed an order / award on 6th August 2012. As per section 18(3) of the MSMED Act, if conciliation is not successful, the said proceedings stand terminated, and thereafter council is empowered to take up such dispute for arbitration on its own or to refer it to any other institution. The said section itself makes it clear that when the arbitration is initiated, all the provisions of the Arbitration and Conciliation Act 1996 will apply as if the arbitration was in pursuance of an arbitration agreement referred to under subsection 1 of section 7. Then 18 is set out, disregards that. 11 onwards, Lordship will bear with me for 4 paragraphs. From a reading of section 18 to paragraph 11.
No,
From a
just tell me
reading
what
of
the
section.
point is, Mr. Banerjee. I will read the paragraphs. What
Well,
is
the point is that this proceeding has to be in accordance with the Arbitration and Conciliation Act. If it is not, then any order or an award passed is a nullity. That one line, Your Lordship will find.
In which paragraph?
15.
Which line?
First line. The order dated 6/8/2012 is a nullity and runs contrary not only to the provisions of the MSMED Act, but contrary to the various mandatory provisions of Arbitration and Conciliation Act
Wait,
1996.
this is a conclusion. Where is the reason?
That is 11 onwards. 11 onwards, that the act, the proceeding will have to be in terms of the Arbitration and Conciliation Act. If that be so, may I place it, for your Lordship?
No, I've read it. So there was no recording by the arbitration, by the arbitrator.
There, because in this, the Urja Nigam case,
Yes.
because after summons they had not filed anything, an award was passed.
Yes.
There the court held that this is not the procedure that's contemplated. In my case, I file a 16. The 16 is decided on the day when I'm called for final hearing. And then 10 January, this has come that they want to pass an award. So my case before your Lordship is that once the Arbitration Act is applicable, then 16, firstly, I'm entitled to know, your Lordship is right, it's just my section 18 of the Arbitration Act. I'm entitled to a certain procedure following a principles of natural justice and fair treatment and equal procedure. It can't be that the claimant gets everything.
You were not heard in your section 16.
No, that
No.
your Lordship will find from this order of 10 January.
Yes.
On 10 January, he records that on that day itself, he finds it is not tenable. And I'm immediately asked to reply on merits. My statement of defense, I'm not even given an opportunity after deciding my 16. But if I have failed to file my statement of defense, then section 25 will apply of the Arbitration Act. Therefore, there also I'm entitled to show cause why it should not be terminated under 25(3). It can't be at the whims of a particular council who records in the
25(3) or 28(3).
25(3).
25(3).
25(3), where sufficient cause is shown, why it should not be terminated. This finding, your Lordship will find on 10 January, what my learned friend was, he's handed up. It holds that this is a different process and Arbitration Act is a different process. And because I've delayed it, all my rights are going to go. So that can't be the proceeding content.
Yes.
So my only only prayer is that this be stayed, 10 January be stayed. I be allowed to file a statement of defense and the proceedings be conducted in terms of.
How is 10 January bothering you?
Well, it's come to a conclusive finding that my right is forfeited. And he's decided he will pass the award. Last page, your Lordship will find.
So this is an award or a minutes?
It's a minutes which says that my right to file statement of defense is gone. My 16 is gone on the same day. I am liable. So everything is by, and then the last 4 lines, my lord, at the last page. Submit an application after more than 5 months from the date of initiation of the arbitration proceeding without submitting the defense. This continual delaying attitude of the bar unit indicates their ignorance towards the legislation as laid down in the Act. This is again MSMED Act.
So how come this document is not part of your writ petition?
No, we didn't even get it. My learned friend handed it over. Let the council show this was served on us. We appeared, the junior here, he appeared. They disconnected the call. And the entire attitude, even from the order, your lordship will find as if they are sitting under the MSME Act. And this continual delay, this line that your lordship will find here, this continual delaying attitude of the bar unit indicates their ignorance towards the legislation as laid down in the Act. This is again MSMED Act. There is a proceeding that's happening under the Arbitration Act. There is a certain checks, certain balances that's given to even a defaulting party. I have a right to show cause as to why
So now you're saying that 18.3 now holds the field. Whatever happened before now has gone.
Now
That
it's
is what
gone.
you're saying.
Yes, 18.3 holds the field. This has to go. If your lordship is otherwise convinced, this has to go because this is a nullity as held by the Supreme Court's order. And the rest of the proceeding may be allowed to participate. Let them not have a walkover. That's all I'm saying.
Very well. You are appearing for the supplier. Microphone, please. Yes, tomorrow or day after?
Very well. Tomorrow will be.
Yes. Order to
Look, may I also indicate one thing before?
Order gulo debe sob shomoy. Yes.
Could I just indicate, would it be your lordship pleasure to look at one document from the writ
No.
petition?
Tomorrow or day after.
Very well.
You're Mr. Sharma.
Hello.
Yes. Learned counsel appearing for the petitioner / buyer has made his submissions. Stop. Counsel is aggrieved by a communication consisting of a proceedings of an online arbitration held on 10/1/2023. Stop. Counsel submits that the Facilitation Council, capitals,
Petitioner submit.
the petitioner's প্রথমটা ACL হবে তারপরটা CIL হবে. Council submits that the Facilitation Council is not complying with the mandate of Section 18 within brackets 3 of the MSME Act, which envisages initiation of an arbitration proceeding under the 1996 Act. Stop. Council claims violation of the equal opportunity of being heard under Section 18 of the 1996 Act. Stop. Next, list this matter when tomorrow? List this matter tomorrow to hear the council, CIL council, and the private respondent.
Well, look, I'll be constrained to ask for a stay of this. Well, any day they'll pass this award in terms of this 10 January because that is what
Tomorrow,
is there.
not without hearing your learned friend. Yes, call on the next matter, please.
Number 4.
Great.
I appear for the respondent number 1, Malam.
My senior
Microphone, please.
Item 4, my senior Parthasarathy Bhattacharya, he is still in code number 19, my lord. Kindly give me some accommodation.
But I would raise the point of maintainability, my lord, at the first instance, Malam.
Yes, Mr. Banerjee, what is the maintainability point?
Yes, my lord, this is an.
What is the prayer in the writ petition?
My lord, their prayer, my lord, I am for the respondent number 1, is that, my lord, then order has been passed by the NCLT against which they have come before, my lord. My lord, this order, my lord, has to be appealed against under Section 61 of the IBC code. They have a remedy before the, my lord.
NCLT.
NCLT, first of all. Secondly, my lord, this matter, my lord, is pending before the, my lord, Supreme Court. My lord, the order that they have come up against kindly takes the paper book, my lord, page. They've enclosed the order. It's not marked, my lord, the last annexure, my lord.
What is the that's the impugned order?
my lord, this is the my lord, jumbo paper, my lord, wherein, my lord, when the
No,
notification.
no, which page?
Well, this is not this last annexure. It's not
My lord,
paginated.
after
Last
291,
annexure.
after page 291, volume 2, my lord.
Yes.
Since, my lord, the, my lord, pecuniary jurisdiction was raised from 1 lakh to, my lord, 1 crore. So, my lord, they had to, my lord, file it, my lord. Their claim is admittedly, my lord, of 55 lakhs. So, my lord, kindly sees the order, the third, my lord, the third paragraph.
This is the order challenged?
Yes.
Yes.
Therefore, in terms of the order dated such and such in company appeal number such and such passed by the Honorable NCLAT, the petition is not maintainable and is dismissed as infructuous. Liberty is granted to the operational creditor to file appropriate application for revival of the company petition. In the case civil appeal number such and such, jumbo paper mills, before the Honorable Supreme Court against the order dated such and such passed by the Honorable NCLAT succeeds. Now, this matter is pending before the Supreme Court as to whether, my lord, claims below 1 crore can be entertained or not. At the present moment, all applications below 1 crore are, my lord, dismissed. So, my lord, accordingly, this has been done.
So what is the what was the matter before the
My lord,
HCLT?
They had a section 9 application, my lord, for certain claims as an operational creditor, I believe, my lord.
Yes.
They filed an application. His claim was 55 lakhs, my lord. My lord, the law is that, my lord, below 1 crore, it will not be entertained by the NCLT. So they've dismissed it on that. There was one matter which had been challenged, my lord, in NCLAT. The NCLAT also ruled the same, and now they've gone to Supreme Court. That's the matter, my lord, jumbo paper.
No, because the second paragraph says claim to be in default of rupees. What does this mean?
24 lakhs, my lord. This is his claim. 24 lakhs along with interest. 27 lakhs. So it's around 51 lakhs which is there.
Yes.
Which is below the threshold limit of rupees 1 crore specified in section 4 as amended on 24th of March 2020. But there was a notification. I have a copy of that which came from the central government, my lord, whereby, my lord, the pecuniary jurisdiction was raised. So, my lord, after that, there is no question of, my lord, this being entertained by the NCLT, my lord. So, all matters across India has been dismissed. And, my lord, even if they are aggrieved, they have to go before the NCLAT, my lord, with an appeal under section 61. This court doesn't have jurisdiction under the writ jurisdiction, my lord.
Very well. You ask your senior to be present tomorrow. Understood?
my lord.
Yes, learned counsel appearing for the respondent number 1/NCLT has raised a preliminary objection as to maintainability. Stop according to counsel, comma. The petitioner has recourse under section 61 of the IBC to go before the National Company Law Appellate Tribunal. Stop. Council also places notification of the Ministry of Corporate Affairs of 24th March 2020 with regard to the base limit of rupees 1 crore as the minimum default for in terms of the proviso to section 4 of the IBC. Stop. Yes, you better place the proviso tomorrow. I don't remember what the proviso was.
Lord, maybe, my lord, day after, my lord. Tomorrow I have some difficulty tomorrow, my lord.
19th.
Grateful.
Much.
প্রোভাইসোটা দেখিয়ে দেবো, মনে রাখিস। সেকশন 4 চেঞ্জ হয়েছে।